Hello, everyone, and welcome. My name is Ronald Brand. I'm a professor at the University of Pittsburgh School of Law and director of Pitt's Center for International Legal Education, CILE. I welcome you to this webinar conference on sovereignty, humanity, and law, which is co-sponsored by CILE and the Law and Humanities Institute. We are pleased to bring you what we believe will be an interesting, challenging, and rewarding group of presentations in the form of 3 panels and a keynote address. We will begin today with our first panel, followed by the keynote address by Ambassador Stuart Eisenstadt. For each of the panels and for the keynote, we invite you to use the Q&A function at the bottom of the screen to present your questions in written form. Those questions will then be given to the speakers by the moderators in each of the panels and after the keynote address. This conference will continue tomorrow, of course, at 2 p.m. Pittsburgh time. We believe the panels tomorrow will add a valuable interdisciplinary approach to the discussion of sovereignty and look forward to having you with us then as well. I greet you both on behalf of the Dean of the University of Pittsburgh School of Law, Amy Wildermuth, and in my own capacity as director of CILE. Dean Wildermuth is unable to be with us today as a result of having taken on extra teaching obligations during the spring term. She will join us tomorrow to welcome you in person on Zoom, that is. This academic year marks the 25th anniversary of CILE, the Center for International Legal Education. In a year of remote events, we have held a major event each month to celebrate CILE's 25th anniversary. This conference is the April event. I want to take just a moment to invite you as well to the final event of this special year, which will occur on May 18 through 20, when CILE with Pitt's Asian Studies Center will co-host a conference on deals and disputes, China, Hong Kong, and commercial law. We have a stellar set of panels and keynote addresses scheduled. You may find more information on that program as well as a registration link at law.pitt.edu/CILE, where you can click on Celebrate with us. CILE has a history of collaborative and cooperative events and programs with law schools and other institutions around the world. Today's program is an example of that cooperative model. Our co-sponsor for this event is the Law and Humanities Institute. So as I conclude my welcome, I want to turn the microphone over to Professor Richard Weisberg, who will speak on behalf of the Institute. Again, welcome to the program.
Thank you so much, Professor Brand. It is a tremendous honor, privilege, also joy to be working with so many wonderful people and in organizing this conference, especially with the CILE, an outstanding organization at the University of Pittsburgh, which I've come to know myself personally over the last couple of years, sponsoring stupendous events. And for the Law and Humanities Institute, which I'm representing in welcoming everybody here, for that organization called LHI, also a great pleasure to be joining with CILE, particularly in its celebratory 25th anniversary year. If only we were all together in person, we would be lifting many a glass in salute to our co-sponsors, CILE, and maybe 1 or 2 to the Law and Humanities Institute, which is an organization that is senior to CILE. We're in our 42nd year of existence as a not-for-profit independent organization. Our work, our charter, our mission involves bringing together the law with various areas of the humanities, as the title indicates, perhaps especially literature and literary expression. And for the years that we have been in existence, we have helped to found and still work actively on a journal that is, I think, just into its fourth decade of continuous publication. That journal is called Law and Literature. It is published now by Taylor and Francis. And we welcome contributions to that peer-reviewed journal from everybody in the room right now. We publish work, and the Law and Humanities Institute sponsors work done by a wide range of individuals: poets, playwrights, literary artists, judges, law professors in the fields of the humanities, in the fields of legal theory and law generally. We also submit amicus briefs in the areas of our concern. We keep our eye on the censorship of especially literary expression or filmic expression, and such censorship continues to exist as a threat in the United States. And although our work is by no means limited to the United States, we will be among the first voices to express our concern when governmental censorship is attempting to suppress works of literary expression. And we have also filed amicus briefs in the area of capital punishment when asked to do so, to provide a kind of literary slant on and against that particular form of punishment. We co-sponsor events such as this one. In recent years, we have co-sponsored or presented symposia, typically like this one, 2 days long, on such themes as the blood libel, the Rosenberg spy trials, how we value lives, Shylock versus Antonio on appeal, which was a mock trial that was held at the Cardozo Law School, and the abolition of war. You can tell from that last title that our aims and our practice are not exactly narrow. We're ambitious in our aims, and we hope that you'll join with our work. Personally, I'm not going to introduce myself because I'm about to, in my professional capacity, beyond being the president of LHI, because I'm about to hand the microphone over to my colleague here at the University of Pittsburgh, Professor Elena Bayless. And since I'm on the first panel, you'll hear a little bit more about me. So welcome and enjoy.
Thank you, Richard, and welcome everyone to our first panel on the current litigation of sovereign responsibility. I want to begin by adding my congratulations to CILE on its 25th anniversary, and especially, of course, to Professor Ron Brand for the many years in which he has shepherded this institution to all of its accomplishments. It's a real pleasure and honor to be taking part in this event. Before I introduce our panelists, I want to mention a couple of logistical matters for our audience. Each of the panelists will be speaking for about 15 minutes, followed by comments by our commentator for about 10 minutes. You, as the audience, are welcome to ask questions. We, as Ron mentioned, we ask that you use the Q&A button at the bottom of your screen to do so. Please type your full question in to the Q&A function, and I will read it out, crediting you for it when we get to the Q&A portion of the panel presentation. So you should feel free to type in your questions at any time, and I will go through them in order. I'm going to introduce all of our panelists now so that once we get started, we can just move ahead through the program. Please know that I've been asked to be very brief, so these introductions do not remotely do justice to the many accomplishments of our panelists. If I were to credit them for all of the wonderful things they've done, we would be here with my introductions for the whole time of the panel. Our first panelist is Professor Vivian Curran, who will be speaking about her paper, which is a critique of the genocide exception to sovereign immunity. She's a distinguished professor of law here at the University of Pittsburgh School of Law and has served in many leadership roles in international and national comparative law societies. She's been decorated by the governments of Austria and France, and she's published a recent article on the Foreign Sovereign Immunities Act already. So we're looking forward very much to hearing her comments on that. She will be followed by Professor Richard Weisberg, who you have already met. Professor Weisberg is the Walter Florsheimer Professor of Constitutional Law at the Cardozo School of Law, and he's also a visiting professor of law here at the University of Pittsburgh. He has been the recipient of various awards, including a Guggenheim and a Rockefeller Foundation Award. He's received the Legion of Honor from France. And he's done extensive litigation in US federal courts concerning Holocaust-related claims. Our third panelist is Janis Klump, who I'm particularly happy to welcome back because I had the pleasure of having him as a student in my legislation and regulation class a couple of years ago when he was getting his LLM here at the University of Pittsburgh. He's also earned a Bachelor of Law and an additional master's degree from the Université Paris, and he's currently studying for the German bar exam. And then finally, we'll be hearing from our commenter, Todd Grabarski, who is a Deputy Attorney General at the California Department of Justice. He's clerked in both the District Court and the Ninth Circuit in California and is an adjunct professor at the University of Southern California Gould School of Law. With that, I will turn it over to our first panelist, Professor Vivian Curran.
Thank you so much, Elena, and it's a great pleasure for me to be able to speak to all of you here about the Foreign Sovereign Immunities Act. I gave the title of my presentation before the genocide exception to the Foreign Sovereign Immunities Act had been eradicated by the Supreme Court. And so the topic of my presentation is actually an appraisal of this recent Supreme Court decision, which was the Phillips decision. And in this decision, the US Supreme Court put an end to what really was a novel and mystifying case law evolution in several federal courts of appeal that had been developing over the past several years, including in the very influential DC Court of Appeals. The federal appellate courts in question had adopted an exception to foreign sovereign immunity for property expropriations that occurred in the context of genocide, but which was nowhere to be found in the Foreign Sovereign Immunities Act itself. The problem with this evolution in the law of the FSIA was there was more than one problem with this. And notably among these problems is that the FSIA is a comprehensive text, which is something that Congress stated when it was enacting it. And in addition to that, the Supreme Court has also expressly held on more than one occasion that the statute is to be interpreted based on its texts, and that arguments based on the FSIA must stand or fall based on the text. The statute's property expropriation section makes no mention of genocide. This is enough of a reason to have concluded that genocide is not an exception to immunity under it. In Philip, the Supreme Court further elaborated on this point by reasoning that the plaintiffs were misguided in arguing that Section 1605's phrase, "in violation of international law," includes genocide because, as the Supreme Court said, the international law referenced in the FSIA section at issue in cases of property expropriation is the law of property. So presumably the customary international law of property, but not an expanded law of international customary law that encompasses all of international human rights. By trying to expand the meaning of the FSIA's property expropriation exception to immunity to include genocide, or more accurately, by trying to convince courts to create a new exception for genocide from this section, plaintiffs needlessly ended up confronting the Supreme Court's recent and outspoken reluctance to allow US courts to open their doors to international human rights victims. This was apparent in the Kiobel case. That was the case, if you remember, that ended 30 years of the Alien Tort Statutes, the ATS, allowing victims of the most heinous violation of international human rights from pursuing compensation in the United States. In that case, the court's decision echoed concerns justices had expressed at the oral arguments that the ATS was transforming the United States into the world's sole platform for plaintiffs with complaints from everywhere, however unconnected they might be from this country. The ATS had indeed become a vehicle for universal jurisdiction. Now, universal jurisdiction is a recognized and legal basis of jurisdiction for just the sorts of complaints that plaintiffs had been able to make under the ATS before the court shifted that statute from the terrain of human rights to a commercial terrain by analogizing it to extraterritoriality cases that had been decided in commercial law contexts. And in that way, curtailing the extraterritorial reach of the ATS. Under the Foreign Sovereign Immunity Act's property expropriation exception, plaintiffs have similarly been allowed to pursue the most fundamental of human rights issues to be adjudicated under the FSIA. Whether the unwarranted creation of an explicit genocide exception by lower and appellate courts has led to the closing of the door, how this developed and what remains now is the subject of what I'm going to be talking about for the rest of my time. The courts that created the genocide exception to immunity had started by requiring that the claimed property expropriation had to be a part of the genocide. But as the cases progressed, the courts went further than that. They said that the confiscation of the property was itself genocide. This meant that the taking of a backpack at a train station before deportation was genocide. The courts could not have been clearer that this is really what they were saying. In Simon, the DC Circuit said, quote, "We see the takings as themselves genocide." In Philip, the same court quoted this language from Simon, but at least it placed the takings that they equated with genocide in an overall state policy of genocide. The person who coined the term genocide was Raphael Lemkin, who did so after having lost almost all of his family to the Nazi genocide of Jews. And as some of you may know, today, coincidentally, and it was a coincidence, is Holocaust Remembrance Day. He had been an occasional law professor at Duke Law School and Columbia Law School after his emigration to the United States. But he spent almost all of his time and energy trying to persuade the UN to pass a genocide convention. Michael Ignatieff, whose father was a Canadian diplomat at the UN at the time, told his son that Lemkin was a relentless pest who pestered anyone he came across at the UN until finally he succeeded. In Philippe Sand's book, East Street, West Street, about Lemkin and Lauterpacht, the two giants of 20th century international human rights law, who influenced, among others, the Nuremberg trials, Lemkin comes across in much the same way. In 1948, his work paid off. The UN passed the Convention on the Prevention and Punishment of the Crime of Genocide. Here is what it says. As part of an intent to destroy a national, ethnical, racial, or religious group, genocide is defined as killing members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction and similar acts calculated to annihilate the group. For those who care about the history of genocide, for those who may appreciate how hard it was to get the UN to adopt the Genocide Convention, and still harder to persuade individual states to adopt it. It wasn't, for example, until 1988 that the United States ratified it, among others out of long-held fears that we were violating it in our treatment of our African American population. And for those of us who lament the subsequent trivialization of the term as time passed and as victim narratives have abounded in hopes of profiting from the definition, it is vital to preserve the meaning of what genocide is by binding it to the real atrocities that define it, not just of the past, but that we have seen and continue to see around the world. Its definition requires this. Others have said that the passage of time has not diminished acts of genocide around the world as it originally had fervently been hoped it would, as Lemkin certainly did when he devoted his life to the passage of the convention. When a court says that the taking of any property, however minimal, is genocide, the court, however well-intentioned the judge might be, and I do not doubt for a moment that all of these judges were very well-meaning, such a judge is not performing a service to the victims of the Nazi genocide represented by the plaintiffs before them, or in one California case of the Armenian genocide. Rather, it is a disservice to the memory of those terrible events. And the pity of it all is that it was utterly unnecessary. That is the last reason the US court's adoption of a FSIA genocide exception was unfortunate. It was unnecessary in the very lawsuits that promulgated it. Long-standing FSIA case law would have protected the plaintiffs in all of the cases urging the genocide exception. Had the plaintiffs availed themselves of a different argument connected to a rule called the domestic takings exception, they almost certainly would have won in the Supreme Court in both Philip and its companion case, Simon. The Supreme Court justices ironically seemed better briefed than the parties on this issue at oral argument, from Justice Sotomayor to Justice Thomas, and several of the Supreme Court justices pointed the way for the plaintiffs. In the written decision, the court did not shut the door entirely to potential relief, but these particular plaintiffs may lose the compensation they merit if lower courts on remand conclude that they lost their domestic takings argument by failing to preserve it. Because the plaintiffs argued for a genocide exception, when the case reached the Supreme Court, the court defined the law in a way that in the future purports to exclude general international human rights claims beyond those claims that fall within the FSIA property exception to immunity. This is part of the court's recent rejection of opening the United States to the floodgates of litigation, and especially to being, as it sees it, the sole nation in the world to have universal jurisdiction for civil claims. The established protection concerning domestic takings I mentioned above arises under an exception to an exception. Of course, we are all lawyers. The rule of the domestic takings exception grants immunity to foreign states under Section 1605 if the property expropriation was perpetrated against their own nationals at the time of the act. The general law is that a foreign sovereign which expropriates property in violation of international law is not immune from jurisdiction if the expropriation was committed against aliens at the time of the taking. As the Supreme Court explained, the rule and the exception are consistent with the widely accepted international law policy that a foreign sovereign's taking of the property of an alien is a matter of international concern, but that a taking of its own national's property is the business of no state but itself. And so the United States, like most other nations, will not interfere with what a nation does within its own territory to its own nationals. The Philip case involved valuable art that had belonged to German Jewish owners during the Nazi period until Hitler's Reichsmarschall Goering decided he wanted to own it personally. The plaintiffs alleged in the case that the owners then were forced to sell at a coerced price after Goering's representatives threatened them. Cases far more heart-wrenching than Philipp had been tried under the FSIA relating to the persecution of Jews during the Nazi genocide. Since the FSIA does not allow suits for torts which occurred outside of the United States, plaintiffs have brought suits for property dispossession during that time, as Jews also, as most of you probably know, were robbed of all they possessed before they were deported to concentration camps or killing sites. In FSIA case law, long before the genocide exception was created by courts, another exception, this one to the domestic takings exception, had developed. Established case law held, and it still holds, that where a foreign state does not treat a member of a dispossessed minority group as one of its citizens with full civil and political rights, the foreign sovereign is not entitled to assert the domestic takings exception to immunize itself under the FSIA from the US court's jurisdiction. I call this the substantive citizenship test. US courts in FSIA cases and elsewhere look to the substance rather than the form of citizenship. So regardless of whether the plaintiff at the time nominally was a national of the defendant state and had no other citizenship than that of the defendant state, so long as he or she was not treated as a full-fledged citizen by the defendant state, the US rejects the defendant state's claim that a domestic taking was concerned. This analysis has very specifically been held to apply to the situation of Jews in Nazi Germany as well as in Hungary after the enactment of Hungary's anti-Semitic statutes there in the late 1930s. Philipp involved German Jews while Simon involved Hungarian Jews dispossessed of their last remaining possessions at the train stations as they were being deported to concentration camps. In conclusion, the recent US Supreme Court Philipp decision, which was unanimous, in my view, has corrected the law of the Foreign Sovereign Immunities Act by eliminating a genocide exception that the FSIA does not have and does not warrant under the text and interpretive case law of the statute, and that demeans the meaning of genocide. By not eliminating the substantive citizenship test for domestic takings, and indeed by referring to it with approval, the Supreme Court has also left open the door to future claims of victims of genocide, since property expropriations by foreign states of such victims generally will involve a minority already deprived of full-fledged recognition as a citizen of that taking state. When the court construed Section 1605's phrase of property expropriations that are, quote, in violation of international law, to exclude in and of itself a reference to international customary law beyond property law, that was to be expected from a court which has shown itself hostile to any trace of universal jurisdiction and which has shown itself highly reluctant to open the doors of the courts to claims of foreigners. But I do not think that this will be an impediment to victims of future genocides or of past ones suing under the FSIA, since international customary law signals discriminatory takings as a key aspect of property expropriations. And the US Restatement of Foreign Relations also endorses this reading of international property law. That the genocide exception could not withstand the test of FSIA scrutiny is a positive development for the law of both the FSIA and for international human rights. Thank you very much. And I look forward to your questions in the Q&A period.
Thank you. Next, we have Professor Richard Weisberg. Richard, you are still muted.
I appreciated very much Professor Curran's paper. We have perhaps some differences at the margins, but they are at the margins of the same exception to the immunity that sovereign states have under international law and under the Foreign Sovereign Immunities Act, which at 1605A3, which was cited by Professor Curran, provides what is usually called the takings exception or the expropriation exception to that immunity, and which says a foreign state shall not be immune from the jurisdiction of US courts where rights in property taken in violation of international law are an issue. Two cases arose very recently. The Phillips case, which Professor Curran has discussed authoritatively, having to do with domestic takings, and the one that I want to talk to you about a little bit, which is the Simon case, which she also alluded to. Now, the Simon case was less about domestic takings than about what I consider to be an equally strange development in the Seventh Circuit, especially when it came to this takings exception, in which the court that otherwise had granted jurisdiction, which was a difficult task to plaintiffs suing the Hungarian National Railroad under that exception. And the Hungarian National Railroad, known as MÁV, is the railroad that almost every Holocaust-related documentary, and today is Holocaust Memorial Day, as Vivian mentioned, you'll see people being shoved into horrible cattle cars, and the railroad shuts those doors, and the next stop for these Hungarians, usually the Hungarian Jews who are shown in that guise, is going to be Auschwitz-Birkenau or death camps. 500,000 Jews in 1944 from Hungary suffered that fate. The case that is trying to find a remedy under this exception, the takings exception, included Simon. And there was some hope that Simon would resolve the issue that had resulted in a circuit split. And with the DC Circuit in Simon finding that there is no requirement to go back to the country of origin, in that case also Hungary, to seek a remedy there under a theory of exhaustion / comity, C-O-M-I-T-Y, whereas in the Seventh Circuit, a case that I've been helping to litigate, in the MÁV case, let's just call it that, or Fisher, the Seventh Circuit required plaintiffs to go back to the country of origin to try their hand and exhaust remedies. And the reason they were being set back had something to do with comity, which is a very vague notion, noted in the case law and in the scholarship as really slippery, flexible, indeterminate. But this has become a crucial factor in cases against Holocaust wrongdoers. So yes, the court very recently, as Professor Curran reported, did resolve the issue of domestic takings and swept away the claims of Philip, the art dealer, against Germany, and all such claims, but it punted on the Simon case. It really said nothing. It sent the case down to these various circuits to proceed in a manner consistent with what it said about Philip, which gave very little information about exhaustion and about comity as a requirement, not in the DC Circuit, but in the Seventh Circuit. What I want to focus on today in a paper called From the Frying Pan to the Fire is what I consider to be a set of developments under the FSIA that re-elevate the influence of the executive branch, Article 1, in the resolution of lawsuits brought by Holocaust victims, which have been really started in the mid-1990s and continue to this very day, and I think will be going on for quite a while. What happened in the recent events in the Supreme Court is fairly typical. The court probably took certiorari in Simon and Philip at the behest of the Solicitor General. This is not unusual, which recommended a resolution of the circuit split in favor of requiring exhaustion of remedies. And that's the oddity, or one of four ironies, that I want to talk about when the executive branch of the United States gets involved in FSIA cases under this particular exception. The FSIA came into existence in 1976 to eliminate, to the extent possible, the influence of the executive branch and to vest in Article 3 courts the adjudication of claims against sovereigns. It's somewhat bizarre that executive branch officials like the Solicitor General, and as I'll tell you a little bit about in a few minutes, the State Department, often affirmatively enter these cases and almost as often enter these cases in order to quash them, to put an end to them. These are cases involving US citizens and others under the FSIA who have indeed proven a takings of property. Now there is the problem that Professor Curran mentioned of the language under international law, which will have to be adjudicated in both of the circuits that are still entertaining these claims, the DC Circuit and the Seventh. There is language, a lot of language in the 1976 statute, specifically saying in the congressional lead up to the statute that executive branch influence over the resolution of these cases is being, to the extent possible, negated in favor of judges taking over the job of figuring out the thorny issues of that exception. And by the way, other claims against sovereigns in many cases, sovereigns or their entities. The railroad is considered an entity of the sovereign. And one of the reasons Congress codified, as Professor Curran pointed out, it was a comprehensive codification of this law involving sovereignty, according to the congressional record, is precisely to put some order into what had prior to 1976 been a chaotic process in which the State Department, often on its own, through a device called the tape letter, had intervened one way or another with an Article 3 court to advise them as to what to do in cases involving sovereigns. And the statute was explicitly designed to minimize and, in fact, to eliminate that influence. When you see the Solicitor General advising the Supreme Court as to whether it should take certiorari, that's not unusual. When you see them in both cases advising the court to find against plaintiffs, including US citizens and others. Unfortunately, that also is not unusual. It's ironic that the executive has regained influence in influencing courts in this area. An example is a case in the Seventh Circuit that is currently pending called Scalin, S-C-A-L-I-N, versus the SNCF. The SNCF is also a railroad. It's a government entity. It stole property from Jews en route to the East. 80,000 Jews died under color of French law here. 3,000 others died in French administered camps during the Vichy period, probably sent to those camps on these same railroads. Property was taken en route to the deaths of most of the unfortunates, who, by the way, in the case of the SNCF, had to pay for their own train tickets en route to the death camps. Well, a claim was brought, and at the moment, it's running afoul of the exhaustion and comity requirements that were set up by its circuit, the Seventh Circuit, as I mentioned earlier. So the State Department intervened in Scalin and wrote a letter of intent to the court. It's obviously not binding on the Article 3 court, but they often take the advice, maybe too often, of the executive branch, and the advice given by the Article 1 agency, in this case, the State Department, was let's try almost any other remedy besides going through with the case in your court, even though jurisdiction has otherwise been pleaded and proven under the exception. And I just want to repeat, that is not an easy task. And in the case in the Seventh Circuit, we were the first to be able to plead and prove that exception in suits against railroads. The exception itself and how it works is extremely interesting. What I'm interested in is what happens when there is a successful pleading and proving, and then the executive branch intervenes. We have the Solicitor General, we have the State Department. You have essentially an Article 1 agency attempting to influence an Article 3 court, despite a clear statement of the Article 2 legislative branch that that was no longer to happen. And what the court has done in Scalin is to send the plaintiffs back to France, where an agency, too many initials here, but it's called the CIVS, the Commission for the Indemnification of Victims of the Shoah. I work very closely with that commission. It's a very fine commission, but it has never taken jurisdiction over suits connected to railroads. And it will probably not deal with claims in a way that is commensurate with the way US courts have dealt with similar claims here. It's the country of origin. France is a great country. I love it. I've worked with them on restitution, but it is, in its Vichy years, the country that brought about the very wrongdoing that the Scalin plaintiffs are seeking a resolution to. That's a second irony. From the frying pan to the fire, the frying pan of the FSIA to the fire of the country of origin. In Mauve, our case in the Seventh Circuit, sometimes called Abeles or Fisher, an elderly lady was sent to Budapest, or I should say courageously volunteered. She was one of our clients. She was, as a child, one of those who was pushed into the cars. Her family all perished. They took valuables from the family in the train. She survived, and now she is sent back to Budapest, where a full judicial hearing occurred. And as was completely predictable, her claims failed in front of an Orban court, and her efforts were futile. And now perhaps the case, after many people have died, including her, may be able to proceed in the original American court of jurisdiction. The executive did not formally intervene in Fisher, but every indication was that it would prefer, for various reasons, not to have exclusive control vested in Article 3, despite the language of that particular statute, and rather to, perhaps for reasons of comity, perhaps out of protecting US executives or US agencies that might be sued in a foreign court for, let's say, slavery reparation claims, to protect them against action of this kind in a foreign court by setting up a principle of comity. The fourth irony is that, and this relates to our superb keynote speaker today, Stuart Eisenstadt, what originated as a very healthy synergy between lawsuits brought by plaintiffs in FSIA cases or in cases against private entities such as banks, the successful or potentially successful action by the plaintiffs provided a catalyst for US executive branch officials such as Stuart Eisenstadt to bring the parties together in a form of negotiation and resolve the situation in a way that the countries involved or the entities involved had to sign off on, but was favorable also to the plaintiffs who had to sign off on this. It's ironic that now we have, before the fact, really, in some cases, of a full resolution or even a partial resolution of a case that might be favorable to plaintiffs, we have intervention of the executive branch, such as the Solicitor General in Simon and in Philip, designed actually to put an end to the case. Solicitor General did not prevail as to Simon. Solicitor General did virtually fully prevail for reasons that, and I concur in many of them, Professor Curran agrees with, in the domestic takings area as it had been defined by certain courts, though we would probably have minor squabbles, just as I have some minor squabbles with Ambassador Eisenstadt that might come out. So in conclusion, the FSIA is a self-contained statute. I think all analysts agree with this. There is no such language as comity in the statute or exhaustion of remedies. That was imported. That is an irony because the statute was specifically involved not to entertain or respect the views of sovereigns, either in the United States or elsewhere, but to allow Article 3 courts to adjudicate those claims fully. And the statute, if interpreted on its terms, probably would go along with the Simon view that exhaustion of remedies should not be a requirement under the FSIA. How costly it is in human life and human emotion to extend these lawsuits by forcing the plaintiffs to go back to the original origin country, whether or not that country has questionable independent judges, which I think you could say about Orban with a history of anti-Semitism there, or whether it is an upstanding country like France. And in closing, about Scalen, it was the Bodner case, which was successfully brought to a conclusion by Ambassador Eisenstadt, a case against 23 French banks, Chase Manhattan, JP Morgan, and Barclays Bank, added as defendants because they did business on French soil during Vichy. It was in that case that the organization, the CIVS that I referenced, was in fact actually empowered to handle individual claims with no jurisdiction over SNCF claims. And now, years later, we have, because of the urging of the State Department, we have that agency, which was brought into, not into creation, but into its active role in restitution. I've been privileged to play a role as the plaintiff's oversight person on banking claims and material claims, now brought back into the circle of resolution in an area that it was never designed to cover. And we have a judge in the district court in Chicago handling the matter very different than Sterling Johnson handled it, meaning the Bodner case, in the Eastern District of New York, which was admittedly a case against private banks, but which nonetheless brought up the same kinds of defenses. It's even more ironic because now you have a statute which on its terms makes such intervention inadvisable. So I call this the perverse increased intervention of the executive branch in FSIA exception cases, largely because the trend over time, with Ambassador Eisenstadt being a key exception, the trend over time has been not to springboard from cases that are allowed to go forward, at least to a certain extent, successfully for the plaintiff, but to intervene against US citizen plaintiffs and others who are the plaintiffs in these cases, and to recommend nipping the cases in the bud, or at least delaying them greatly by giving the countries of origin at least a shot at resolving the cases for plaintiffs, as unlikely as that may seem. Thank you very much.
Thank you. Our next speaker is Jens Klump.
So good afternoon, ladies and gentlemen. Welcome to my presentation on exhaustion of remedies in light of SNCF Holocaust wrongdoing within the FSIA expropriation exception. First, I wanted to thank Professors Curran, Brand, and Weisberg for inviting me to speak at this conference, which I'm very pleased about. And especially thanks to Professor Weisberg, who inspired me for this topic with his Legal Institutions and the Holocaust class last year at Pitt Law, and who kindly supervised my master thesis for Paris 1 University Panthéon-Sorbonne. The exhaustion of remedies topic is interesting because, as Professor Weisberg already mentioned, there's a circuit split at the moment between the 7th Circuit on the one hand, requiring exhaustion of remedies, and the 9th and the DC Circuit on the other hand, who reject such a requirement. And the United States Supreme Court granted certiorari on the question and might soon resolve the controversy between the circuits. And moreover, there's a personal reach for plaintiffs concerning exhaustion of remedies, because as Professor Weisberg already mentioned too, victims of Holocaust wrongdoing and their heirs are forced to plead in Germany, in France, or in Hungary in a different legal system with the help of foreign law firms and in a different language, which is difficult. Concerning SNCF Holocaust wrongdoing, the Northern District of Illinois required plaintiffs to exhaust remedies in France in the Scalin v. SNCF case recently. And my presentation is going to focus on the effect of such an exhaustion requirement related to SNCF Holocaust wrongdoing, and will argue why such a requirement should be avoided and why the United States Supreme Court should not introduce such a requirement in the FSIA expropriation exception. So what are the conditions of the expropriation exception, and why do we need it? I know Professor Karen Weisberg already mentioned some of them, but I just want to repeat them once more. So the general principle of the Foreign Sovereignties Immunities Act is that foreign sovereigns and their entities have immunity in United States courts, which means that a United States court cannot adjudicate over a foreign sovereign, By contrast, this is different if an exception to immunity is satisfied. And in cases related to Holocaust wrongdoing, the expropriation exception is of central importance, which has 4 conditions. There must be a taking. The taking must be perpetrated by a public entity, which in the case of the SNCF, the French National Railroad, was disputed because the SNCF's status at the time of the wrongdoing between 1940 and 1944 was unclear. Third, the expropriation must be in violation of international law, which is generally the case if it's without prompt and adequate compensation. And finally, the foreign sovereign or the entity must engage in a commercial activity and own or operate the benefits of the expropriation in the United States. In a case against the Hungarian National Railroad, the MAV, the Circuit held that an agency for ticket sales can be enough to establish such a commercial nexus. In the case of the SNCF, the commercial nexus might consist of rail projects that an SNCF subsidiary operates in the United States. As Professor Weisberg already mentioned, these conditions of the expropriation exception are very narrow and difficult to establish, especially the 3rd and 4th condition. And as Professor Weisberg already mentioned too, there is no requirement to exhaust remedies in the wording of the FSIA expropriation exception. So the next question is, what would be the effect of the unwritten exhaustion requirement within the FSIA expropriation exception, especially in light of SNCF Holocaust wrongdoing? So there would be a risk of displacement of the FSIA expropriation exception because claims against the SNCF would be entirely dealt with by French courts or French executive remedies. And why is that? It's because exhaustion leads to the production of foreign judgments and foreign executive acts, which are generally recognized in the United States unless they are rendered by fraud or violate American public policy notions. And especially for judgments, they have a so-called res judicata effect, precluding any further action in the United States. So if a French court decides in a case on SNCF Holocaust wrongdoing, a United States court cannot decide afterwards on the same case. And moreover, there's a high bar to overcome the exhaustion requirement. Plaintiffs have to establish that foreign remedies are clearly a sham or inadequate, which is difficult to prove. In France, related to SNCF Holocaust wrongdoing, an exhaustion requirement would have the result that plaintiffs received no judicial compensation, no compensation from French courts. For example, the Paris Appeal Court held in 2004 in a case called Schächter that the plaintiff's civil compensation claim was time barred as of 1974. The court set the starting point for the 30-year statute of limitations in 1944. The court argued that there were publications on the SNCF's role in the Holocaust and in deportations immediately after World War II. And thus, the statute of limitations started in 1944 and went until 1974. However, the plaintiff argued that he was unable to gather sufficient information to file a claim in court until a scientific report was published on the role of the SNCF in the Holocaust in 1991, partly, and definitely in 1996, which is the so-called Bachelier report. The Toulouse Administrative Court came to the same conclusion in an unrelated case, and also held that plaintiffs were unable to gather sufficient evidence for their claims until the Bachelier report was published. And I personally would say that it was certainly difficult for a plaintiff to research and to have access to public archives, given that the French state only recognized its culpability in the Holocaust in 1995 with the speech of President Jacques Chirac. Thus, the reasoning of the Paris Appeals Court can be doubted, but is legally defensible. So the opinion is likely to be recognized in the United States and precludes a United States court from deciding. Moving on to administrative actions in France, the highest French court, the Conseil d'État, declared itself incompetent to hear claims in 2007. The Conseil d'État argued that the SNCF was a private entity between 1940 and 1944, and that the SNCF was an industrial and commercial service without exercising public powers, giving competence to the administrative judge. Indeed, a decree law of 1937 conferred the SNCF the status of a private stock company. However, there was the French government concluded a ceasefire agreement with the German occupier in 1940, putting the SNCF at the disposal of the French state, and putting the SNCF at the disposal of the French state and the German occupier. Furthermore, the Toulouse Administrative Court argued that the French state held a majority in the shares in the SNCF at the time, and that the decree law of 1937 only covered civil transportation and not the SNCF's deportation function of Jews and other so-called undesirables within France. Concerning the second argument, it can be severely doubted that the deportation of Jews and other so-called undesirables is an industrial and commercial service. This is rather the execution of an administrative policy of the Vichy government. Furthermore, there is evidence that SNCF agents were involved in the planning and scheduling of the trains, and that they helped to manage the deportation of Jews and other undesirables within France. So the SNCF agents exercised some public powers, although German soldiers and sometimes French police mostly guarded the trains and helped or forced the deportees onto the trains. Thus, like the judgment of the Paris Appeals Court, the Conseil d'État's opinion can be doubted, but is legally defensible and would also be recognized in the United States, making a United States court action very unlikely. relating to SNCF Holocaust wrongdoing. Moreover, plaintiffs in France can turn to the CIVS, Professor Weisberg already mentioned, which is the Commission d'indemnisation des victimes des spoliations, which is an executive commission created by the French government in 1999. The CIVS receives petitions relating to Holocaust wrongdoing of the French government, French state and its entities. And it determines and recommends compensation amounts to the French Prime Minister, who finally approves or rejects the compensation recommendation. In Scalin v. SNCF, plaintiffs tried to establish that CIVS is clearly a sham or inadequate as a remedy. They argued that there was a lengthy procedure in front of CIVS, that the commission lacked transparency, and that there were sometimes unfair compensation amounts. Professor Eric Friedman, an academic who represented over 1,000 CIVS petitioners, confirmed these allegations. Similarly, the Paris Administrative Court held in 2007 that CIVS is not a jurisdiction under the European Convention of Human Rights, and thus not bound to the rule of a speedy procedure and not forced to give full access to its research documents, which underlines plaintiffs' claim of opacity and lengthy procedure. And finally, there's no immediate judicial review of CIVS recommendations. Plaintiffs can only attack the Prime Minister's final compensation decision in front of the French administrative judge. In front of the French administrative judge, so no immediate judicial review of the CIVS compensation, only an internal review procedure. Thus, as executive acts, CIVS recommendations and the French Prime Minister's compensation decision are entitled to recognition in the United States due to comity, and would displace an action in front of a United States court and make it impossible for plaintiffs to plead jurisdiction under the FSIA expropriation exception. And in general, one can say that there is the risk that a general exhaustion requirement displaces the FSIA expropriation exception, and that the expropriation exception entirely might lose significance through an exhaustion requirement. And therefore, the United States Supreme Court should not introduce an exhaustion requirement into the FSIA expropriation exception. Thank you very much for your attention.
Thank you. And finally, we're going to have comments on the three papers by Todd Grabarski.
Hello. So thank you, everyone, and thank you for those informative talks. A lot of what has been said dovetails with some of the research that I had done when I was a student, actually under Richard Weisberg at Cardozo about 10 to 12 years ago at this point. And I think it would make sense just to talk about how a bit more, and Richard had touched on this, but just to flesh out how the FSIA actually got put into place. And I think there's one story that I'll tell that I think I've told before, but I think it illuminates the rationale behind the FSIA with its exceptions, particularly the property expropriation exception, and how it came to be. And I think it kind of serves as a subtle critique on the Supreme Court's recent jurisprudence on the expropriation exception, as Vivian, I think was pointing out with the recent Phillips decision. So during, and this story it's a Holocaust related story. comes from in Germany, in the 1930s. There was a German Jewish businessman named Arnold Bernstein who owned a few shipping lines, and he, his nationality was German. He was also Jewish. I think it's unquestionable that he would have been considered a German citizen. He had, was a veteran of World War I fighting for Germany. In the late 1930s, he was imprisoned, probably tortured, and agreed, under duress, to sell his shipping lines to a Dutch shipping company. Eventually, after his friends paid a ransom, in the late 1930s, I think right before World War II actually broke out, so before September of 1939, he fled Germany to Holland and then eventually made his way to the United States. After the war, after the war, he became a United States citizen and started several businesses in New York and Florida. After World War II, he actually sued the Dutch company to whom he had sold his shipping lines to receive compensation. And the lawsuit was brought in United States federal court in Southern District of New York in Manhattan. The material claim of that lawsuit was that a foreign nation, namely Germany, to whom he was a citizen at the time, had wrongfully expropriated his property. And the district court had, this is the 1940s, this is before the FSIA was codified. And so the district court had to determine whether it had jurisdiction over this case, which really involved laying judgment on the actions of a foreign country, a foreign sovereign. Ultimately, the district court decided it did not have jurisdiction, and it cited this, amorphous principle of sovereign immunity, principles of comity, which the prior speakers had talked about extensively and intelligently, and this issue that foreign sovereigns, United States, like all foreign sovereigns, can't really pass judgment and hold accountable in American courts the actions of other countries. So Mr. Bernstein's lawsuit was dismissed for lack of subject matter jurisdiction. As Richard had pointed out, and I think this is what he was alluding to, he had turned, Mr. Bernstein then went to the state, he didn't give up, and he went to the State Department and basically asked the State Department to provide him some relief. And what he got in return was this letter, and I think Richard had called it the Tate letter, and Tate refers to, I think it's either one of the undersecretaries of state who was the actual drafter of the letter, and basically said it was a letter that was sent and directed to the federal courts and said, look, when it comes to matters of the actions of the German Nazi officials and the German Nazi government during World War II, the State Department is giving quasi-authorization to the federal courts to take up those cases and to adjudicate those actions. And that it was the policy of the federal executive basically to, I think the quote is, to relieve American courts from any restraint upon the exercise of their jurisdiction to pass upon the validity of the acts of Nazi officials. So we have a situation where the federal executive is saying, look, there are situations where it would be appropriate for the American courts to exercise jurisdiction over a foreign sovereign. Mr. Bernstein, basically, he restarted his case in the Southern District and eventually went up to the Second Circuit, where he brought this letter in hand, and the court sided with him, said, look, in light of this letter, we do have jurisdiction over this case. The case eventually settled with the Dutch shipping company out of court. But I think the significance of this case is that this marks the first, and I think one of the more significant shifts from this notion of absolute sovereign immunity, where American courts are just completely saying we can't pass judgment on foreign sovereigns, to ones where they do have jurisdiction. And then that ultimately led in the 1970s to the Foreign Sovereign Immunities Act. So I think the recent Phillips decision, and I think our previous speakers are probably much more knowledgeable on the recent developments in the law than I am, but the history behind the FSIA and the preceding events to the FSIA, I think would say that even where property is expropriated from a national of a country, as was the case with Mr. Bernstein's, and I've written about this topic before, and I've cited many examples where a foreign country expropriated property from one of its own nationals, as was the case in Spain, Argentina, Germany, I think France, in some of the litigation that Richard has been involved with, the Altman versus Austria case, which involves the famous Gustav Klimt painting. In each of these situations, I think unquestionably, the victim and the plaintiff was a foreign national. And there should be jurisdiction over that case because the expropriation took place as part of a greater scheme of genocide or large-scale discrimination, which I think clearly would be a violation of international law, even as it was understood in the 1970s. One other point, that the prior speakers made me think of, and this might be getting a little bit off topic, we have when victims of genocide or victims of illegal property expropriation are, we're kind of looking at the aftermath of all that the expropriation took place, the victims have been, victimized, and they're seeking redress or some sort of compensation in the federal courts. But I think, and the federal courts are one avenue to get that, as Richard had pointed out. The federal executive might be another avenue. As Giannis had discussed, seeking remuneration in foreign courts, as sometimes is, might be required in some of this litigation. That is a possible, though highly unlikely, avenue. But I think it's just important to think about of the ethics of, the attorneys kind of who are working on the ground, possibly at the time when the illegal, whether it's expropriation or other acts are going on. And Richard, I just know from working with Richard and studying under him, he's written a lot about this, about even during World War II and the Holocaust, judges and lawyers who are refusing to act unethically at the least, and refusing to go along with, the genocidal or expropriation or discriminatory programs, surprisingly are often not met with large opposition, even under during World War II and under Nazi and related regimes. And I think that's just one thing to think about, that there's a reason why in all the cases that we've been talking about, there's a reason why the property was expropriated, and there was a reason why that was allowed to happen. And it really, I think without, for example, with Mr. Bernstein, the story I described, someone had to draw up the bogus contracts, and someone was involved with the bean counting to figure out exactly what his property and the shipping lines were worth, in order for forcibly the property to be transferred to someone else. And I think it's it's just important to, you know, my overall kind of amorphous comment that might be a little bit off topic, but it's just important to think about exactly how that happened. And you know, not most, but not all of us are attorneys, but it goes beyond the law profession and the legal profession. But I think it's important to keep in mind all professionals' ethical responsibilities in the face of you know, being asked to do something that you know, transcends or, you know, violates those ethics and morals. That's all I have to say. Happy to, you know, answer questions if there are any. And I probably should have said this at the outset. As you know, Professor Bayless had said in the beginning, my title is I work for the California Department of Justice. None of what I've said, you know, before it is in my professional capacity. It's all in my personal capacity, based on the work I've done before that. So nothing that I've said is attributed or attributable to state of California or the California Department of Justice. Apologize for not saying that from the outset.
Wonderful. Thank you, Todd. We're now going to move into the Q&A part of our panel presentation, and I want to invite the audience to enter your questions in using the Q&A button at the bottom of your screen. You can type your full question in, and then I'll read it and give the panel members a chance to respond. So our first question, and I apologize if I mispronounce your name, is from Monika Brzozowska-Pasieka. The question is, the defendants in both Simon and Phillips cases proposed a novel doctrine, the comedy-based abstention. How may the court weigh or assess whether or not this particular case could trigger or cause international friction or tension? What are the factors that might be taken into account in the process of weighing this? And would this doctrine extend to private disputes? That's a lot of sub-questions, so I'm just going to repeat them one more time. Concerning the comedy-based abstention, how might the court weigh or assess whether this particular case could trigger international friction or tension? What factors might it take into account in that weighing process? And would the doctrine extend to private disputes? I guess I'll start I'll go through the panelists and give you a chance to respond in the order that you originally spoke. So I'll turn it over first to Professor Vivian Curran, if you would like to respond.
I was just going to say in a more general sense about comedy that based on what we've already heard from all of us, the FSIA in and of itself is both a comprehensive statute and also, as Professor Weisberg stressed, had as one of its purposes to take the executive out of the picture of FSIA decisions. So on the one hand, comedy just has no role in these decisions. The court is not set up to make political decisions, and the executive should not have a recognized role in influencing the decisions. I would also like to note, in terms of what Yanis Klump was telling us, something that is often overlooked in these cases about comedy, which is the combination of comedy and exhaustion. It is often thought that allowing exhaustion of remedies in the country of origin favors international comedy. So it actually does exactly the opposite. Where you have exhaustion of remedies in the local, in the place where the victimization occurred to begin with, you will almost certainly get a court to deny the claim of the victim. So this happened actually in the case that Professor Weisberg was involved with the Abeles and Fisher case, where this poor elderly woman volunteered to go back to Hungary to adjudicate her case. She goes back and the court says, well, we have to dismiss your claim because you don't have any documentary evidence. Well, there are not a whole lot of people who were sent to concentration camps who have documentary evidence of what happened to them in these cars. So her case was dismissed. Now, when under US law, under United States law, it will be much easier to get a court which agrees to adjudicate the case under the Foreign Sovereign Immunities Act to grant compensation to a victim than it is to get a court to agree that that another country's opinion cannot be, has to be overcome because it was unfair. That's the standard for such a plaintiff to come back to the US court and say, now would you please hear my case anyway, because I didn't get a fair hearing. That is an overall condemnation of the entire country's judiciary. The bar for that is extremely high. Whereas if you think about what is really involved in comedy in the United States in these cases, these are cases, for example, against Germany with respect to the Nazi period, against France with respect to the Vichy period, against even Hungary, which technically completely rejects the period in which it had anti-Semitic statutes. All of these countries repudiate the government which committed these expropriations of property. So to try these cases in the United States under the FSIA, even if you were to argue that comedy should have a place, which I think it doesn't, but even if one should argue that comedy has a place here, is far less problematic from the perspective of comedy than to send these people back to their countries of origin.
Thank you. Professor Weisberg, did you want to respond?
Pleased to, and associate myself completely with Vivian's remarks in response to the question, but I would just add that again, the Solicitor General in Simon and Philip espoused the notion of comedy as though it were a working legal doctrine and very important in the resolution of the cases, whereas scholars and US courts have defined comedy. I'll just quote Anne-Marie Slaughter. Comedy is a concept with almost as many meanings as sovereignty, which is interesting. Maybe our next conference will have to be on comedy, but frankly, I hope it's comedy, C-O-M-E-D-Y. William Dodge, pretty prominent scholar, has also suggested the difficult to grasp nature of this concept, and then a whole host of cases that in the US that have defined the concept in terms of precisely slipperiness, vagueness, etc. So there are a lot of concepts in law that have those qualities. Courts are there to sort of work them through. I just want to, in reinforcing my own perspective here, indicate the irony of the Solicitor General, one of our government's top lawyers, espousing as determinative or potentially determinative this difficult to grasp indeterminate concept.
Thank you. Janis Klump, did you want to add anything?
I'm also mostly joining Professor Curran and Professor Weisberg. Maybe one thing I would add is As we already mentioned, there's no exhaustion requirement due to comedy in the FSI expropriation exception. So for example, like the Arbalest Court did in the Seventh Circuit, it has to derive the exhaustion requirement, and it derives it from international law. However, as Professor Curran already said, the FSIA is a comprehensive statute, so there's no room for intrusion of international law. And that's why comedy cannot require exhaustion of remedies.
Thank you. Todd Grabowski, did you want to add anything?
No, nothing further from me.
Okay,
Thank you.
super. So our next question comes from Avi Roskam. In light of the recent Philip decision that if a foreign sovereign takes property from its own national, that is not a taking in violation of international law within the meaning of the FSIA's expropriation exception, what is the path forward for plaintiffs in cases like Simon? Do the Simon plaintiffs merely need to prove that they were not citizens of Hungary? Would they be able to succeed in establishing that?
So the answer is yes. And to be very clear, the case law that has been established and that long predates what I call the genocide exception makes it clear that the formal nationality of the victim is not at issue. It is whether the plaintiff was treated as a full-fledged victim by the country. And there's one case in which the court said of someone who was a Hungarian Jew, and another case quite some years ago, the plaintiff may have considered him or herself, I can't remember, to be Hungarian, but it was clear the government did not. So the Simon case absolutely would be able to move forward and win on that. The only issue in the US, because we are a common law country in which objections are lost if they are not made at the first trial court level, and that has everything to do with the common law system, which psychologically is built on the idea of a jury, even though it's complicated, but that's the way the common law system is set up. Means that they may have lost, they may have been deemed to have lost this argument if it was not considered to have been made early enough, and that is what the defendant has, I believe, argued, that they have lost that argument. But yes, the Simon case, that's all they would have to do.
I believe that Fisher and Abelez will be confronted with the same problem. They have overcome hurdle after hurdle, including the exhaustion of remedies. They actually walk the walk and talk the talk of the otherwise sympathetic judge in the Seventh Circuit and gone there. I agree with Vivian, though, that there could be that problem of not having raised this, and maybe it's too late. There are all kinds of problems. From my point of view, what we hope will not happen is the intervention of, again, the executive branch favoring dismissal of the suits on that or other basis. And maybe that will happen, but that we will find out about. I want to take the occasion of the questioners posing it to recognize that Yanis Klump and Todd Gwibarski, two of our panelists today, have written just lucidly and extensively, more or less as students, published their approach to not only this problem, but a host of problems under FSIA. And the questioner also, who, if I am heard him correctly, Russ Cummins, coming from Cardozo Law School, has written a very, very excellent law review note on this question. And I want to throw in one other name. I don't know if he's in the room, but Michael Cooper, a young man, has written on the questions that we have taken up today in the Brooklyn Journal of International Law. This is very encouraging to senior, white or silver-headed, I'm not referring to Vivian,
I have quite a few silver hairs here.
just a few professors in this field. I congratulate all of you. And Grabarsky's reminding us, incidentally, of the Bernstein case in its 2 iterations is just an example of the contributions to discussions like this that even very busy people who are not ensconced at the moment in this area can make.
Thank you. Yanis, did you want to add to those comments?
No, I'm joining the comments before.
Wonderful. Todd?
Yeah, so just to piggyback off what Vivian had said, I mean, it boggles my mind a little bit that someone who would be considered a national when this program of expropriation, really stripping them of their rightful any and all rights as a citizen, which is exactly what happened, in many cases, and certainly during the Holocaust. I mean, a Hungarian citizen who was Jewish certainly was not treated as a Hungarian citizen who was not Jewish, and that would go for France or Germany and other countries as well. So I'm not sure in the Philip case what more the court would have wanted for the plaintiff to show exactly that they were stripped of their citizenship and therefore might be treated as some sort of alien who happened to be living in the country. I guess that would be my question in response to this question as well.
Thank you. And I know I just want to note that we're coming to the end of our time on this panel, but I think we do have time to answer one more question. The question is, can the plaintiff be a legal person, an institution or organization acting on behalf of the late victims?
I haven't seen that. Clearly, the heirs of predeceased Holocaust victims, by and large, although there can be arguments against this, can step into the shoes of the category that I call direct victims, such as our clients, 2 of them, in Fisher Abeles, who were young children who were pushed into trains. They survived, except the older one, who was, I think, a girl of 14 or 15, has now died. Their heirs are allowed to step into their shoes for the purposes of the litigation. That does not mean that there couldn't be collateral problems raised by defendants. The defendants will raise everything. But I think the question has something to do with corporations, and if I heard it correctly. Is that right, Elena? Can corporations?
The question was, can the plaintiff be a legal person, an institution or organization on behalf of the late victims? I took it to refer perhaps to a nonprofit or other, public interest organization, but that was not stated in the question. That was just my.
It's interesting. I haven't seen that across 6 or 7 cases, maybe, but the difficulties even for heirs will will eventually get out there. They were raised in the successful Bodner action, what constitutes an heir, and in the resolution of claims, how far out on the family chart do you go? That's a CIVS issue frequently. Do you go out to first cousins, or do you cut things off at second cousins when you define the question of heirs? For in that instance, an award that has already been recognized by the agency or by the court. I do want to mention, apropos of Todd Grabarski's excellent remarks, incidentally, about lawyering, I think we would call it that, that although some of them I've occasionally had meals with or drinks with, and I personally have nothing against their work, I would say that over the course of many years and cases, defense counsel, generally speaking, as you would expect, are high-priced, pretty tony, I would say, using an old-fashioned term, partners often with their associates of big law firms. The plaintiffs are kind of ragtag individuals with a variety of talents who fight hard. And apropos of the question about heirs, it's one thing for the plaintiffs to overcome the hurdles that we have talked about today, particularly in the face often of US opposition. They also have to face the hurdles of these defense lawyers, which is legitimate, but who extend the case themselves as far as they can, raising all kinds of issues. And it might interest the audience just to raise one of these. In open court in Fisher, Judge Hamilton, who was sending our clients to Hungary, this was quite unusual, took 7 minutes of oral argument to elicit from the MOV defense counsel a promise that the statute of limitations would not be raised in the Hungarian equivalent of this case. And with some reluctance, the defense counsel said that it would not. That's not what happened when the case actually took place in Hungary. Aside from what Vivian mentioned, the court requiring documentation, meaning disbelieving the Holocaust victim herself and needing some documentation or some corroboration of her claims, the statute of limitations was indeed raised, which is an oddity, I think, and something that if we ever get back to the Seventh Circuit to argue substantively that exhaustion of remedies has proven futile, we are bound to raise ourselves on behalf of the plaintiffs.
I'd like to raise just for a moment one other point that to address the issue about legal persons. It's important to keep in mind that the FSIA courts are domestic courts, and generally speaking, when we see entities representing plaintiffs, they tend to be states representing individuals in international tribunals. And one of the problems we have with US courts applying the Foreign Sovereign Immunities Act is that they too get that confused. They sometimes interpret the statute as though it applied to international tribunals, looking at legal sources like the restatement of US foreign relations law, and which applies only to international tribunals, and transposing it onto the terrain of the domestic court, which can lead to incorrect conclusions. And so I think that that may be something that's at work here, which is confusing the issue, and probably the answer is no, that the plaintiffs need to represent themselves.
Thank you both. Todd, Yanis, did you want to add to those comments?
I'm once more joining.
One thing I would say is that just on this specific question, I mean, a lot of these cases involve events that happened so long ago. I think there's been recent cases about the Armenian genocide, even cases about German colonization of Africa at the turn of the 20th century. So, you know, naturally the plaintiffs are the heirs of the victims. I'm not sure, you know, they're actual people who are the heirs, but I'm not so familiar with the laws regarding, you know, entities representing individuals, but I assume that possibly could be the case, considering that at this point it needs to be heirs who are the actual plaintiffs. So that could be a possibility.
Wonderful, thank you. Well, we've now come to, and even a few minutes past our time for this panel. Many thanks to all of our panelists for their very thought-provoking remarks, and to the audience for your questions. We now have a short break until 4 p.m. when Stuart Eisenstadt is giving the keynote address on Holocaust justice and sovereignty. And I am not privy to all of the technical details of how this works. So I hope that if there's anything that the audience needs to do at this point in order to hold on for that someone else will step in and tell them that. In the meantime, thank you to the panelists. And it looks like I can turn this over to Ron.
Yeah. Thank you to the panel. Wonderful presentations. I'm going to ask everybody simply to remain on the connection you are on. Hang with us, and we will begin promptly at 4 p.m. With the keynote address.
Thanks, guys.
I think a nice core group to hear you.
Okay. So Richard, are you on sabbatical there?
In a sense, in that I maintain my relationship with Cardozo, but it's a distinguished visiting professorship here, it's called. And I'm teaching this year full load, meaning at Pittsburgh.
Richard, I think we can begin.
Very good. Everybody's back?
And Kim, if you can remove the, we will be right back. We will be back.
So welcome back on behalf of the CILE program at the University of Pittsburgh and the Law and Humanities Institute as co-sponsor. The word honor is used an awful lot when introducing people. It is my honor, et cetera, et cetera. I don't know what other words to use, but it would have to be more than that. It's like the French verb tense, plus que parfait, you know, something more is going on. To be able to introduce to you our keynote speaker. And in my capacity of doing that, my introduction is going to be a little bit more personal than usual. I need to alert people to the fact that set up your questions for Ambassador Eisenstadt in the Q&A format. There will be time for him, I think, to take questions, and that's the format in which they should be raised. So you have in your programs the incredibly distinguished resume and career of our keynote speaker, Stuart Eisenstadt. What I want to do is, this is the kind of person whose resume develops in a positive fashion on almost, it seems like a weekly basis. So I want to start from an honor that our keynote speaker received only 10 days ago from the Holocaust Memorial Museum, the US Holocaust Memorial Museum, which gave Stuart Eisenstadt its highest award, the Elie Wiesel Award. And although there may be some redundancy with what you see in your programs, I'm going to read what they say about Stuart Eisenstadt and giving him the award. And a lot of this is especially appropriate on Holocaust Memorial or Remembrance Day. Although his career entails an enormous amount of other work involving diplomacy that has nothing to do with the Holocaust and with sovereigns. By bringing the issue of Holocaust justice back on the world's agenda after decades of indifference, Ambassador Eisenstadt has played a singular role in securing the permanence of Holocaust memory, as well as compensation and restitution for Holocaust survivors worldwide. In 1978, in his capacity as Chief White House Domestic Affairs Advisor under President Carter, Eisenstadt played a pivotal role in the establishment of the President's Commission on the Holocaust, recommended the appointment of Elie Wiesel as its chair, and was instrumental in the legislation that led to the creation of the United States Holocaust Memorial Museum. I'm going to pause for a moment just to have three props as part of this introduction. Eisenstadt's career in respect of Holocaust-related work and other work goes back to the Carter administration. And I know he won't mind if I give a plug to one of his books, which is in front of you now. It's a remarkable work. And what was just referenced, it's called President Carter, the White House Years. What was just referenced by the Holocaust Museum's encomium is, as a young man, setting into place or helping to set into place the establishment of Holocaust memory under Carter. You'll read in his book that played a role, very interesting anecdote, in the remarkable achievement of the Carter administration, which was the Camp David Accords, almost a miracle, that were signed by Menachem Begin and Anwar Sadat at Camp David on September 17th, 1978, and a lot of other things that played into that. Let me just continue a little bit with the Holocaust Museum's description. Serving 4 additional presidential administrations, Ambassador Eisenstadt has led tireless efforts to secure justice for survivors. In the Clinton administration, while serving as ambassador to the European Union, Under Secretary of Commerce, Under Secretary of State, and Deputy Secretary of the Treasury, he also served as special representative on Holocaust-era issues. He negotiated major compensation agreements with many European countries, banks, corporations, and insurance companies, the 42-nation Washington Principles on Nazi-confiscated art, and for communal and private party restitution. Here I also pause, and on a more personal level, it was in his work on the French banks case, as we call it, that I first met Ambassador Eisenstadt and became privy to his unique negotiating skills After we had prevailed in the Eastern District of New York, he brought the parties together in the waning moments of the Clinton administration. And in early 2001, together with the banks, the defendant banks, and with the French government, the plaintiffs signed on, as did everybody else, to an agreement that he, Stewart, I don't know if anybody else could have done it, masterminded in a 5 or 6 week period. All parties signed that agreement in the anteroom of the Secretary of State, Madeleine Albright. And forgive me, but here's a picture of moi signing with Stewart in the background. And of course, it was an unforgettable moment in so many ways, and personally led to a trajectory of working with the French, not as an advocate or an enemy or an adversary, which is sort of the way it started, but really as a friend and a diplomat. And we were able, under the agreement, which is called the Washington Accord of 2001, to do a lot of good work for victims of Vichy, primarily in the banking and material claim area. I'll just continue a bit. During the Obama administration, as special advisor to the Secretary of State, he negotiated additional agreements, including with the French railroads, and led the effort to create the 47-nation Terezin Declaration, encouraging more benefits to survivors. He continued to serve as an expert advisor on Holocaust-era issues in the Trump and Biden administrations. That's a very important little factoid, at least for me. And finally, to plug a book of his that is better known when we have the kinds of discussions that we're doing today, maybe than the Carter book. Much of his work in cases like the Banks case, French and Swiss, the European insurance company cases, numerous other cases that he was instrumental in resolving, are reported in his superb book called Imperfect Justice, which I recommend to all of you who haven't read it yet, who are interested in our topic today. So our keynoter is a movable feast of good works. And even though he and I disagree on some fairly key issues, that's nothing. That is a crumb compared to the wonderful cake that his career represents, an inspiration to all of us. So without further ado, I hand the floor over to our keynoter, Stuart Eisenstadt.
Thank you for that overly generous introduction, Richard, and for your friendship. And thanks also to Ron Brand for making this possible. Recent decisions by the U.S. Supreme Court reinforce my view that the best means to achieve belated justice for Holocaust survivors or heirs of victims of the Holocaust are voluntary agreements negotiated by the U.S. government with other governments or foreign corporations, emphasizing the moral issues involved and the reputational damage to the nation or company of not rectifying the results of their violations of human rights. At the same time, I do hope, and Richard and I have talked about this, that Congress will clarify the expropriation exception to the Foreign Sovereign Immunities Act to give a more liberal push to our courts to permit cases to be brought in this area of human rights violations. There was nothing inevitable about the killing of 6 million Jews. and millions of other innocent people in the Holocaust between 1933 and 1945, any more than there is anything inevitable about the genocide that occurred under Pol Pot in Cambodia, the Rwandan genocide, the ethnic cleansing by Serbian militias and troops against the Bosnian Muslims and the Kosovo Albanians in the 1990s, or the ongoing mass human rights violations against the Rohingya in Myanmar, the Kurds in Syria, or the Uyghurs in China. All have one thing in common. They're perpetrated against vulnerable minority groups while the world largely ignores their plight. The Holocaust, or the Shoah, is the most tragic example of what happens when people and governments are indifferent or inactive in the face of evil. When the Western world refuses to act because of prevailing anti-Semitism, Jews were expendable then, just as other religious or ethnic minorities are today. Hitler's goal was to make Germany Judenrein, free of Jews, not the final solution initially. He proceeded very cautiously and carefully, waiting to judge German and world reaction. And seeing none, took one step after another. First, racial laws, destruction of property, barring Jews from professions, expropriating all sorts of goods and services, and then finally deportation and murder. At the outbreak of World War II in 1939, there were 17 million Jews in a world of 2 billion. Today, as a result of the Holocaust, there are only 14.7 million Jews in a world of 7 billion. The German people acquiesced in or even supported seeing their neighbors dispossessed and deported. And the world failed to act, including the United States. Hitler got a clear signal and said so publicly that the world didn't care about protecting Jews and that therefore he had a free hand to commit the worst genocide in world history. For example, at the Avian Conference in 1938, called by President Roosevelt to deal with the growing plight of German refugees with 32 countries, the United States failed to take the lead to lift our rigid immigration quotas and set an example for the rest of the world. While at the same time and throughout the war, his State Department, under Breckinridge Long at the time, as Assistant Secretary, did all it could to restrict immigration. In May of 1939, the SS St. Louis, a German ocean liner carrying 907 German Jewish refugees, sat for days outside of Miami and was not allowed to dock. No sanctions were imposed on Germany before the US finally entered the war. President Roosevelt had substantial evidence about the genocide but failed to act, including smuggled reports by resistance fighters and a personal visit by a man I met many times in his later years, a courageous non-Jewish Polish diplomat, Jan Karsten, who twice secreted himself into the sewers of the Warsaw Ghetto so he could bear witness, and then in the Oval Office itself poured his heart out to FDR and later that same day to Justice Frankfurter about what he saw, and FDR still refused to act because he didn't want World War II to be perceived as a war for the Jews. The publisher of the New York Times gave his editors instructions to bury stories of the Holocaust for fear it would be viewed as a Jewish newspaper. Nor, frankly, did American Jewish leaders do all they should to have put pressure on FDR to act more urgently. In the immediate post-war days, upon the liberation of death camps, Nazi atrocities were revealed and filmed at the assistance of Supreme Allied Commander Dwight Eisenhower. And if anyone doubts what we knew, I was Deputy Secretary of the Treasury. I can tell you now, it's well documented. In 1944, when Henry Morgenthau Jr. was Secretary of the Treasury. His staff presented him a report labeled "The Acquiescence of This Administration in the Genocide of the Jews." And when he finally got that to FDR, it stimulated FDR to create the War Refugee Board and save tens of thousands of Jews, but it was too late. So in the immediate post-war era, Eisenhower, to his great credit, insisted on film crews filming the decimated people in the concentration camps. And while Americans were shocked to see these newsreels, the staggering dimensions of the Shoah were not understood. And the Holocaust quickly took a back seat as the focus of the United States and the Western world was fighting another war, the Cold War, against the Soviet Union. And so as a result, there was little demand for justice of senior Nazi officials beyond the Nuremberg trials of only a tiny fraction of Nazi perpetrators. And read the New York Times this very week to learn how we incorporated some of the worst of the Nazi offenders in our post-war intelligence against the Soviets. Jewish survivors were poorly treated. Those trying to reclaim their confiscated homes in Poland and Lithuania were killed. And post-war property restitution laws in Western Europe were unsatisfactory. They were placed in squalid DP camps after the war, so bad that President Truman's representative, Earl Harrison, said that these concentration camps are the equivalent of the German camps, except we don't exterminate the Jews. Great Britain had 52,000 survivors trying to reach Palestine in camps in Cyprus. Authors like Elie Wiesel had difficulty finding publishers for their books. And yet, the monstrous dimensions of the Holocaust could not forever be hidden, although action to deal with its consequences were slow and painful. The 1961 trial and conviction of Adolf Eichmann, almost exactly to the day, 60 years from then, one of the central perpetrators of the Holocaust, following his dramatic abduction from hiding in Argentina, presented on worldwide television a human face to the brutality of the Nazis. The Eichmann trial helped lay the groundwork for later criminal trials decades later against other perpetrators of mass violations of human rights, although not on the scale of the Holocaust. My personal exposure to all of this came when I was 25 years old. I had completed a year in the Johnson White House, and I was working on the Hubert Humphrey presidential campaign against Richard Nixon. One of my co-workers was Arthur Morse, who had just published a path-breaking book called While 6 Million Died, using newly declassified Roosevelt-era records. And it spread before my eyes and the world's, shockingly, what FDR knew and failed to act on. And this was, to me, a complete shock, because Roosevelt was an icon in my home. And I said to myself, literally at the time, as a 25-year-old, if I'm ever in a senior position in government, I want to do something to remove this cloud from the history of the United States in World War II, whose soldiers had done so much bravely to win the war. A whole genre of books then followed by other major historians, as did major films, including the 1978 NBC widely watched miniseries, The Holocaust. Beyond books and movies, the Holocaust created for the first time in the history of warfare a unique legal process by which a country, here Germany, that had abused and murdered civilians, both its own and those in the countries it occupied, agreed to compensate survivors regardless of where they lived. This was really earth-shattering legally. It didn't rely on traditional court cases. The slaughter of the Jews was too vast. There was no established legal principles. And so it called for a novel approach. And that came beginning in September of 1951, when the first post-war German Chancellor, Konrad Adenauer, accepted responsibility, in his words, for the unspeakable crimes committed in the name of the German people. A month after Adenauer's speech, 23 major Jewish organizations created a unique non-governmental institution, the Conference on Jewish Material Claims Against Germany, or the Claims Conference. And in a historic agreement in Luxembourg in September of 1952, the Claims Conference, the new state of Israel, only 4 years old, and the West German federal government signed two protocols, one calling for German laws to compensate Nazi victims directly, and a second to begin passing money through the Claims Conference for the rehabilitation, resettlement, and relief of Jewish victims. Now, years later, Germany has paid $80 billion in compensation. And yet, today, 2021, there remain around 330,000 Holocaust survivors worldwide, of whom at least 50% are poor or near poor. At least 90% in the former Soviet Union and Central and Eastern Europe, 35% remarkably in the Jewish state of Israel, and around 30% in the richest nation in the world, the United States. Almost all of the German payments, and all the payments that I'll talk about shortly, have gone to those in economic need. This is not a millionaire's payment for those who did well after the war. It's based on need. During this year, 2021, about 250,000 of those 330,000 survivors will receive some form of payment. Over the decades, the mission of the Claims Conference in their negotiations with Germany expanded to cover broader eligibilities. For example, reducing the number of months required to be in a ghetto or a concentration camp to get a pension or a hardship payment. And after the end of the Cold War, for the first time, covering those behind the Iron Curtain who were not able to take advantage of any of the payments. So over the past 40 years, approximately 525,000 Nazi victims, survivors, have benefited from programs like the hardship fund payments. I began in 2009 as the chief voluntary pro bono negotiator for the Claims Conference, along with a team of Holocaust survivors. And since then, as I negotiate with the German Finance Ministry and their state secretary, their number 2 person, I am inspired by the fact that I'm negotiating with people who weren't even born during the war, and yet they feel some obligation to continue to pay and compensate survivors. So since 2009, when I took over, we've obtained over $9 billion of additional benefits, especially allocated for home care, increased pensions, and one-time payments. Now, home care is a special need. As survivors become more frail, they need home care workers to come to keep them out of old age homes where you would not put your worst enemy if they lived in the former Soviet Union, if they exist at all. These home care workers provide things like medicines and help with food and transportation to doctors and socialization services. In 2009, when I began my negotiations, the worldwide home care budget was 34 million euros, around $40 million. Today, 2021, it's 544 million euros, around $600 million, including 24/7 coverage for the most ill and infirm. we began to cover, again, people in Eastern Europe, and we're constantly expanding. We've recently created, for example, a program for those who were on the kinder transport from Germany and Austria to England. We've created new child survivor programs for those who had the trauma of losing their parents during the war. And again, with the reunification of Germany, we not only began covering individuals who had been behind the Iron Curtain, we created a claims process by which property that had been confiscated could be claimed. And so what we did is an organization called the Successor Organization was created under the umbrella of the Claims Conference. And it took title to all of that property, set up a claims process where thousands of heirs of victims could claim and recover their property. But because in so many instances, tragically, whole families had been decimated, there were no heirs. The question of heirless property came, and that heirless property was again given to the claims conference. And 80% of the value when they sold it was given to survivors, but 20% was put aside for Holocaust education. In 1992, the World Jewish Restitution Organization was created to deal with property recovery outside of Germany in the former East Bloc. So the first unique feature, again, is the claims conference concept. Second unique feature occurred during the Clinton administration under my leadership, as Richard was so gracious to mention. And this is payouts by private, underscore, private corporations for the harm they caused to civilians during the war. Again, this has never been done before or since in the history of warfare, where private companies were held to task for injuries they caused decades earlier in warfare. We should remember that the genocide of the Jews, the Holocaust, was not only the largest genocide in history, it was the largest theft in history, only a small fraction of which has been recovered. Now, how did I get involved? I was ambassador of the European Union at the time, a full-time job. When I was asked by Assistant Secretary of State Richard Holbrooke, famous for negotiating the Dayton Accords, at the instance of President Clinton, to serve as a special envoy to recover communal property, churches, synagogues, cemeteries, schools, community centers, after the fall of communism, from what I call the double victims, those who had suffered under both Nazism and communism, so that they could rebuild their shattered communities and begin to practice their religion, which was obviously impossible during the Holocaust, but also was impossible during the communist era. And so as I went from country to country, from Czech Republic, Slovakia, Hungary, Romania, Poland, seeking to recover the physical infrastructure to permit these shattered communities to rebuild their lives. I was reading an article in 1995 in the Wall Street Journal in my office at the US Mission in Brussels about what the reporter called dormant Swiss bank accounts, accounts opened by Jews seeking to put their assets out of the grasp of the Wehrmacht and Hitler into the most safe, neutral banks in Europe and Switzerland. And according to the article, people who tried then to recover were told there were not such accounts. We have no idea about them, no records. I received permission to follow this path. And so I went to Basel, Switzerland, and met with the Swiss Bankers Association and showed them the Wall Street Journal article. Is this true? I asked. Yes, they said, it's true up to a point. We've appointed our own ombudsman. We've gone through every account in every Swiss bank, even those that don't exist anymore, between 33 and 45. We found 732 such accounts, and we plussed up the interest that would have been paid over the years to $30 million. Well, we didn't trust them. And so a memorandum of understanding was signed by Edgar Bronfman on behalf of the Jewish Agency of Israel and the World Jewish Congress, and with our support, appointing Paul Volcker, the former chairman of the Federal Reserve Bank, who we had appointed in the Carter years to kill inflation. And he conducted an independent audit over several years with large US accounting firms. And there weren't 732 accounts. There were 54,000 possible or probable accounts and over 20,000 certain accounts. And in the process, I led an interagency study producing a report on what the Swiss central bank did, helping to finance the Nazi war effort by trading Swiss francs in return for looted Nazi gold that they stole from the coffers of the central banks of the countries they overran. Under the combined pressure of Edgar Bronfman, of sensational Senate hearings chaired by Senator Al D'Amato of New York, class action lawsuits against the Swiss banks, my mediation on behalf of President Clinton, and then the critical intervention of U.S. District Court Judge Edward Corman, a staggering settlement of $1.25 billion was created. Even though this was a class action, this was hardly a traditional one. It is unclear if the cases could have sustained a motion to dismiss. There was never a formal certification of a class or of jurisdiction. Rather, this claims process was set up, and after all the account holders, their heirs, were paid, there was still a huge amount left over. And Judge Corman decided that rather than refund those to the banks, they should be distributed to almost 500,000 Holocaust victims. Then it was like peeling back the layers of an onion. The Swiss bank settlement led to class actions against German slave and forced labor companies who had employed Jewish and non-Jewish slave laborers, often working the Jewish inmates to death. And I mediated these cases along with my German government-appointed counterpart, Kyle Lambsdorff, negotiating with German companies and the German government through 18 months of extremely difficult negotiations. And we reached a settlement of $5 billion, 10 billion Deutschmarks. And I insisted to the German government and to the Jewish organizations and to the class action lawyers who did not represent non-Jewish forced laborers. This should not only cover Jewish slave laborers, but also forced laborers. Yes, their conditions were much better. And so here, again, we come up with a novel concept that wouldn't have been possible in a traditional court setting. We developed a concept we call rough justice. How in the world, in a traditional setting, could you match up a slave or forced laborer decades later with a particular company? And so under rough justice, we assumed that any Holocaust survivor who was in a concentration camp, ghetto, or in hiding, whether for a day, a month, or the whole war, would be considered a slave laborer and receive a one-time payment of $7,500, and forced laborers $2,500. And this was the first time that Germany ever paid compensation to non-Jewish forced laborers. As part of that, we also agreed to $350 million to settle insurance claims paid to an institution called the International Commission of Holocaust Insurance Claims, created by state insurance commissioners. Why did we do this? Because the European insurers refused to pay claims after the war, saying that premiums hadn't been kept up by the owners when they were in Auschwitz. Another novel legal concept to settle the German and ultimately the Austrian case, which succeeded it, was how to assure the German companies who were paying this massive amount that they wouldn't be sued again. And we said to them, under US law, the only way to be sure of that is to get Congress to pass a law barring any future suits, and that's impossible. So we came up with a concept we call legal peace. It made the German companies very, very uncomfortable. Yes, the class action lawyers all dismissed their cases, but how about future cases? So under legal peace, we got President Clinton to issue a presidential proclamation that stated, it will be, and I quote, in the enduring and high interest of the United States to support efforts to achieve dismissal of all World War II cases, that the U.S. Justice Department will affirmatively recommend dismissal on any valid legal ground, we never said which, and that the United States would take no legal position that would preclude dismissal of these cases. Now, again, this did not give the Germans all the satisfaction they wanted, but it's held up in a Supreme Court case in 2003 under the president's power as commander-in-chief. When we then moved to settling class actions in Austria, we had a special challenge because Austria still carried with them the notion that they were Hitler's first victims, not his first willing allies. Again, class action lawsuits were filed. Again, I negotiated a settlement. It was a fat $400 million settlement with the Austrian companies. And an Austria fund was created, capitalized by the private sector and the Austrian government. Even there, that was not enough to settle the cases because the class action lawyers insisted that property claims must also be satisfied before they dismissed any of their cases. And this was very complicated. Chancellor Wolfgang Schussel, the Chancellor of Austria, was widely distrusted by Jewish groups because he had entered a new coalition with a far-right neo-Nazi group. I, by the way, had excellent relations with him. And in negotiations with the Jewish groups, class action lawyers, and Austria, we agreed on a fund of $150 million to cover apartments and leases, movable property like furniture, valuables such as jewelry or violins and the like. And then in an all-night negotiation in the Chancellor's office, which we call the pizza negotiations because the Chancellor ordered pizza for everyone, the Austrians agreed to establish another fund of $210 million for the confiscation of Jewish private property with a formal claims process. There were over 18,000 claims. There was a double cap, no more than 210 million in total. No individual or heir could get more than $2 million. At almost the same time, in the waning hours of the Clinton administration, as Richard mentioned, I concluded an agreement with the French banks and French governments for Jewish bank accounts there, based on lawsuits that Richard and his colleagues filed. And when federal judge Sterling Johnson refused to dismiss the cases and ordered discovery, the French banks and governments were shocked. It was the first time in Holocaust litigation that a US judge permitted a case to go forward. And the French were very angry because they had created their own fund of $375 million to deal with these issues. The president of France, Lionel Jospin, appointed Jacques Andriani to be my negotiating partner. He was a distinguished former French ambassador to the US, and working with Richard and his colleagues in the French government, we reached a $22.5 million settlement for another rough justice fund. In 2014, during the Obama administration, I negotiated another agreement with France, this one for the deportation of Jews on the French railway, and that was for $40 million. This was occasioned by Maryland legislation that would have banned the French government railway, SNCF, from bidding on a lucrative project. And recently, very recently, the Dutch government, following this, has created its own fund for the deportation of Jews from Westerbork on the Dutch railway. Another novelty of international law during the Clinton administration was my negotiation with over 40 countries in 1998 of the Washington Principles on Nazi Confiscated Art, establishing principles for the identification, publication, claims, and return of some of the 600,000 artworks stolen by the Nazis. This was amplified and broadened by the 47-nation Terezin Declaration I negotiated in 2009 in the Obama administration. Now, interestingly, neither the Washington Principles nor Terezin were legally binding. They were moral documents, but they profoundly changed the art world. 5 nations, the Netherlands, Germany, Austria, France, and the UK, have established claims commissions to adjudicate claims against public museums that hold looted artworks. And Christie's and Sotheby's, the great auction houses, have created full-time staffs to vet any painting or artwork before they auction or sell it that's gone through European hands between 1933 and 45 and will not sell it if there's any suspect provenance. Christie's alone has settled over 100 cases. In 2018, the US Congress passed the JUST Act, calling on the State Department to report on the implementation of our Terezin Declaration by its 47 state signatories. And we just, in July of last year, with my assistance as expert advisor to the State Department of Holocaust Issues and led by the Special Holocaust Envoy, Sherry Daniels, in effect gave a report card to each of the 47 countries in terms of their implementation. All of these are examples of resolving mass violations of human rights with the leadership of the US government when issues of Holocaust justice are raised directly and forcibly and are essential, indeed more effective, and can cover vastly more victims than would be possible in any traditional civil litigation. This is certainly not universally the case, as we have other instances where there have been disappointments. For example, in a case involving the Thyssen Museum in Madrid, where there was clearly a theft from the Casarir family, they simply refused to return the art and were supported by a US court on the ground that under Spanish law, the ultimate donor, Baron Thyssen, may not have known that the artwork was stolen. Indeed, US courts are not sympathetic to Holocaust claims brought against museums, nor frankly is our own Justice Department, out of concern that the US should provide what's called comity to foreign governments from suits in US courts. That is, if we sue a foreign government, then they might sue us for slavery or whatever in their courts. Now, there's an exception that's been created in 1976, an expropriation exception, but that's been given a very narrow reading in a very recent case, March of 2021, and the Supreme Court called Germany versus Phillips, following the amicus brief of the US Solicitor General, and they ruled against a recovery of what's called the Guelph Treasure, a collection of medieval religious art that Hermann Goering obtained in 1935 following intense pressure against German Jewish art dealers and gave as a gift to Hitler. No one denied that this had been stolen, but because the Washington Principles are not binding and because of a reading by the Supreme Court that in effect international law in this instance and the FISA exception, expropriation exception, only covered situations where alien property was wrongfully taken. That is, where a country takes property not from its own citizens, but from aliens, it struck the case down. Now, this to me was ridiculous because in 1935, to suggest that German Jews were real citizens, I think was a failure of understanding history, but that's what they did. Let me conclude by saying that monetary compensation or restitution should not be the only way to deal with the victims of the Holocaust or other acts of genocide. Nelson Mandela showed a very effective way by creating a Truth and Reconciliation Commission. This makes Holocaust education also all the more important. A recent survey by the Claims Conference showed almost half of American millennials and Generation Z had almost no knowledge of the Holocaust, and I could go into more detail if time permitted. So what we've done is the following. In January 2000, as Deputy Secretary of the Treasury, I worked with the Prime Minister of Sweden, Göran Persson, and we established a Holocaust Education Task Force, which now is the Holocaust Remembrance Association Alliance with 30 countries to promote Holocaust education. Last year, Congress passed the Never Again Holocaust Act to provide $10 million for Holocaust education to the U.S. Holocaust Museum. And in our most recent negotiations with Germany, we got Germany to agree to fund worldwide Jewish education up to 18 million euros by 2023. Now, I'll leave you with a question, and I think time doesn't permit, if we're going to have any time for questions, given the fact that Richard took 10 minutes of my time with this wonderful introduction. The question is, has the Holocaust taught the world anything? And I've got an answer to that, but maybe we should take that as a question because, again, our time has run short.
Thank you, Ambassador Eisenstadt, for that wonderful review of a remarkable career and the ways in which lawyers can work at these things. And I invite our audience to put questions in the Q&A. There is one question to begin with, and I think it relates this to beyond the Holocaust, which goes to your question, has the Holocaust taught us anything? Can you tell us something more about racial laws that were applied in the Jasenovac extermination camps for Serbs, Jews, and Roma, and if they were similar to Nazi ones?
Yes, they were. And so there is the question, as genocides are going on as we speak, have we learned anything? We certainly have learned what happens when good countries say nothing. And that's why I was so pleased, for example, that Secretary of State Blinken was very direct about China's treatment of the Uyghurs. But let's look at some of the positives. The Universal Declaration of Human Rights in 1948 remains a landmark and has led to other declarations against racial discrimination, genocide, discrimination against women. The Council of Europe adopted the European Commission on Human Rights, and now there is in Strasbourg a European Court of Human Rights, which to this day allows individuals to bring claims for human rights violations against their governments, and it works. The International Court of Justice was created in The Hague in 1943 and is in effect the principal civil court of the U.S. International criminal law has also developed. This began, of course, with Nuremberg and with the Eichmann trial, but now, since 1993, the UN Security Council established the International Criminal Tribunal for the former Yugoslavia, and several of the worst Serbian human rights offenders were tried and convicted. In 1994, the International Criminal Court for Rwanda was established following the Rwandan genocide, and in 2002, the International Criminal Court in The Hague came into being with now over 120 nations, not including the United States. In addition, there are NGOs like Human Rights Watch and Doctors Without Borders and Amnesty International, which identify war crimes and bring them into our attention, and the Holocaust Museum's own Genocide Prevention Committee does so as well. So the internet, while it spreads hatred, also can inform us about these. And a critical factor is, in my opinion, the President of the United States. if the president makes human rights a key part of his foreign policy, as I'm proud to say President Carter did, and as President Biden and Secretary of State Tony Blinken are doing, it makes a difference. It does make a difference. And I would say also, to conclude on this, that this is an individual responsibility as well. We have a responsibility to learn the lessons of the Holocaust, not to be indifferent in the face of genocide and mass human rights violations, to pressure our government to take a stand, to fund human rights groups, to take effective action against hate at home and genocide abroad.
I'd like to follow up on that if I might. Your work and the agreements you've been able to achieve have been as a representative of the executive branch, as a representative of the president, and you emphasize that importance. You've also emphasized, you began by kind of forcing a question when you said that the best means to achieve belated justice are voluntary agreements, but you also said that you believe Congress should amend the FSIA to make it more effective against human rights violations. And so you seem to be suggesting that lawyers should be working in multiple ways in order to achieve these.
And here, I mean, Richard and I have somewhat of a difference of opinion because with my State Department hat on, there is an issue of comity, of being concerned about the U.S. being sued in foreign courts. There is an issue of exhaustion of remedies to make sure you exhaust your remedies in the home country. But Congress created this exception to the Foreign Sovereign Immunities Act for expropriation for a reason. And when that is given a very narrow reading, I think it precludes action. What I'm suggesting, I think, is that if you look at all the negotiations that I did, almost all of them were catalyzed initially by class actions. Now, I don't think they would have gone to term, but the fact they were brought, the fact that they were high visibility, the fact that it impugned the reputational value of Swiss banks or German and Austrian companies that wanted access to the biggest market in the world, the United States, and with this cloud hanging over them, realized they needed to settle, that combination of action forcing device made it possible for me to negotiate.
I see Richard leading in, and I believe he has a question. Am I right, Richard, as I look at your face there?
I like Stuart's use of the verb catalyzed. Actually, I stole that from a conversation we had yesterday and used it in my own talk. On his account, many of the effective negotiating follow-ups, diplomacy, you might call them, of the executive branch were catalyzed by either actually successful US court actions or potentially successful federal court actions. And I guess I was saying, and I think Stuart may agree, and all we are asking is that the US government does not affirmatively take a role in opposition to those lawsuits, because then a primary catalyst disappears. We still have to find a way of settling the Hungarian situation. It's a shame, as Stuart, I think, himself said, and as Vivian said on the panel, that the Supreme Court took the position they did on domestic takings, obliterating the lawsuit in Philip having to do with works of art. They were strongly urged to do so by the Solicitor General. So I very much like his verb catalyzed. There is kind of a healthy symbiotic relationship between the statute that permits these lawsuits, if they are permitted to go forward, and eventual action by the executive branch, if that is to be found. And thanks to Stuart Eisenstadt, it very frequently has.
Yes, but again, I think we have to be careful. And again, I come at this not just as a private attorney, which is what I was not taking that, all these negotiations. I wasn't a private lawyer. I was representing the US government. There is a legitimate concern about what's called comity. That is, if we bring a suit against a German museum or a German court, a Hungarian museum, or could we, the United States government, then be sued in their country and not claim sovereign immunity? There's also the issue of exhaustion of remedies, that before one goes into the US court, you should exhaust your remedies at home. Now, I think in the Phillips case, the German case, the case where Goering, in effect, confiscated these properties and gave them gave them as a gift to Hitler, there was exhaustion. They went to the German Art Commission before they came to the US. So those two issues are legitimate issues. I think that it would be useful if Congress clarified circumstances under which there was more access to US courts and under the expropriation exception. Congress created that exception for a reason. And I think, frankly, it was a Holocaust-related reason. But again, this is a difficult area, and there are legitimate US government concerns about the implications of suing a foreign sovereign in the US relative to what will happen to the United States if we're sued abroad.
Well, there is an area of disagreement here. Again, maybe it will be resolved by the US Congress. I concur that clarification is needed. On the other hand, the statute says nothing about either comity, which is a concept that almost all scholars have wondered about, and even precedent cases in federal courts have questioned. Very slippery and difficult notion. The executive branch certainly can be concerned about that. But if, at least as I read the statute, even currently, the control of these cases, once jurisdiction has been established, under an exception, is in Article 3 courts. And it's really a wide open question unless they're being pushed by the executive, or even if, as in the Scalin case versus the French Railroad, they are explicitly not being ordered. The executive doesn't have that power, but through a letter of interest, advised strongly to go that way, then the Article 1 has, I think, exceeded its intended power under the comprehensive Article 2 statute as relates to Article 3 judgment.
If I can, Stu, before you respond to that, I'd like to, we do have a question from the audience that I think raises comity in a reverse process. It asks, is a court held in favor in Phillips or the Simon case of the plaintiffs, how would the compensation be enforced in the case where a defendant state refused to pay compensation voluntarily? This brings up the question, comity also arises in questions of recognition and enforcement of judgments across borders. And it's the other aspect, what will we do with what their decision is, not can it be used on the other side against us. Could you respond a little bit to that, Ambassador?
Well, maybe Richard is the one who should do it. He's the one that's pushing these private causes of action. I mean, what I've done is I've done it in a US government capacity. I guess the answer is that there are many instances in which a verdict in one court of one country is enforceable in another There are all sorts of statutes which permit countries to enforce judgments of other countries. So I don't think that's an impossible standard, number one. Number two, if the German museum had lost this case, it's inconceivable to me that they would have stood behind the issue of, you can't now enforce this. The reputational damage would have been much too great.
I would very briefly piggyback on what Stuart said by responding, although it's a complex issue, and there have been cases in the United States, post-judgment cases. For example, the Iranian collection at the Oriental Institute of the University of Chicago. It's a whole separate area of jurisprudence. And again, the executive here sometimes plays a role in making actually the satisfaction of such judgments a possibility, but that's separate. I would say my best answer to that question is the career of Stuart Eisenstadt. I don't know what more to say, but can we, as time goes on in these areas and in other human rights areas, count on a force like this to use superb negotiation methods and other means of settling suits upon reluctant nations, if indeed they prove themselves reluctant, once a judgment has been enforced or once a judgment has been declared against them.
I'm going to ask one last question, Ambassador Eisenstadt, that I think takes this to the step back to your question. Have we learned anything from the Holocaust? And it does seem to me you and Richard have both been talking about compensation for past acts. In the legal system, we hope that what we do will create, help remedy past acts, but also prevent future acts. Do you see the system as it is now as being such that it does cause those in power to think twice before doing something like this again?
I think the answer is yes. Now, does that prevent the military in Myanmar from suppressing demonstrators and terrible acts against the minority population or the Uyghurs? Does it prevent the Chinese from putting Uyghurs in concentration camps for quote unquote re-education? No, but by shining the light on that repeatedly, it is a reputational damage to them, which is, I think, a prophylactic about how far they can go. And it has a reputational damage to them. I mean, if we see ourselves, as I do, in the 21st century as being in a competition across the board with China, military, economic, political, but also in terms of values. I mean, I think that this is a huge argument for the United States and the West in terms of values, that we don't want a world in which countries can freely suppress their own people like that. And again, if it had existed in the Holocaust might not have happened. We had no human rights groups. We have human rights groups now. We have intrusive reporters. We have the internet. We have all sorts of things to raise the visibility of these mass violations of human rights. But again, I come back to the fact, having served in many administrations, at the end of the day, it's the President of the United States and his administration that set the tone of this. If, as occurred in perhaps the previous administrations, this and what Putin does and so forth are just ignored, then it gives a green light. But if the United States and the President, knowing that he has to balance things, I mean, we can't, look, I learned during the Carter years, we put tremendous pressure on the military dictators in Latin America. We cut off arms. It ended up producing democracies there, releasing thousands of prisoners. But even there, we had to balance. The same thing, we championed the rights of Soviet Jews to get out. But we had to sign an arms control agreement, SALT II, with the Soviet Union. So it's always a balance. But if human rights are a major part of your foreign policy, it can make a difference. Combined with active journalists and NGOs.
I'm going to take that as a glass half full optimistic perspective on which we can end the session today. Thank you, Ambassador Eisenstadt, for wonderful presentations. I invite everyone with us to join us again at 2 o'clock tomorrow, where the first panel takes up the sovereign and the individual in the law. And so we'll dig into some of these issues and related issues a bit more. But once again, Ambassador Eisenstadt, simply thank you.
So hello, everybody. Welcome to our second day of this terrific conference. And I just want to add my thanks again to Ron for all he has done to put this together, to Richard Reisberg, and to, of course, the CILE folks and the Great Law and Humanities Institute that have sponsored this event. We have great speakers, so I'm going to get out of the way, but I want to tell you how grateful we are to have everyone joining us, and I am looking forward to a spectacular second day. So thanks again for being here.
Thank you, Dineen. And welcome back, everyone. I think that yesterday's program was challenging, interesting, and incredibly informative. We had the wonderful keynote, of course, by Stuart Eisenstadt, former ambassadors to the European Union, as well as official in 4 different administrations in other ways. Today, we turn to topics of the sovereign and the individual in the law, and the sovereign in literature and history. So we take a bit broader look at things. I'm going to turn things over right now to the moderators for that first panel, Professor and Vice Dean Haider Al-Hamoudi here at the University of Pittsburgh. Haider, take it away.
Well, thanks very much, Ron. I appreciate the opportunity to introduce such a distinguished panel and to moderate the panel. And what I think I'm going to do is go ahead and introduce all the speakers and the commenters at once, and then we'll go seriatim through them. As I say, it's a very distinguished panel. Each panelist will have 15 minutes to make their remarks, and then Professor Lobel, as the commentator, will offer comments for about 10 minutes, and then we'll open it up to the Q&A. We'll give the speakers an opportunity to speak with each other, and then we'll open it up to Q&A. So introducing the speakers first, and their bios, and they're extremely distinguished speakers without exception. Their bios are available in the program. I'll just point out some highlights. First of all, starting with Professor Paul Guyer, who is the Jonathan Nelson Professor of Humanities and Philosophy at Brown University, and Florence R.C. Murray Professor in the Humanities Emeritus at the University of Pennsylvania. His bachelor's degree and his PhD are from Harvard. He's been a fellow of the American American Academy of Arts and Sciences since 1999, and one of his awards, among many, is the Centennial Medal of the Harvard Graduate School of Arts and Sciences in 1996. He is probably the leading scholar, certainly one of, and I would say the leading scholar of the philosophy of Immanuel Kant within the American Academy. He's general co-editor of the Cambridge edition of the works of Immanuel Kant. It's a 16-volume edition, and a 16-volume work. He co-edited and translated within that the Critique of Pure Reason, among Kant's greatest works, the Critique of Pure Reason, Critique of the Power of Judgment, and Notes and Fragments. He is the author of more than 24 books, including a biography on Kant, which is in its 2nd edition, published in 2014, A History of Modern Aesthetics, which is published in 2014, and 2 recent books, Kant on the Rationality of Morality in 2019, and Reason and Experience of Mendelssohn and Kant in 2020. 2020. He's going to be publishing something entitled A Philosopher Looks at Architecture in 2021, and he's written on Kant's political philosophy and its relation to the natural law tradition as well. The next speaker is going to be Charles Kutubi, Chuck Kutubi. He is a partner at the Washington, D.C. office of Jones Day, and he has represented states and private parties in international arbitration and litigation of disputes around the world. He offers a practitioner's perspective on the way in which the law allows and limits claims by private parties against states and the ability of states to claim special status in international dispute resolution. He's also published, in addition to offering this practitioner's perspective, he has published numerous articles on international dispute resolution, and he's co-author of the general principles of law and international due process, principles and norms applicable in transnational disputes. That was co-authored with Luke Sabata, our own Luke Sabata, Oxford University Press, 2017. The third speaker is someone you may have heard of. His name is Professor Ronald A. Brandt. He is the Chancellor Mark A. Nordenberg University Professor. He's a John Murray Faculty Scholar, and he, of course, is the director, the academic director of the Center for International Legal Education. He's written on issues of sovereignty really throughout his entire career, particularly in the context of dispute regulation, analyzing traditional scholarship on sovereignty and how it applies in contemporary affairs. Finally, as our commentator, we've got Jules Lobel, who is the Bessie McKee Walthour Endowed Chair at the University of Pittsburgh School of Law. He's co-authored an award-winning book, Less Safe, Less Free, Why America is Losing the War on Terror, Professor David Cole. It won the Roy C. Palmer Civil Liberties Prize for exemplary scholarship on the tension between civil liberties and national security. He's written a book entitled Success Without Victory, Lost Legal Battles and the Long Road to Justice in America for 2003. He may need to offer a new edition of that because he has won some important legal battles recently, primarily with respect to prisoners' rights, which has been a recent passion of Professor Lobel, and successfully leading a charge to all but end the practice of solitary confinement in California prisons. He has been a former president of the Center for Constitutional Rights, and has litigated a number of cases involving constitutional and human rights issues. So what we have really is an excellent panel that does a great job of mixing as the panel title suggests. It is describing the relationship between the sovereign on the one hand and the individual on the other, but not only in the context of human rights and not only in the context of economic relationships and commercial relationships, but rather it's a wonderful opportunity to really cross those boundaries with scholars who have focused on one or both of those respective fields. So with that, I'll ask each panelist if they could just keep themselves to 15 minutes, and then we'll let Professor Lobel offer some comments for 5 minutes. So Professor Geyer, I believe you are up first.
Okay, I will do my best to speak for 15 minutes. I would like to begin with thanks to Ron, Vivian, and especially to Richard Weisberg for my invitation. As you might infer, my contribution is going to be philosophical rather than legal. And as you might not infer, it's going to concern domestic rather than international sovereignty. But before I begin, allow me a personal word. My wife, Pamela Foa, and I were both assistant professors of philosophy at Pitt in the 1970s. Pamela decided that she would rather be a lawyer and enrolled at Pitt Law while she was still teaching philosophy across the street. Philosophy was in Shenley Hall in those days. She was very upset when I told her that I had learned from Ron a few weeks ago that Emeritus Professor Richard Seeberger had passed away from COVID last fall, because Dick Seeberger was one of the most inspiring teachers she ever had at any point in her academic career. And his approach to constitutional law had informed her work through a decade in the Office of City Solicitor of Philadelphia and nearly a quarter century as an assistant United States attorney in the Eastern District of Pennsylvania. So on behalf of both of us, I am dedicating this talk to the memory of Dick Seeberger. My question for today is whether the traditional notion of sovereignty makes sense when applied to governments that supposedly consist of multiple, in particular 3 co-equal branches. My answer is that it can if we disregard some of the rhetoric that goes around the idea of the 3 equal branches, but that the devil lies in the details, namely in which branch is in fact awarded the key attribute of sovereignty. I use Immanuel Kant and James Madison for a contrast. The result of my comparison will be that while Kant asserted the de jure sovereignty of the legislature, he gave de facto sovereignty to the executive. But while Madison spoke the language of checks and balances, the original design of the Constitution, if not its recent application, clearly awarded sovereignty to the legislature, and in that way does make room for continued use of the traditional concept of sovereignty. My argument is strictly a comparison with no claim of historical influence. Kant published his political philosophy late in his life, well into the 1790s, but with no evidence of any American influence. And conversely, it's never been influential in the American tradition. Even John Rawls constructed his very Kantian political philosophy entirely on the basis of Kant's moral philosophy, with virtually no reference to Kant's own works in political philosophy. And Kant's political philosophy has received serious scholarly attention in the Anglophone domain only in the last few decades. And in fact, I believe it still has very little influence in US jurisprudential circles, although perhaps it has some more north of the border, specifically in Toronto. Sovereignty was defined in the 16th century by Jean Bodin to consist in the recognition of no power greater than the sovereign other than God, or subsequently the law of nature, that is, other than morality in general. In the words of one modern commentator, sovereignty lies with the power that gets to make the decision in the final instance. Sovereignty was similarly understood by Hobbes. So I take that to be the sense or meaning of the concept of sovereignty, but that the concept can be applied in different cases, in particular, in the case of the relations among states, in relations of power within states, and with regard to individual control over certain matters, such as the control of cyber data. And the last use of sovereignty, individual sovereignty, might be a recent usage. First two, obviously, are of long standing. It was certainly assumed by Hobbes that sovereignty in the first sense can be maintained only if a polity has a strongly sovereign ruler in the second sense, that is, a single domestic authority. And here is Hobbes right behind me. However, the first two applications can be considered separately, and I am going to consider here almost exclusively the second. So my question is, how does the concept of sovereignty apply to governments divided into multiple, supposedly co-equal branches? And if it does apply, then exactly how does it apply? Now, the distinction among three distinct functions or powers of government, namely the legislative, executive, and judiciary functions, had long been recognized by Hobbes. But for example, it's recognized well into 18th century Germany by Gottfried Achenwall, who was professor of law at Göttingen and author of a text on the law of nature, which Kant used for his lectures a dozen times, and which provides at least the outward structure of Kant's own doctrine of right in his Metaphysics of Morals. But both Hobbes and Achenwall suppose that sovereignty had to remain with a single natural or moral person, a single person or group of persons, or in Achenwall's terms, a single civil overlord, even if those functions of the sovereign can be distinguished. Already in 1748, however, and no doubt with other precedents, Montesquieu had argued that the best protection of liberty is the distribution of those three functions among three different persons or bodies of persons, on the ground that allowing more than one of those functions to lie in the same hands makes it too easy for persons with such multiple powers to govern in their own interest rather than for the sake of the liberty of their subjects. Montesquieu's supposition was widely accepted in the second half of the 18th century, certainly by the framers of the US Constitution led by Madison, but also in Germany by Kant and other members of the later Enlightenment. Now, as Richard Tuck has demonstrated particularly well in a 2015 book entitled The Sleeping Sovereign, 18th century enlighteners also distinguished between the undivided sovereignty of the people and the exercise of the three distinct powers of the government. Both Madison and Kant asserted the ultimate sovereignty of the people, and insisted that this be in some form manifested or represented in the government. And that, of course, raises huge questions about how representative of or responsive to the actual wishes of the people any actual government or form of government is. My question, though, is the abstract question, whether it makes sense even to apply the concept of sovereignty as final decision-making power, or the last say, in the case of governments in which the three functions are divided among three persons, bodies, branches, or departments, whatever terms are used. In opposition to Achenval, Kant firmly insisted that every state contains three authorities, unquote, in three persons, a political triad in Latin, namely the legislator, who is the, quote, executive authority, the legislator first, second, the, quote, executive authority in the person of the ruler, and then third, the judicial authority in the person of the judge, who is to award to each what is his own, unquote. Kant describes the three authorities as both, quote, coordinate with one another as so many moral persons, unquote, but also as, quote, subordinate to one another, so that one of them, in assisting another, cannot also usurp its function, unquote. In other words, he describes them as separate but equal. The cooperation of the three authorities is necessary, quote, for each subject to be apportioned his rights, unquote. In other words, in order to secure the rights specified by Kant as various innate forms of freedom or right, including the right to acquire property under conditions that preserve the equal freedom of others. In order to secure the rights of all subjects, Kant says, there needs to be proper legislation of rights, adjudication of disputes over rights in accordance with that legislation, and enforcement of such adjudications. But those authorities must be kept distinct. I mean, that is to say, distributed among distinct persons for the reasons given by Montesquieu. Kant also insists, however, that the united people itself, unquote, is, quote, superior over all, unquote. So it has ultimate sovereignty. That's the sovereignty of the people in Tuck's sense. And that the legislative, and he also insists that the legislative authority can belong only to the united will of the people. So therefore, the person, and he therefore infers that the, quote, person of the legislator is or possesses the sovereign authority among the three branches or within the government. And continuing on that line of thought, he says that the executive or ruler, for which he uses a lot of different terms, particularly perhaps to flatter the Prussian monarchs, is only the agent of the sovereign legislature, charged with enforcing its laws, but only as its agent. He doesn't say very much about the judiciary at all, apologies to the lawyers, except to say that it should be separate from the executive authority because it would be, quote, beneath the dignity of the head of state to play the judge, unquote, because in that case he would, quote, put himself in a position where he could do wrong and so have his decision appealed, unquote. So, in spite of the rhetoric of three equally coordinate and subordinate branches of government, Kant in fact seems to make the legislature de jure sovereign within the government in order to represent the ultimate sovereignty of the people. But Kant then argues that the executive must have a monopoly on the use of coercion and therefore the sole power to punish, because otherwise there will be chaos or anarchy in a polity with everyone playing judge in his own cause. And therefore, he says the legislature has the right to, quote, take the ruler's authority away from him, depose him, or reform his administration, but does not have the right to punish him for misdeeds or misrule. Kant gives no details on how any of the former are to be done. After all, he's stating very general principles. He's not writing a constitution. But by giving the executive complete control over the use of coercion with no constraints, such as, for example, the legislative power of the purse or of or the legislative right to declare war, Kant in fact gives the executive de facto sovereignty. There's no power that can constrain his use of coercion, even if he departs from the law. The legislature can say they're taking away his power or deposing him, but the legislature has no means to make that effective if the executive is willing to use the coercive power over which it has sole control against the legislature. And I might add here, perhaps, that Kant actually is reflecting the traditional definition of sovereignty as answering to no power but except for morality itself in his 1784 essay on the idea of universal history, when he says that the only solution to the fact that all human beings, including rulers, are made out of crooked timber is that rulers must have great experience, a sound understanding of the law, and good will, i.e. morality. That's the only thing that can constrain them, because they're not constrained by anyone else. So, to go back to the text, Kant first contradicts himself, I would say, by giving de jure equality to the three branches, but at the same time giving de jure sovereignty to the legislature. But then he resolves the contradiction by giving de facto sovereignty to the executive. That might allow for coherent application of the concept of sovereignty in the end, but that might not be a happy resolution of the contradiction. Now, Madison uses the language of checks and balances, thus the rhetoric of three separate and co-equal branches of government, throughout his contributions to the Federalist, his speeches in the Constitutional Convention, and other materials such as correspondence with, for example, Washington and Jefferson. Madison praises the division of power not just among the legislature, executive, and judiciary as a protection against tyranny by self-interested minorities. He also praises the division of sovereignty between federal and state governments as another safeguard of liberty. So he seems to advocate genuinely divided sovereignty within the government, which might be to say no sovereignty at all in the traditional sense, except perhaps the mythical, if you want, sovereignty of the people as a whole, represented through highly divided government at both federal and state levels. However, the actual design of the Constitution clearly awards sovereignty in the traditional sense to the legislature, although it makes the exercise of that sovereignty in the last instance very difficult. I have in mind more than the stylistic feature that the nature and function of the legislature is described in Article 1 of the Constitution, which suggests it's the most important branch of government, and that of the executive only in Article 2, and the judiciary almost as an afterthought, certainly not as a contender for a last say, in Article 3. What I have in mind is rather the very specific powers accorded to the legislature by the Constitution, which are all powers that give Congress the last word. So first of all, only the legislature has the power of the purse in the form of both the power to levy taxes and the power to expend money. And if I'm not mistaken, the Constitution doesn't even suggest that the executive should submit a budget for the approval of Congress. Only the legislature has the power to raise and maintain an army, which should follow from the first thing I mentioned. And also, only the legislature, once upon a time, had the power to declare war, grant letters of marque, and so on, and thereby to put the army and navy, which it has raised and it has paid for, to work, even though, as I assume was originally intended, in time of war, the executive will be the commander-in-chief. That is the chief executive in the execution of war aims that, however, must come from the legislature. So the legislature has the final say on the raising of arms and their permissible use, although not on the actual execution of war aims. And likewise, Congress has the final say on the promotion of general officers. Third, the legislature, in this case through the Senate, has veto power over the appointment of ambassadors, other public ministers and councils, judges of the Supreme Court, and eventually other federal courts, and all other officers of the United States whose appointments are not otherwise provided for in the Constitution. So, except for the special case of recess appointments, the legislature retains final say on these appointments. Now, In the original design of the Constitution, and it's certainly in many of the Federalist Papers, the intention was that all of these powers were to be exercised by simple majority. And I take it that Madison would be rolling over in his grave, and would have been so now for some decades, because of the way in which the Senate imposed a supermajoritarian rule on itself, and has so often paralyzed the nation. The Constitution did require supermajorities for further legislative powers, all of which are still, however, powers in which the legislature has the final word, namely the senatorial power to approve treaties, which of course requires a 2/3 majority, the congressional power to override executive vetoes, which again requires 2/3 majority in both houses, but is still a clear instance of Congress having the last say. The strictly congressional power to propose amendments to the Constitution, of course, requiring 2/3 majorities in both houses, and further expression of popular sovereignty by the approval of 3/4 of the states, whether expressed through their legislatures or through conventions that would presumably be even more direct expressions of popular sovereignty. And finally, of course, last but not least, the legislature has the last word in the unappealable form of the power to impeach and remove from office officers of the other two branches. Although again, a 2/3 supermajority in the Senate is required to convict. So in all these cases, the legislature has the last word, and thus has in principle sovereignty on the traditional definition of sovereignty. Now, of course, we have recently and repeatedly been reminded how difficult it is for Congress to successfully exercise the last of those powers. More generally, we all know that there's been a tremendous flow of power from legislature to executive, perhaps beginning with the Civil War, but certainly flowering in World War II and the Cold War, and that there has been a flow of power to the Supreme Court in the form of the power of judicial review, appropriated by the court for itself as early as 1813. Nevertheless, the original design of the Constitution was one that could be, at least from the philosopher's bird's eye point of view, accurately described as intending to maintain in numerous important ways the final say and therefore the sovereignty of the legislature. Perhaps we ought to remind ourselves of that daily, along with brushing our teeth. Given the excessive power of small population states in the Senate, of course, the result of the compromise between the federal government and the existing states that constituted the original Constitution, a rebalancing in favor of the sovereign power of the legislature might not be the answer to all our woes, but would be what was originally intended for those originalists out there. So thank you very much for your attention.
Thank you, Professor Geyer, for those really interesting remarks. And I think we turn next to Chuck Katubi for his perspective.
I think I'm muted. All right, I'm unmuted. Can you hear me okay?
Yes, we can hear you.
Excellent. All right. So I'm very pleased to be here back at my alma mater of Pitt Law to discuss this very interesting question that's being raised in this symposium, and that's the interaction between sovereign states and private parties in global dispute resolution. This is a favorite topic of mine, mainly because I've dedicated most of my legal career to suing sovereigns for violations of international law. I've filed claims and won cases against states from Latin America to Central Asia, usually under bilateral and multilateral investment treaties. And I'm almost always on the claimant side. So one would think that my contribution to this discussion would be markedly anti-sovereign. And in some ways it will be. And in fact, that's where I'm going to start with the hopefully non-controversial proposition, pulling this to an international level. The non-controversial proposition that a key function of international law, if we're talking about checks and balances here, the key function of international law, and perhaps the primary function today, is as a guardrail in the narrow corridor of liberty, restricting and regulating the world's sovereigns vis-a-vis private parties. This captures not only state obligations under commercial agreements, but also the broader obligation of the state to provide due process and fundamental justice to persons within their borders. Now, this much should be non-controversial, But the bigger question here for all of us as scholars, as practitioners, as lawyers is how can international law accomplish this and thereby provide real normative guidance on what the law requires of the world's sovereigns? I mean, this is a philosophical question for sure. It's much less tethered to the hard law that our presentations yesterday discussed. But it's also a timely and practical question too, based on where we are right now as a global polity. Here, and perhaps a bit controversially, I'm going to take the side of the sovereign a bit and say, based on my experience, we cannot rely on international institutions, on international courts and arbitral tribunals to adequately define the contours of the international limits on sovereignty. These bodies might be good at imposing liability and having the temerity to do so, but they are not as good as explaining where that liability comes from and setting future normative limits. For this, I think we have to look within the states themselves. And perhaps the best resort for this is the domestic courts. And that's what I'm going to talk about today. So my support for this conclusion comes from three observations that I see as indisputable from my practice. It's what we've all learned from the past 30 or so years of international dispute resolution between states and private persons. The first observation is this. This is a sad reality, but it's true. But left to their own devices, states will always prefer to remain unshackled, immune, and unaccountable. And their concessions to the contrary are relatively easy to retract. This is the sad reality of our global polity, that less than half of our fellow travelers live under a sovereign that provides a reliable rule of law. And yet each one of those sovereigns sees fit to declare floored constitutional and legislative commitments to the contrary. Perhaps the only meaningful consensus we can claim today is what Professor Jan Paulsen once called the fraudulent consensus of each sovereign's self-description that we live in a glorious world governed by the rule of law. And at the same time, sovereign accountability to the governed is a hard-won bargain that is becoming less popular as time goes by. In thousands of treaties over the last 50 years, states have agreed to the relatively benign promises like not to expropriate property, to provide fair and equitable treatment to foreign investors. And Professor Gaillard talked about a minute ago that states were the ultimate deciders. Thankfully, we've moved beyond the state, the sovereign, as the ultimate deciders because they've given away some of their sovereignty in treaties like this. And these states really have nothing to fear from private claims if they simply to aspire to provide the bare minimum of good governance and due process to people within their jurisdiction. But after 2 decades or so of exposure to their shortcomings by adverse arbitral awards, developing and developed states alike are withdrawing these promises of accountability at an alarming rate and are otherwise challenging the legitimacy of a system, of an international legal system that dares to hold them liable. This is similar to the actions that were rightly bemoaned yesterday by Professor Weisberg, with the US executive branch asking our own courts to minimize the effect of international law. It's a sign of the times across the board. The wolves are in charge of the henhouse, with sovereigns uniformly seeking to minimize state liability out of fear of their own accountability in every circumstance they can find. I'm an advisor to the US delegation on multilateral efforts at investor state dispute settlement reform. And I can report that those discussions are a primal scream of how dare you from the states around the world aimed at private parties that are armed with international law. And this brings me to my second observation. If meaningful limitations on state conduct are going to advance, it has to come from sustained effort by private parties to vindicate their rights vis-a-vis the sovereign. Self-limiting treaties are not enough. The bare promise of fair and equitable treatment in investment treaties hardly provides a solid foundation on which to base normative guidance. And the promise of life, liberty, and the security of person in human rights treaties don't fare much better. Let's look at an example. Let's look at the US-Germany Treaty of Friendship and Commerce of 1925. In it, Germany guaranteed the most constant protection and security for persons and property, and that degree of protection that is required by international law, such that property cannot be taken without due process of law and without just compensation. Now, this harkens back to what we all talked about yesterday of the Holocaust claims. But without this treaty having a mechanism to enforce or articulate the scope of these promises before a competent court or tribunal, are we surprised at how poorly they provided normative guardrails restricting sovereign action? And nor will strictly interstate affairs lead to an adequate development of normative solutions. Let's be honest, customary international law rarely answers the types of questions of what states owe to the governed, because the primary aim there is to regulate interstate commerce. And if we wait on the ICJ to tell us what international due process means, we're going to be waiting a very long time. Like self-imposed limitations and paper declarations, checks and balances parachuted from above have proven relatively impotent in promoting sovereign restraint. So really liberty, it needs the state and its laws, but it needs individuals armed with procedural rights vis-a-vis the state to shape, enforce, and expand these narrow corridors of liberty. So my third observation, the permanence of these developing norms will depend on their grounding in positive law and the quality of their explication. Important questions like what is adequate notice of proceedings under international law? When a litigant can be deemed to have had a meaningful opportunity to be heard? When is a judge truly unbiased and independent? These are the grifts of most investment treaty claims. But international law can hardly depend on a system of justice that is wedded to the confidentiality of its awards or the lack of precedent to answer these normative questions. What's more, the awards from ISDS, the investor state awards that do see daylight, are often beset by an absence of satisfactory legal reasoning. In my experience, after a decade and a half of practice, the average ICSID award will include hundreds of pages of recitation of the party's positions, followed by 1 or 2 paragraphs of legal conclusions with no substance in between. These normative guardrails between the state and the individual can hardly be shaped by a system of justice that fails so completely in this task. Not so really with domestic courts. If we look at Lord Bingham's famous Freshfields lecture in 1988, he brought out what are the core functions of a judiciary. They're not just to decide cases, but to explain why each party won and lost. And this is a fundamental part of judicial judgment, the safeguard against arbitrariness as a guide to future conduct to enable the proper view of reversible errors. And for all the shortcomings of domestic courts and litigation, of which there are many, judges from the most developed nations of the world certainly take Marbury v. Madison's directive to emphatically say what the law is much more seriously than even the highest paid international arbitrators. So I would say that domestic courts have the opportunity to do this on the international level and should grasp the nettle much more often to do so. And it's not as uncommon as we would think. Domestic courts engage as global actors all the time. They do so when they're asked to recognize and enforce foreign judgments. Here, private litigants press a claim that a foreign sovereign judiciary did or did not act in accordance with international law. One court will sit in judgment of another court, applying and articulating the international standards before giving a stamp of credit and enforceability to another judgment. When these decisions are grounded in universal principles, they create a positive incentive. Municipal courts are on notice that they need to do better to earn foreign recognition of their own judicial acts by the community states around the world. Domestic courts also make international value judgments when deciding whether to apply and how to interpret foreign laws. Under most content-free and conventional methodologies for choice of law, the judge is supposed to point to a foreign law and say no more. But is this how courts actually behave? Most scholars say no. There's the safety valve of public policy. They can adjust the line between procedure and substance, and courts are not always oblivious to the outcome when they decide to apply a foreign law or when they interpret that foreign law and try to ensure harmony between that law and the international legal order. When this happens, judges become the surveyors and purveyors of principles of international law, and this is all for the better. And perhaps the last place that this happens is in the much rarer instance when domestic courts are allowed to adjudicate liability of foreign sovereigns themselves. There's a rich history of U.S. courts adjudicating U.S. liability under friendship, commerce, and navigation treaties, and most modern BITs allow litigants to bring their claims to a domestic court first. For reasons that Professor Curran and Weisberg said yesterday about Holocaust victims doubting the justice they'll get in Hungary, this avenue is rarely pursued at all for understandable reasons. But there's also these little nuances in domestic laws, like the U.S. expropriation exception, which allows international law expropriation claims, certain ones, to come within domestic courts' jurisdiction. As scholars and practitioners, we should all work to embrace and expand the international causes of action in domestic courts. It's all for the better of the international legal order. And what's so important about these scenarios that I talked about, these opportunities for domestic courts to get involved in international law, is that they harbor no retreat for offending states. States can't simply take their ball and go home once held to account by another sovereign. They are locked together in a community of states where accountability becomes the cost of membership. And with this realization comes really my thesis and my contribution to this discussion, is that I tend to think that acts of the sovereign are essential to restrict the sovereign, and judicial acts of domestic courts are maybe the most promising engines to generate international norms. Now, I'm going to conclude here with a brief caveat. The idea that domestic courts can save us from the Leviathan cannot be overstated. Domestic courts are no panacea for complex global disputes, even in the dozen or so national enclaves of justice that competently dispense impartial justice. And international arbitration has rightly become a virtual monopoly for international cases. The offshoring of disputes away from sovereigns has facilitated global discourse, perhaps more than any other innovation over the past century. And the particular decision to place investment arbitration within the paradigm of arbitration and not an international or domestic court is what gives the regime its temerity to adjudicate state responsibility. This ground lost by the world's sovereigns is itself a shackle on their authority, and the ground gained within this narrow corridor should not be ceded back to municipal courts. At its core, international arbitration is a concept of liberty and self-governance. But without functioning judiciaries, arbitration will collapse. Arbitration agreements won't be enforced, awards won't be enforced, and the benefits of arbitration will be an illusion. And here's why I'll add one more thing, and perhaps more to the point. Without an armory of international legal standards to apply, we are leaving this corridor of liberty to be policed by opaque treaty standards, inapposite custom, and the reluctant efforts of international arbitrators to really place international norms on paper. We would all be better served to encourage domestic courts to grapple with international law whenever they have the opportunity and create positive international law whenever they can. This comes from my experience that I think this is all for the better of the order moving forward. And this is the way we get checks on the sovereign in favor of the individual that are more likely to stick.
Thank you, Professor Kutubi, for those really enlightening remarks and from your for that unique perspective. And turning now to Professor Brandt.
Thank you, Heider. I am going to do two things here that haven't been done. I'm going to use a PowerPoint slide. And the second thing is I'm going to change the title from that in the program. In the program, I'm listed as the role of sovereignty in international law. I'm going to deal with that, but I'm going to call this the vulnerable sovereign. The term sovereignty has confounded philosophers, lawyers, and scholars over time. The connection between sovereignty and law is a fundamental one, both in the domestic level, internal sovereignty, and the international level, external sovereignty. My premise for this presentation is that as the dominant forms of government have evolved over time, so has the way in which we must think about sovereignty. I propose to track the evolution of the concept of sovereignty through the historical development of governing systems, including international law, and to offer some thoughts about what that evolutionary process means as we think of sovereignty today. From a legal perspective, a term that was born to represent the relationship between the governor and the governed has, in international law, become a term that is used to represent the relationship between and among states in the global legal order. Yet its roots in the relationship between the governor and the governed remain fundamental. Some have suggested that it would be best if we simply get rid of the term sovereignty altogether. Early concepts of sovereignty were a very Western development, focusing on a singular human society as a Universitas Christiana or a Res Publica Christiana, finding its oneness in the pervasive unity of God. Professor Geyer has indicated that origin in the early works, in Bodin, for example. This was an all-pervasive sovereign, not a territorial sovereign. The Christian, Roman Catholic faith found representation of the sovereignty of God in the person of the Pope. Thus, according to de Maistre, making infallibility in the spiritual order and sovereignty in the temporal order two perfectly synonymous words. With the Reformation, the singularity of the Universitas Christiana gave way to the concept of co-equal sovereigns in the form of states. For international law purposes, this process began with the 1555 Peace of Augsburg and became more formalized with the 1648 Peace of Westphalia. Concepts of Westphalian sovereignty were based on two principles: territoriality and the exclusion of external actors from domestic authority structures. The sovereignty of the king became absolute, and this sovereignty became equated with the sovereignty of the state. As the concept was applied to the ability to rule over defined territory, it had to account for multiple sovereigns. Concepts of sovereignty came to focus on the king as holding territorially supreme power, unlimited by any other earthly authority. The rise of democratic republics, beginning in the late 18th century, brought with it further evolution of the concept of sovereignty, with the accompanying rise of the importance of the sovereign state. The idea of sovereign power over territory resting within the state has at least three important consequences. First, the concept of sovereignty emanating from the Westphalian order presents each state as having co-equal authority with every other state. The second concept is a result of the first. A state will not be bound by a rule unless it consents to that rule. Third, and perhaps more important for contemporary purposes, when the state is represented not by a king, but by democratic institutions and popularly elected leaders, the line between the governor, formerly the king, and the governed is blurred. If pure democracy were possible, then the governed would be the governor. But it is a spectrum of representative democracy that has thrived. The rise of representative democracies brought with it the evolutionary development of limitations on the governor in relation to the governed. These limitations came both internally and externally. Internally, limitations are best exemplified in the form of written constitutions, with the delineation of rights granted to or retained by individuals, often, as in the US Bill of Rights, in the form of limitations on state power. Externally, and fitting with our topic of the panel, those limitations have developed in the rules of international law. Some have described international law as a new sort of social contract, adding a second layer of relationships on top of the relationship of the citizen to the state. This tends to place the focus on relationships between and among states and emphasizes the rules that govern the actions of one state towards other states. That analogy, I believe, is problematic, however, because there is no truly international sovereign to enforce the rules governing these relationships, making it a social contract very unlike the one in which a sovereign, in contract with its citizens, can create and enforce rules governing its citizens. Still, that development of international law has affected rules regarding relationships among states, and those rules necessarily assume limitations on individual states. Thus, it is useful to consider both limitations on states in their relationships with other states and limitations on states in their relationships with individuals. When considering international law developments that limit states in their relationships with other states, it is important to note that these developments also affect the relationship of the state with individuals as well. These include relationships with a state's own citizens as well as with citizens of other states. A classic element of sovereignty in 19th century concepts of international law was the right of a state to settle disputes with other states by going to war, the liberté de guerre. Post-World War II development of the United Nations Charter included Article 2.4, which codified the rejection of this right through a prohibition on the use of force against other states. Democratic forms of government, even in a representative form, require new developments in our understanding of sovereignty in international relations and international law. The governor, who is the sovereign, takes a very different form than does the absolute monarch. Citizens must at the same time be seen as the governed as well as the makers of the government. The 20th century also experienced the evolution of organizations of states such as the European Union, which have evolved from having a primary purpose of economic cooperation to becoming more in the nature of federal states themselves in many ways. They clearly changed the relationships between and among states and the corresponding ways in which we use the term sovereignty. Consistent with Article 2.4 of the United Nations Charter, states have established more peaceful mechanisms for dispute resolution. As Chuck Katubi has indicated, the process of settlement of disputes between private parties and states has advanced itself. The International Court of Justice, the World Trade Organization, and other institutions have resulted in successful legal mechanisms for the resolution of disputes between states and for the process of investor-state dispute settlement, and in particular through the International Center for the Settlement of Investment Disputes, demonstrate international organizations set up specifically to provide peaceful settlement of disputes arising directly between states and individuals. On the human rights front, the European Court of Human Rights plays a similar role. A second evolution has come not in the institutions that administer international law, but in the rules applied when a dispute arises between persons and states that are subject to international law. Just as the 20th century saw a new recognition of fora for disputes between individuals and states, it also witnessed the development of the direct application of international law to relationships between individuals and states. Persons and states entering into commercial relationships may have their relationships governed by rules of public international law. Private parties may use the negotiation process to enter agreements with stabilization clauses that limit the ability of states to exercise lawmaking powers to change the nature of the contractual relationship, even within that state's own territory. The dissipation of the absolute theory of sovereign immunity discussed yesterday that occurred throughout the 20th century means that states have become increasingly subject to the application of municipal law in municipal courts. Not only may states waive contractually their immunity from suit in national courts, but their involvement in commercial activities sheds the cloak of immunity otherwise available in relationships with individuals. And as we discussed in yesterday's program, And in our keynote address, in the United States, certain violations of international law may subject states to claims in domestic courts. When foreign states are parties in national courts or arbitration proceedings, if they have engaged in conduct common to private persons, they too may be subjected not only to the courts of another state, but to the laws of another state. Hobbes considered it a right of the sovereign to punish a subject who refuses to obey the king. The subject could refuse to obey when the right of self-preservation outweighed the obligation to keep the covenant with the king. At the same time, however, the sovereign retained the right to punish the subject for refusal. States today are limited by international law in their treatment, even of their own citizens, through important human rights treaties and customary norms. The 20th century witnessed the return to a significant role of the merchant in determining the rules applicable to commercial conduct, a new type of law merchant or lex mercatoria. National codes that originally replaced merchant determination of customary rules are now accompanied by rules established directly by merchant groups, and ultimately by the movement to treaties through which the rules once again become truly international in nature and context. All of these developments indicate the increasing need to apply rules of international legal order to relationships between states and private parties. Changes in international law, particularly in the application to relationships between states and individuals, require that we take great care in the manner in which we use the term sovereignty. We must recognize that a term now commonly used to describe relationships between and among states originated as a concept describing the relationship between the individual and the state. Developments in the law governing relationships between states and private parties have brought private parties into the realm of international law and states under the authority of national legal systems. The development of binding international protections for individuals, even against their own states and against those representing states, makes outdated notions of sovereignty difficult to apply. Limitations on the governor as sovereign require that we continuously reconsider whether the term sovereignty provides a useful function in modern legal relationships. For this reason, I propose a different focus in the analysis of sovereign relationships. This change in focus requires that we view sovereignty not as a quality to be exercised. We do view it as a quality to be exercised and not as a quantity of authority to be used to rule over others. This requires that we view the sovereign relationship between the governor and the governed as a mutual relationship, not as a power hierarchy. Once we focus on mutuality of relationship rather than hierarchy of authority, we then must consider the sovereign relationship in the way we consider other human relationships. Human relationships thrive when each party in the relationship opens themselves to the other. This requires that risks be taken in relationships. It is precisely those risks that make relationships worthwhile, valuable, and strong. In human experiences, it is when those on each side of the relationship have the ability to raise up or bring down those on the other side of the relationship that the relationship has real value to each party in that relationship. Each party's acceptance of the other party's ability to affect them in this way, that is, the acceptance of risk, is precisely what provides the ability to be built up in the relationship by the other, that is, the reward. Both internally and externally, it is really not necessary for either the governor or the governed to agree with a focus on mutuality of relationship, regardless of whether states consent to be guided by shared rules or treaties or standards of justice. All their citizens' fates are interconnected and governed by the basic laws of cause and effect. The spread of COVID, rising tides of refugee migration, and the ongoing intensification of climate change are clear examples of this. For too long, we have considered states to be strong when they can exercise power over citizens and over other states. But power in an individual or even a political party does not ensure peace and security for those whom the individual or party governs. We have only to think of the sovereign police power and how it has been abused in current times to demonstrate this fact. It is the provision of peace and security that is the hallmark of sovereignty properly considered. Nor does power necessarily translate to strength in 21st century global relationships. Article 38 of the ICJ statute places conventional law, that is treaties, at the top of the international law source hierarchy for a reason. Treaties provide the clearest form of consent by a state to rules to be applied in its relationships with other states. But treaties are built on reciprocity. They are built on trade-offs designed to obtain a greater good. Some would say that treaties are built on giving up sovereignty because they limit the exercise of power and authority of the state entering into the treaty. But that is a mistake. If a treaty, by limiting each of the states party to the treaty, makes those governed in each state more likely to experience peace and security, then entering into the treaty is not giving up sovereignty. It is rather a proper exercise of sovereignty. Do treaties require risk? Yes. Do they allow one party to the treaty to breach a treaty commitment and thus cause harm to the other party or to individual persons? Yes. Does that make treaties a bad move by a sovereign government? No. Humankind may never find a perfect form of government or reach complete peace and security for every human being. The cruel irony of human existence is that if we would ever reach what could be conceived of as perfect peace and security, the value of an existence built on improving the world would be lost. Without the ability to reach higher goals, we could only either atrophy or move backwards. As the concept of sovereignty has evolved from a Universitas Christiana to sovereign kings, to representative democratic institutions in the form of states, to governors who are limited in both relationships with other sovereigns and with individuals, a new focus is required. We need to ask, can it be that the vulnerable sovereign can in fact bring us closer to true peace and security in a globalized world? Thank you.
Thank you, Professor Brand. Really appreciate those remarks. And I think we're turning to Professor Lobel for 10 minutes of comments.
Thank you. And this has been 3 very interesting presentations. I want to thank Professor Brand for inviting me to comment on this. I think it's particularly important that we're celebrating the 25th anniversary of CIVS, which has provided so much useful intellectual discourse and interchange with foreign law students panels like this throughout its history, and it's enriched the law school so much. I also want to say one word about Professor Seeberger. I was originally hired to teach international law at Pitt. I moved into constitutional law after a while, and I taught next to Richard Seeberger, and it was always a model to keep a high standard of teaching. And I was grateful for your remembering of Professor Seeberger, because he was a great professor. I want to say that I have sort of a unique experience here to bring to this panel, because I both am an academic who taught international law for 20 years or so. And I've been a litigator, both representing states in domestic courts, in US courts in particular, in challenging lawsuits brought by litigators like Mr. Katubi. And I've also represented human rights activists in American courts challenging the action of states. So I have both perspectives. I want to say one thing that I felt about all 3 presentations. And it was a question that to me was the elephant in the room. And that is, what is the relationship between law and sovereignty? Because as we define sovereignty, and as Professor Geyer defined it, sovereignty is the action, the final decision of an entity, the entity that has the power to make a final decision, unconstrained by anything else. And law is the attempt to constrain sovereign decisions. And so to what extent is there a tension, general tension between law and sovereignty, and how do we try to resolve that tension? And I think that underlies the entire discussion of sovereignty, and I think it underlay a lot of the comments that the three of you made today. That was my first point. The second is that I agree with Charles Katubi that domestic courts can play an enormous role in the development of international law. And here I've had the experience both as a human rights activist, trying to punish both foreign actors and constrain US actors through international law and domestic courts with some success. And I've also had the experience of representing different governments in US courts, particularly governments that have problems with the United States, for example, Cuba. And in the Cuban case, the US courts have been quite intriguing in their relationship to international law. Probably the most important Supreme Court case on international law in maybe the last 50 years was the Sabatino case, in which the court said, you know, domestic courts shouldn't really be deciding the appropriateness or the legality of expropriation claims because domestic courts are biased. And the foreign countries are not going to look at the legitimacy of the law if decided by domestic courts. And so they abstained, using the act of state doctrine, from deciding the broad nationalization claims against Cuba. On the other hand, I'm now currently litigating a case representing Cuba, which raises the question of, can shareholders sue under international law for the expropriation of their companies in which they are either the sole shareholders or which are subsidiary companies? And here is an area where everybody agrees that the court could play an important role in developing international law in that area. And I also litigated a case in the US Supreme Court, which involved the question of, can a government be held liable for the expropriation taken by a independent government corporation, a separately incorporated government corporation, but which is controlled by the government? And that raises basic principles of corporate law. And the US Supreme Court held it could develop international law by looking at the corporate law of nations all around the world. So I do think that Charles Katubi is correct that international law can be in many areas developed by domestic courts. But I think the question is, to me, is what is the role of a domestic court coming from a particular background and particular national experience in developing law for the world? The third question I wanted to raise, and I think Professor Brand and Professor Goya raised this, is what's the role of sovereignty in change? And I was particularly struck by your quotation or your use of the declare war clause in the United States. That seems to reflect legislative sovereignty. But over 200 years, we've seen that as the United States has become transformed from a marginal power, a weak power in the world stage, to the dominant power in the world stage, that part of the Constitution and that grant of sovereignty in a way has been transformed. And so how does sovereignty change with changing times? And how does our notions of sovereignty, and that's what I think Professor Brand was really speaking to, and I thought it was very interesting, the idea that sovereignty is not a static concept, that it changes over time, and that it can change in different ways. And finally, I wanted to give a couple of examples of areas where courts and law run up against the sovereign and the different outcomes. I thought one very interesting thing about Professor Geyer's talk was that he said separation of powers says there are three different powers, but when he defined sovereignty, there was either the legislature or the executive. There was very little discussion in Madison or Kant of the judiciary. And so, particularly when we're talking about the rule of law, the question is, what role does the judiciary have in the notion of sovereignty? And here, another key area that I was involved in was the US case versus Nicaragua, or rather the Nicaragua case versus the United States in the World Court. Here was a case where the United States by treaty had agreed to the jurisdiction of the World Court. Nicaragua seized upon that, said, okay, let's have the World Court, not a domestic court, decide whether what you're doing with respect to the Contras is lawful. The World Court ruled, and the United States said, all you law professors can talk about sovereignty and the change of sovereignty all you want, but might makes right, and we are not going to comply with this. It doesn't matter that we signed the treaty. And who's going to make it? Us do it. In fact, as I'm sure Professor Brand remembers, the United Nations Security Council, which you might say is sovereign in the world of international law, having the most important power, ruled almost unanimously that the United States should comply with the ICJ judgment in the Nicaragua versus US case. The key word I used was almost. The one country that refused to agree was the United States. And of course, we had a veto power. So, that case really represents the question of, to what extent, as Professor Brand said, after World War II, the UN Charter said, law limits your sovereign power to go to war. To what extent is that meaningful in a world where a country like the United States or like Russia that has very strong power can violate the law without very much consequence? The last case I want to discuss is the Guantanamo cases, where here I was representing people claiming that international law restrained the power of the United States government. And by use of both international law as incorporated into domestic law, the US Supreme Court agreed, and the government basically complied with that. I mean, they didn't totally comply, but they basically complied. So I'm not sure what meaning and what lesson I would learn from that. Maybe the lesson gets back to the role of people as sovereign, that when public opinion really supports a particular point of view, international law and the courts can make an impact. And when the people don't, sovereignty seems to, in the nation state sovereignty seems to govern. But thank you for 3 excellent presentations that were very thoughtful and inspired some thoughts in me, and I hope my thoughts were helpful. Thank you.
Thanks very much, Jules. I really do appreciate that and appreciate the insightful comments. I am going to, we have 2 questions in the Q&A, but I think before we move to them, I just wanted to invite the panelists to see if they had any reactions or any sort of further discussion they wanted that was inspired by either the remarks of the other panelists or by Professor Lobel's very interesting commentary.
Well, if I can, I'll be very brief. I found those all the papers and those remarks extremely interesting. I think that the point that actual sovereignty is, if we're going to use the concept at all, is in fact in flux. I mean, it's changeable, is very important. And maybe the distinction I was cooking up between de jure and de facto sovereignty can be helpful in this regard. I mean, it's one thing what either a philosophical political theory or a constitution actually says, that de jure sovereignty. It's another thing what's actually happening, and the way in which, say, the war-making power over time flowed from Congress to the executive, which I alluded to, is a perfect example of that. The other thing that I found quite interesting in Professor Lobel's comments was his remark about the tension between law and sovereignty. And it seems to me that, the tradition that I know a little bit about, that is the natural law tradition from which Kant was coming, is very much aware of that tension and trying to work that out in terms of trying to work out the relationship between natural law and positive law. I mean, in Kant's case in particular, it's interesting that on the one hand, he wants to ascribe sovereignty to the people, through the people, sovereignty to the legislature. But that has to be tested against, or laws actually passed by a legislature are supposed to be tested against the rational ideal of a social contract, not an historical fact, as far as Kant is concerned. But the idea that legislation is just only if it could be consented to by people in a contractual situation, the idea that Rawls took up as well. And that's a way of trying to work out what the relationship between, so to speak, the ideal law and actual sovereignty ought to be. Anyway, those are just two thoughts suggested by your comments.
Thanks very much. Wonderful. And I'm going to keep the spotlight on you. Well, actually, let me just, Professors Brand or Katubi, did you have anything you wanted to add, or?
I just very briefly,
Sure.
on Professor Lobel's last remark, I thought it really hit the nail on the head here. It's, does might make right? And at the end of the day, it's a bit of a nihilistic view of why do we have international law anyway if the biggest states can simply ignore it? And in some way, us international law practitioners, us lawyers who have used international law to do something with it vis-a-vis a state, we're among the most patient lawyers in the world, right? Because unfortunately, we don't get a judgment that we can take to a federal marshal and it's done, it's fixed. The problem is solved. At some level, the Nicaragua case, and we go into the Medellin Vina issues, and then into the Guantanamo Bay issues, it just, us litigants armed with international law, our job is to shine a light on these things, right? And to use international law and these international standards to shine a light on these things, hoping eventually, after decades of work, that these sovereigns can be shamed into compliance. And it happens, and you've seen it happen through decades of work, Professor Lobel. And I think at the end of the day, that's the best we can do.
Let me just say,
yes. Go ahead, Jules.
Yeah, just one thing, very quick. I agree 110% with what Charles just said. That's exactly a critical function of international law and domestic courts and the work that we do and that you've done.
Yeah, and I think all of this ties into thinking of sovereignty as power, and we may think of which of the branches has more power, what state has more power in a kind of clash of sovereign relationships, or what is the hierarchy, I guess, between the state and individuals. And in the end, we get into a linguistic problem here a bit. We talk about law and what is the role between, what relationship between law and sovereignty, and it depends a bit on how you define each of them. And if we think of sovereignty as power, it seems to me that what we really need, and I think in the kind of litigation that both Chuck and Jules that you've done, they raise questions about power, but I think more importantly, they raise questions about authority. And it takes us back to the kind of classic statement that the politicians have made, that the US should lead not by the example of our power, but by the power of our example. And to me, the kind of litigation you are doing is the kind of litigation that tries to create a better example in our government, and to encourage the government to do that. And it's a reflection of once again, the obligation of the individual to challenge the government in a democratic society. And I think that's important. I do think that we see different ways of exercising power. The Russian interference in US elections. We think classically of military power, and Article 2.4 of the UN Charter doesn't take care of everything in terms of the way one government can influence what happens within another governmental system these days. And that's where I think we're really going to have to evolve in our understanding of sovereign relationships when modern media can so mix up where the message is coming from, internally, externally, and across hierarchies.
Well, thanks very much, Professor Brandon. That actually, the whole question of power and branches, it leads to the first question that was posed in the Q&A. And that was by Professor Bernadette Myler to Professor Geyer. It's thanks for a fascinating paper. I wanted to focus on the claim that the U.S. Constitution seems to want to make the legislature sovereign. She indicates she's not entirely sure that she's convinced by the claim because many of the framers were attempting to move beyond the inadequacies of the Articles of Confederation, which had set up a legislative body, but which didn't have an executive or judicial power, and the increasing distrust of some of the state legislatures that led up to the ratification of the Constitution that Gordon Wood has observed. And so she was wondering about the work that that particular claim is making in your paper, whether it's necessary. Are you ultimately arguing against Tuck, that the very rarely exercised sovereignty of the people he posits is not really sovereignty, and that therefore a representative sovereign within the government is necessary, whether legislative or executive, but that the representative sovereignty, that representative sovereignty within the state fails as well? And then I've got a separate question for Professor Kutubi, but maybe we'll tackle this one first.
Okay, well, that was kind of complicated question, but I'll try to answer it. I wasn't really worrying too much about the relationship between the sovereignty of the people and the sovereignty of the government. I mean, I alluded to that distinction because I didn't want anyone to think I was completely ignorant of it, but I was really trying to work out what the relations of the intended relation of sovereignty within the government is supposed to be, on the assumption that the government as a whole is supposed to be itself representing the sovereignty of the people. And it just struck me that there was this tension between the rhetoric of checks and balances on the one hand, and the very specific ways in which the legislature is granted the final say on a number of extremely important matters, which fits with the traditional definition of sovereignty. As far as the relation between the Constitution and the Articles of Confederation would go, I mean, I certainly would agree that one concern was that there needed to be a strong way in which to execute the laws of the that would be passed by the legislature. But I would have thought, although here I plead, potential ignorance, since I've spent most of my life wallowing in European thought rather than American thought, I would have thought that it was also a concern that the powers of the legislature under the Articles of Confederation were not adequately defined. So the real issue, or at least one important issue, was simply how much power is the federal government going to have vis-a-vis the states, And obviously the Constitution was giving the federal government, the proposed federal government, much more power than than what Washington had under the Articles of Confederation. And then there was, of course, the further issue about how is this increase of power or increased grant of power to the federal government going to be put into effect, and that would be by an adequately strong executive. Nevertheless, it still seems to me that the Constitution, as originally intended, gave the Congress the last word over the executive on many matters, where, to be sure, some of that power has subsequently flowed away or been let to flow away. So I hope that helps.
Perfect. No, thanks. And then I had one final question here, and that is, it's an anonymous attendee, and it's to Professor Kutubi. You had mentioned that I think I know the answer to this question, but I'm going to let you answer it. You've, in most cases, you've been on the investor side in arbitrations against the claimant. Have there been instances where you've been more comfortable defending the host state in investment treaty arbitration?
So that's a very loaded question for a practitioner. The real answer is, when I have clients, I represent my clients, and I never look to the other side and say, boy, I wish I was on the other side, because that's not what we're paid to do. So I've never been in that situation. But I do want to say two things that I think are really important, and I think Professor Lobel will agree with me here, is I do think I'm built with my worldview to represent claimants more. I like the idea of challenging sovereign authority rather than upholding sovereign authority. That being said, I think it's critically important for practitioners, and this goes for all young lawyers out there, students who are looking to enter this field. I think it's critically important to straddle both sides. I think lawyers who do only one side, and there are these lawyers in this space, there are these law firms in this space who only do one side, are missing out on a broader perspective of what this is all about, and they're not serving their clients when they only take that one perspective. And the place where I think respondents counsel or state counsel get in trouble whenever I see, ugh, that's not something I would do, is anytime they start to make arguments, and they do, start to make arguments that sound a lot like, I am sovereign, I can do what I want, and I'm a judge in my own cause. And that's something that should be a particular affront to any lawyer, to anyone seeking to uphold the rule of law. And that's a situation I've never been in, and frankly, I'd never want to be in. So I'll leave it right there.
Haider, I have one other comment.
Please.
Flowing from this discussion. Thinking about this discussion and Professor Gaia's response, I think could be I don't know if people have written on this, but the idea that there are two forms of sovereignty which are sometimes in tension and which fluctuate based on different circumstances, de jure and de facto, I think could be a very important idea in this whole discussion. And it made me think of a case that I did where I represented members of Congress challenging the first President Bush's going to war with Iraq to get Iraq out of Kuwait. And, their sovereignty as a maybe de jure, or even probably it's a de jure matter, flowed with the executive, who claimed he was commander-in-chief and could use the troops the way he wanted. The court, and this gets to Charles's point about the role of law and the role of litigators, the court found that the executive couldn't do that, didn't have the power to do that, but refused to enjoin him. And so now the question is, where does sovereignty lie? And Attorney General Richard Thornburgh said, we have all the power to do whatever we want. The court didn't enjoin us. And Congressman Dellum said on Nightline, well, the court said you'd be acting unconstitutionally if you did that. And eventually what happened was, within a few weeks, the popular pressure, which in part came from the court's decision on the president to come to Congress and get an authorization for war grew so strong that Bush was forced to do that. So there, the concept of sovereignty was tempered by a de facto reality of what was going on. And again, the court decision itself didn't have any power to it because the court said, you can't do this and I'm not going to enforce it. But in fact, it had significant public opinion and persuasive power. So I just end with that example. But I think that the jure de facto, I'm not a philosopher and I don't know if anybody has written on it, but it seems like a really interesting concept.
I thought I sort of invented it in this context.
Yeah, well.
And I don't know of course, I'm not a lawyer and I don't know the whole jurisprudential history of the commander-in-chief clause, but it did strike me just as a reader used to 18th century prose that in that the way that clause is written, they surely must have intended that, yeah, when Congress approves a war, then of course the executive is in charge of carrying it out. So for that purpose, in that context, he'll be called the commander-in-chief, but it was not this sort of blanket power where now people refer to the president as the commander-in-chief all the time, whether there's a war or not. Of course, there is a war all the time, so but never mind about that. As if that's an extension of the sovereignty of the executive that I think was not intended.
Right. Well, thanks very much. And on that, I apologize. There was one final question. I don't think we had a time to get to it, unfortunately. But I want to thank all of the panelists. It was a really distinguished panel and with a wide variety of different perspectives, and it certainly didn't disappoint. So thanks to all of you for your presentations and the commentary. And I will turn it over back to, I guess, to Professor Brand to sort of carry forward. So.
Yes, and we're going to take a 15-minute break. And we will reconvene at 3:45. I would ask the panelists for 3:45 to come in about 3:40. Everybody can just keep the link on with video and mute off, and we'll give everybody a chance to take a break and come back. Thank you to everyone on the panel.
So we are still gathering here. I'll wait another few seconds before we begin this part of the program, and then we shall go from there. Right, so it is 3:45 according to my clock, so let's begin. I want to say good afternoon to everybody, and I want to welcome you all to the second and last panel of the afternoon on the sovereign in literature. My name is Bernard Hibbets, and I'm a law professor here at the University of Pittsburgh and the resident legal historian at the law school, and I'm absolutely delighted to be part of this CILE 25th anniversary conference. It really is an honor to be here and to be with all of you in that capacity this afternoon. Per the usual format for this conference so far, we've got three panelists with us for this session, all exploring different facets of sovereignty as performed and conceived. And I want to start off by just saying a little bit about each of the panelists, and then of course we'll go to the papers. So first of all, in order of presentation, I guess, Bernadette Mailer is the Carla and Speth Professor of Law at Stanford Law School. She's a scholar of British and American constitutional law and of law and the humanities. Her research and teaching bring together the sometimes disparate fields of legal history and law and literature, and I'm so glad she's doing that. In 2019, she published Theaters of Pardoning with Cornell University Press, a book on changing conceptions of sovereignty in the plays and politics of 17th century England. And one of the great things about being a moderator in these panels is that you get to go back and read all the presenters' books. So I'm looking forward to this. So I will be getting into Bernadette's, I hope, very soon. Christopher Warren, our second presenter today, is an associate professor of English at Carnegie Mellon University right here in Pittsburgh. He's also got a courtesy appointment in history. His research spans digital humanities, law and literature, political theory, early modern literature, print culture, and the history of political thought. And his book, Literature and the Law of Nations, 1580 to 1680, was published by Oxford University Press in 2015. Michael Panazakos is an adjunct professor of legal writing at Cardozo Law School, where he's taught legal writing and lawyering skills for the past 25 years and has published on various aspects of law and literature. And our commentator this afternoon is Shana Trepedo, who is a lecturer in English at Yeshiva University. Her work explores the connections between literacy, cultural identity, and social engagement, and her current book project is entitled From Scripture to Print, the Hebrew Bible on the Early National Stage. So I just want to go over the ground rules for the convenience of everybody before we plunge in here. Each of our panelists will have 15 minutes for their presentations. The commentator will then follow for 10 minutes. I'll ask all of the presenters to be very conscious of your time, as it's hard to sort of pass notes in this virtual environment, although you may see me vigorously waving my arms at some point if that becomes necessary. We will use the remaining time before our hard stop at 5:15 for discussion in the group and or questions from attendees. So our first presenter this afternoon is going to be Bernie Mailer, who will talk to us about pardoning after Trump, transforming the theater of pardoning. So Bernie, it is all yours.
Thanks so much for your kind introduction, and thanks also for to the organizers for inviting me to this conference, which has been fascinating so far. This is a panel on literary approaches, and I'll be using a literary framework to talk about pardoning in the contemporary era, even though I would be actually discussing historical literary materials. So it's sort of extrapolating from earlier work I've done that is more historically based. Early modern European kings notoriously took the opportunity of executions to stage themselves and their sovereign power. Michel Foucault's description of how a failed French regicide was drawn and quartered before a vast crowd in the middle of the 18th century remains perhaps the most vivid account of this practice. Yet pardoning, as well as punishment, held the potential for staging sovereign power. As philosopher Immanuel Kant claimed at the end of the 18th century, the sovereign, quote, shows the splendor of his majesty, unquote, through exercising the power of clemency. Despite the centuries of opportunity, no prior political figure has deployed the theatrical potential of pardoning to aggrandize his sovereignty with as much fanfare and commitment as former President Donald Trump. From the selection of those pardoned, to the timing of his pardons, to the performance of the act itself, to the physical form of his pardon grants, Trump generated spectacle after spectacle designed to enhance his own image through his successive pardons. As a result, although Trump issued only 143 full pardons, fewer than Obama, and in accord with the trend of declining exercise of the presidential pardon power generally, his pardons garnered substantial media attention and spawned widespread criticism. Calls to limit the president's power to pardon, either constitutionally or through statute, pervaded Trump's tenure in office and persist in its aftermath. These calls furnish an opportunity for the Biden administration to transform the pardon process, and in doing so, render it less a relic of sovereign royal authority and more a liberal democratic institution. While the potential for pardons to overturn values of both liberalism and democracy became most evident through Trump's abuse of the power, fear of this possibility is as longstanding as the US Constitution. At the same time as explaining the ability of the pardon to show the splendor of the King's Majesty, Kant, whom also we heard about on the last panel, described it as, quote, of all the rights of a sovereign, the slipperiest one for him to exercise, unquote, because it can entail doing injustice in the highest degree. Closer to home, Thomas Jefferson attempted to excise pardoning from the Virginia Constitution, believing that pardoning would no longer be necessary in a fully enlightened criminal justice system. In order to revitalize pardoning after Trump, it will be crucial to render it visibly compatible with liberal democracy. Rather than a theatrical display of the ultimate authority over life and death, or imprisonment and freedom, it should instead become a participatory theater, permitting citizens to help rethink the foundations of criminal justice. So just to set the stage about Trump's theatrical pardons, President Trump transformed the federal pardon process from a fairly routine bureaucratic mechanism operated by the Office of the Pardon Attorney into a series of personally negotiated and theatrically performed acts. Under the system Trump had inherited from President Obama, with origins in the late 19th century, the Office of the Pardon Attorney, located in the Department of Justice, vetted potential presidential pardons and recommended which the president should grant. Trump instead circumvented that office and directly decided on pardons lobbied by friends, political allies, and prominent personalities. In doing so, Trump staged his pardons with attention to timing and context for maximum effect. Two such events occurred during the Republican National Convention, in which he was nominated for a second term. After auguring the pardon of John Ponder, saying, I have a feeling he's going to get that full pardon. I can't tell you, but I have a feeling. He pardoned the formerly incarcerated bank robber turned nonprofit leader in the midst of the convention and announced the pardon on video during that event. He then announced that he had decided to pardon Alice Johnson, whose sentence he had already commuted, upon seeing her in the audience of his speech accepting the nomination. Already after the commutation of her sentence, as the New York Times reported, the 64-year-old African-American woman was the star of the Trump campaign's multi-million-dollar Super Bowl ad, part of an effort by Mr. Trump and his son-in-law and senior advisor, Jared Kushner, to reach Black voters. Earlier, Trump had brought pardoned war criminals to the stage during a fundraiser. In the pardon spectacles that Trump produced, the hero was none other than himself. The written form of his pardon grants rendered the relative importance of the characters involved evident. Unlike any earlier pardons, they featured the name Donald J. Trump in bold lettering much larger than the pardon recipient's name, and included his magnified signature. Trump had faced criticism for the role of his individual signature on COVID-19 relief checks, but the prominence of him as individual and president appears even more starkly in these pardon documents. Trump's pardons were remarkable not merely for their showmanship, but also for the particular messages they were intended to convey. These messages served to bolster Trump's vision of populist leadership unconstrained by the rule of law. Whether they implicated him personally or involved those with whom he had no direct connection, these pardons upheld the legitimacy of behavior akin to Trump's own. One group of these pardons pertained to him personally. Throughout his tenure in office, Trump fueled widespread speculation about whether he would attempt to pardon himself, a move unprecedented in the history of the American presidency. Although Trump ultimately did not issue a public self-pardon, many of his other pardons nevertheless implicated his own susceptibility to the law. Pardons of his fans signaled that those allied with Trump would not face criminal consequences. Hence, he pardoned former New York City Police Commissioner Bernard Kerik, who often defended the president on Fox News. Pardons of associates and family members showed that those in Trump's inner circle would not be held accountable. The pace of these pardons accelerated as Trump neared the end of his tenure in office, and he pardoned or commuted the sentences of former campaign advisor Paul Manafort, early chief strategist Steve Bannon, and longtime ally Roger Stone. Another set of pardons involved political leaders who had been involved in corruption or those who had put power over and above the rule of law or constitutional and human rights. These pardons suggested the view that the underlying crimes were not crimes at all, a suggestion with implications for Trump's own behavior while in office. Condoning corruption, Trump ultimately commuted the sentence of former Illinois Governor Rod Blagojevich, who had attempted to sell the Senate seat left vacant by Obama when he became president, over the vociferous objections of many Illinois Republicans. Among his late-breaking acts of clemency, several more aided politicians who had been accused of corruption. Trump also pardoned those condemned for or accused of violating the constitutional or human rights of others, particularly people of color. His very first pardon, a former Maricopa County Sheriff Joe Arpaio, set that paradigm. Arpaio had insisted on state and local intervention in immigration enforcement, and in the process had infringed on the constitutionally protected rights of many members of the Latinx community through traffic stops and other interventions that impermissibly targeted people on the basis of their race. Trump, who had vocally supported Arpaio's anti-immigrant measures, expressed disdain for the constitutional constraints on immigration enforcement through this pardon. Similarly, by pardoning war criminals, Trump affirmed the use of force regardless of international human rights law or law of armed conflict constraints. Trump granted full pardons to 4 former Blackwater security personnel involved in a 2007 attack in Baghdad that killed civilians. In a decision that angered military leaders, Trump also pardoned 3 war criminals who had fought in Iraq, including a Navy SEAL whom colleagues characterized as freaking evil. In discussing these pardons, Trump announced that, quote, "I stood up for 3 great warriors against the deep state." So what is possible in terms of democratizing the theater of pardoning? The question of how to reclaim the legitimacy of the pardon power in a liberal democracy looms large in the wake of Trump's presidency. Some recent scholars have echoed the skepticism implicit in the writings of members of the founding generation like Thomas Jefferson toward the possibility of the compatibility of mercy with liberalism or democracy, and particularly with the two taken together. So in a way, they suggest that mercy is only a residue of sovereignty and not compatible with an account of liberalism or democracy. Aziz Haq has observed, quote, "a tension between the demands of democratic rule and merciful discretion, in addition to a tension between the demands of justice and the exercise of mercy." According to Haq's account, there are insufficient constitutionally based reasons to prioritize discretionary mercy over majoritarian will, which he takes as the core of democracy. While acknowledging that in European systems, autonomous bureaucracies may achieve the ends of mercy, Haq views recourse to these as, quote, "abandoning the full spectrum of democratic control mechanisms available on other occasions," unquote. Such views might lead to despair about the possibility or even desirability of redeeming the pardon power. Many have, however, considered how to restore the legitimacy of pardoning today. Proposals divide roughly into 3 major categories. The first insisting on the necessity of constitutional amendment of the pardon power, the second relying on the other branches, whether Congress or the courts, to limit the unchecked discretion of the president, and the third reviving old mechanisms or creating new ones within the executive branch itself to regularize the grant of pardons. Pursuing the constitutional amendment route, Keith Whittington has suggested the necessity of a bipartisan amendment restricting issuance of pardons by a lame duck president, self-pardons and pardons of family members, as well as pre-conviction pardons. Jack Goldsmith has instead pressed for congressional action, arguing that Congress should legislate to expressly make it a crime for a president to issue a pardon as part of a bribe or as an inducement to obstruct justice, and to declare presidential self-pardons unconstitutional. Others, including Neil Buchanan and Lawrence Friedman, have maintained that courts should retain the authority to limit the pardon power against certain significant varieties of presidential overreach. One problem with these proposals is that they only furnish restrictions on the outer limits of presidential pardons and on types of pardons that will hopefully be few and far between under the presidents who succeed Trump. Although earlier presidents had sometimes been accused of corruption in pardoning, as with President Clinton's 11th hour pardon of financier Mark Rich, the extremity of the change in the exercise of pardoning under Trump furnishes some assurance that his use of the power might be an anomaly. More problematic going forward than Trump's efforts to pardon family members or close associates is his use of the pardon not for the general good and for the polity as a whole, but to affirm his own power above the law, or his own, in a sense, sovereign power. It is this lack of democratic legitimacy at the core of the decision-making about pardoning that a reform proposal should address. Judicial reinterpretation of the pardon power or a constitutional amendment might partially remedy this problem by giving the amnesty power back to Congress. It was only during the late 19th century cases arising out of President Andrew Johnson's vigorous use of the pardon power to assist members of the former Confederacy and Congress's objections against it that the Supreme Court declared in United States against Klein that pardoning included amnesty. Earlier constitutional history suggests that that interpretation was not inevitable, and many European countries allocate the responsibility for pardons and amnesty in different actors, giving the amnesty power to a legislative body. Given the history, the Supreme Court could alter its interpretation of the president's power. Alternatively, a constitutional amendment might clearly separate the two functions. This would permit Congress to actively debate amnesties for certain categories of drug crimes or other mechanisms for remedying the problems of mass incarceration and allow for democratic input into the process. In addition, certain proposals to reform pardoning within the executive branch hold promise. Margaret Love has long advocated for reinvigorating the reliability of the administrative process of the Office of Pardon Attorney, including in the aftermath of Obama's presidency, when she lamented how closely Obama's clemency initiative had become tied to the agenda of federal prosecutors. Perhaps most recently, Rachel Barco has proposed to fix that problem by urging President Biden to move the clemency process outside the Department of Justice and to create a clemency advisory board with bipartisan, diverse membership, charge them with evaluating clemency petitions, and consider the board's recommendations regularly. Although this recommendation would regularize pardoning and render it more compatible with a liberal system, it might not solve the problem of its democratic basis, at least not for those unconvinced that an administrative process alone possesses sufficient democratic legitimacy. One mechanism that could be incorporated into the idea of the Clemency Advisory Board, and thereby integrate a more fully democratic element, might be a lay component along the lines of a pardon jury. Bringing ordinary citizens, and this was tried a bit by Jennifer Granholm in Michigan, bringing ordinary citizens into the process through a selection mechanism similar to that of a grand jury would involve individuals directly in the process of deliberation about the justice of granting pardons in particular cases, as well as assessment of the values served by the underlying legal regimes. While citizens are involved in the decision about whether to convict or acquit accused individuals, far too few are privy to the aftermath of the criminal process and evidence of the consequences of conviction, whether in the form of prison terms or the civil disabilities subsequently imposed. Integrating lay members into a clemency advisory board would further implement what Akhil Amar and others have argued was the framers' vision of juries as protective of democratic participation. The most troubling aspect of President Trump's theater of pardoning was not that it sent a variety of messages about the criminal justice system, but rather that the form and nature of those messages affirmed his own sovereign power above the law. A democratized theater of pardoning would involve the citizenry, as well as experts in evaluating the effects of the criminal justice system, and an exploration that would both do justice in the individual case and could motivate broader systemic reform. Thanks so much.
We can't hear you. You're on mute.
Oh, I just said thanks so much.
Thank you, Bernie. Thank you, Kim. Also, I appreciate that. I appreciate the presentation, Bernie, and then the fact that you were actually under time. So well done on all counts, but it was fascinating. We will go on now to our second presenter, Christopher Warren. And Christopher's paper this afternoon is engagingly titled Angels and Diplomats, Sovereignty, Dignity, and the Human. So Christopher, please take it away.
All right, thank you, Bernie, and thanks very much to all the organizers for what has turned out to be a fascinating conference. So what can angels and diplomats teach us about sovereignty and the intellectual history of human rights? So this may well seem like a strange question, and in many ways it is. But my contention is that angels and diplomats are important both for our descriptive and normative accounts of human rights. As a descriptive matter, I want to use today's talk to show first that the conceptual histories of early modern angels and diplomats are interlinked, and secondly, that their shared etymology tells a new and somewhat counterintuitive history of human rights, one that extends and in some cases revises previous work by thinkers like Jacques Derrida, Carl Schmitt, Samuel Moyn, and Jeremy Waldron. If, as Waldron argues, quote, the use of human dignity in constitutional and human rights law can be understood as the attribution of a high legal rank or status to every human being, angels and diplomats are key but neglected figures in what Waldron calls the upwards equalization of rank. Angels and diplomats, I'll show, are conjoined figures of abundance and plenitude. As such, they throw into relief minimalist conceptions of human rights that, in Samuel Moyn's words, have become a worldwide slogan in a time of downsized ambition, weak and cheap, and prisoners of the contemporary age of inequality. Angels and diplomats exemplify what I'd like to call a plurimatic paradigm of inviolable fullness, fullness of dignity, fullness of power, fullness of rights, even fullness of resources. This plurimatic paradigm, more so than the downsized version of human rights under attack from scholars like Moyn, imposes stronger correlative duties and liabilities onto sovereignty through the paradox of its sources in hierarchical, monotheistic political theology. Section 1, From Animals to Angels. For many thinkers of rights who think, begrudgingly or not, in Roman law's long secular shadow, the story of rights and the human cannot be told without reference to animal nature, a nature typically associated with creaturely needs of survival that subtend more refined and strictly human aspects of humanity. So scholars like Annabelle Brett, Martha Nussbaum, and Jacques Derrida have noted, animal essence is the ground upon which the rights of the human achieve figuration. The prominent story in which human rights become human rights through the exclusion of the animal is not wrong, but neither is it complete. Recall Hamlet. What a piece of work is man, how noble in reason, how infinite in faculties, in form and moving, how express and admirable, in action, how like an angel, in apprehension, how like a god, the beauty of the world, the paragon of animals. Adjacency on the great chain of being draws our attention to the animal, but human rights emerged from an early modern context in which the human had neighbors not on one, but on two sides. As John Milton put it, angels and men are far superior to other creatures. I would argue that it is this latter legacy, rather than the one more closely tied to animal bodies, to which we should turn to understand something like the enlarged rights guaranteed by the Vienna Convention on Diplomatic Relations of 1961. According to Articles 27 to 47 of VCDR, which formalized a long prior history of customary diplomatic rights, ambassadors enjoy rights to territory for diplomatic missions, to display a flag on the mission and residence, to free communication, whether through diplomatic couriers or messengers, in code or cipher, the rights to move freely throughout the destination country and through third states on diplomatic travel, and to equal treatment according to national origin. By the same treaty, diplomats are immunized against searches, property taxes, criminal jurisdiction, being compelled to give evidence, public service such as military service or billeting, social security provisions, and so on. Ambassadors' bodies, offices, residences, archives, documents, and correspondence all enjoy the fullest possible security through the claim that all of these are inviolable due to the dignity of his or her office. Dignity, understood here as holding the duties, attitudes, virtues, and bearings of beings with high rank or status, is of course a key term in human rights discourse, but what's often overlooked is that the term's hardly exclusive to humanity. Free will is part of man's dignity, Aquinas had averred, but the angel's dignity surpasses that of men. Angels' dignity corresponded with a unique set of powers, privileges, rights, claims, and immunities. To orient ourselves to this way of thinking, let's listen to the 17th century Jesuit theologian Robert Bellarmine, who wrote that God has so bound the human soul to the body as that without the one, the other cannot move. But God hath not tied the angels to any body, but hath given them power to pass from heaven and earth, from earth to heaven, whensoever they will, and that speedily. So that an angel, by the dignity of his nature, being nearest to God, by his subtlety, also after a sort, imitateth the omnipresence of God. Subjecting angels to a kind of Hofeldian analysis isn't something that comes naturally to folks in the secular 21st century academy, but angels are good to think with. In contrast with rights anchored in creaturely self-preservation, angels open new directions into potentialities and abundance, fullness and flourishing. In general, angels possess powers of movement, annunciation, ministering, and assisting. Immune to the passage of time or human decay, they had privileged access to knowledge and enjoyed rights to be received anywhere on earth. Now, from angels to diplomats. Angels' putative rights were intimately bound with the rights of human ambassadors, for whom traditional appellations like dignitaries and plenipotentiaries signal their own abundance of powers and privileges. As writers from Isidore of Seville to Thomas Hobbes observed, human ambassadors shared an etymology with their divine counterparts. Malak in Hebrew and Angelos in Greek each mean messenger, and also their elaborate internal hierarchy. Although Nazi jurist Carl Schmitt is known for pronouncing that all significant concepts of the modern theory of the state are secularized theological concepts, Schmitt garnered plaudits mostly for transmitting an early modern commonplace to a secular age. Anchoring the origins of human diplomacy in God's use of angels, for example, the 17th century writer James Howell reminded readers that there is no order of government in this lower world as well as ecclesiastical as secular, but it had the pattern of the higher. Howell observed that embassy in Greek is called angliae, as being derived by imitation from the hierarchy of the angels, who are made ambassadors for the great King of heaven upon extraordinary occasions. In Alberico Gentili's earlier 1585 work on ambassadors, considered to be the first systematic work in the law of nations, the author defined ambassadors broadly to include heavenly messengers sent on sacred missions. Now, I'm skipping several other quotations, but I'd just like to add that the link between angels and diplomats has not been lost in the 20th century. William Macomber's diplomatic handbook is entitled The Angel's Game. Early modern angelology was less explicitly a discourse of rights than early modern diplomacy, but the sacral inviolability of the diplomat was a key link. Genesis 19's story of angels traveling through Sodom and Gomorrah, and Lot's attempts to protect them from the citizens, was in part a story of angels' inviolability, their inherent rights against bodily coercion, and the duties owed to them by humans. Reciprocally, the human ambassador's own inviolability was consistently grounded in diplomacy's divine origins. A passage from the 2nd century historian Josephus, in which Herod assailed the Arabians for assaulting the Jews' ambassadors, became for early modern thinkers like Gentili and Grotius one of the main proof texts for diplomatic inviolability. Such declarations, reproduced time and again in early modern legal and diplomatic treatises, served two purposes. On the one hand, they protected vulnerable human bodies by anchoring their special rights in divinity. Grotius quoted this passage in his chapter on the rights of ambassadors. What can be a greater act of impiety than to murder ambassadors who are interceding only for what is just and reasonable? On the other hand, they justified retaliation in cases that those rights might be claimed to have been violated. Herod's oration was to demonstrate that this war is a just one on our side. Such was the case too of David's conquest of the Ammonites in 2 Samuel 10. David had sent ambassadors to comfort the Ammonites when their king had died. Accused of spying, the ambassadors were assaulted and expelled. What casus belli could be more just than the violation of the inviolable? Writers use the terms angels and ambassadors generically, for each of these was understood to cover multiple, more specific subranks. But the general terms set their bearers apart from ordinary humans. In part because angels and ambassadors were used so frequently to explain one another, early modern angelology and diplomatic theory were both shot through with a deep strain of hermeticism. Divine mysteries and mysteries of state were rhetorically enmeshed. The pleromatic paradigm included privileged access to knowledge and information. Meanwhile, the multilingual ground of diplomacy elevated diplomatic practice to the plane of the angels, whose communication with one another and with humans deployed the esoteric secrets of language. In the single most influential text in this tradition, Pseudo-Dionysius's The Celestial Hierarchy, the author explained the connection between what he called the celestial intelligences and human status. It is most fitting to the mysterious passages of Scripture that the sacred and hidden truth about the celestial intelligences be concealed through the inexpressible and the sacred, and be inaccessible to the hoi polloi. Not everyone is sacred, and as Scripture says, knowledge is not for everyone. Parceled, mediated knowledge was a key theme through which Christian angelology's graduated theater of thrones, princes, and dominions justified an ecclesiastical hierarchy of privileged spiritual messengers. Clement of Alexandria had written that the grades of the church of bishops, presbyters, deacons are imitations of the angelic glory. John Donne's poem to Mr. Tillman after he had taken orders illustrates the continuity into Protestant England. Thomas Hobbes's skepticism about both priestcraft and angels illustrates the same phenomenon in obverse. Less remarked than the way church hierarchy mirrored the presumed celestial hierarchy, however, was Christian diplomacy's own hierarchical distinctions among legates, nuncios, and plenipotentiaries. When the Congress of Vienna in 1815, seeking to systematize, therefore vexed rankings of these titles, divided diplomats into three ranked classes, commissioners were also translating Catholicism's earlier stratified model of seraphim, dominions, archangels, and so forth into worldly form. As this brief account suggests, the increasingly prevalent notion of a foreign ministry, such as the one in England that employed poets Milton, Marvell, and Fanshawe, and others, found fewer detractors than the notion of a church ministry. But as a descriptive matter, this helps to explain how the pleromatic paradigm retained enough support across confessional divides to survive into instruments like the Congress of Vienna and the Geneva Convention. For the normative questions I want to raise, it's enormously consequential what the Reformation didn't achieve. The Reformation's famously withering assault on prelacy left diplomacy's parallel hierarchy largely unscathed. To my mind, the questions we face in the present concern, in part, how comfortable we ought to be with surviving hierarchy and political theology. For while the pleromatic rights paradigm of angels and diplomats makes human rights look less full by comparison, it also relies heavily on rank and hierarchy. Angels and diplomats' obsessive preoccupation with rank was and is ultimately about the internal distribution of rights and privileges within a privileged class. In the 21st century, ambassadors enjoy immunity ratione personae, while those of lesser rank claim only immunity ratione materiae. In the case of those angelic beings who in the Neoplatonic tradition have a preeminent right to the title of angel or messenger, those angels higher up in the hierarchy, such as seraphim and cherubim, claimed greater rights to divine knowledge, proximity to God's warmth, and fuller intellectual powers. In the case of diplomacy, there are many analogous possible examples, but I'll just choose one, which is my favorite. Francois de Callier, early 18th century list of privileges of ambassadors included the right to remain covered before the king in public audiences because they represent their masters, the privilege of being borne in the king's coach, of driving their own coaches into the inner court of the Louvre. They still have their own days in the audience chamber, while their wives have a seat by the queen, and they are permitted to drape the driving set for their coaches with a special saddlecloth. Diplomats were just like us, only smarter, safer, comfier, and more tapped in. As we consider the consequences of angels and diplomats, it's important to note that diplomats did not enjoy any mythography as detailed as the king's two bodies. In matters of knowledge, eloquence, mutability, and mobility, angels and diplomats were more closely related to questions of political intelligence, media, and hermeneutics, more so than divine right absolutism. I would argue that it's possible to hear distant echoes of these concerns in the UDHR. But one of the big takeaways is that dignitarian claims to human rights need not settle for the thin versions currently on offer, though that version has most certainly developed in conversation with the pleromatic paradigm I've described. The pluralistic paradigm is also a problematic paradigm. In Jeremy Waldron's terms, the upward equalization of rank in current human rights law invites us to think of the change that comes when one views an assault on an ordinary man or woman, not just as a crude physical interference, but as a sort of sacrilege. But what if protection against assault is not enough? Honing in specifically on the bundles of customary powers and privileges enjoyed by angels and diplomats has the advantage of prompting us to imagine alternative rights regimes accompanied by alternative sovereign duties. Inviolable human rights tell us unequivocally that Black lives matter, that refugees' lives matter, but the additional aspects of knowledge, communication, and travel in my pluralistic paradigm indicate too why libraries matter, why access to education matters, why languages matter, why migration and travel visas matter. Under such a paradigm, the carceral state produced on the back of overzealous criminal jurisdiction becomes a signal outrage, as do the mountains of debt typically required for university diplomas, the diplomatic credentials of the modern age. Equalizing our rights upwards towards angels and diplomats points away from all kinds of hermetic knowledge and toward a politics of open access scholarship and open access vaccines. As I have suggested, early modern people found in angels and diplomats opportunities to theorize rights at the speculative horizons of creaturely life. In our present moment, we might think further about how this pluralistic paradigm of rights both informs and necessitates political action. If we ask why the connection to angels and diplomats have so long been overlooked, it seems reasonable to conclude that there's a very real aspect of embarrassment here. Embarrassment that dignity could be so closely tied to ontologically suspect creatures as angels, and that our thinking about human rights developed out of this bizarre hierarchical political theology. But once we confront our modern embarrassment head on, the important question going forward is whether we A, ought to finally continue the unfinished project of reformation by stripping away under-theorized rights and privileges grounded in outdated political theology, or B, level our human rights upwards to accord with the pluralistic dignity of angels and diplomats. Thanks very much.
Christopher, thank you. That was very interesting. I know that Shana will have lots to chew on afterwards with that, but we need to move on, of course, for the moment to Michael. So our third presenter is Michael Pantzakos, who will be speaking to us on Nietzsche's sovereign individual and the sin of Sodom, maybe picking up a little bit of a theme that Christopher mentioned, who knows. Michael, the floor is yours.
Thank you very much, Professor Hibbets, and thank you especially to Professors Brand and Weisberg for the gracious invitation to participate in this especially fine conference. After so many excellent contributions, I believe my own epilogue will probably prove but modest, at least it will be earnest. Nietzsche, in The Genealogy of Morals, posits sovereignty, that is personal sovereignty, as a process, describing the individual's effort in becoming and ultimately overcoming what one is. Nietzsche's sovereign individual is predicated on exercising the capability of making and abiding by promises, especially against fate. While sovereignty thus begins and never ends as an internalized means of radical autonomy, its externalizing aspect is the product of a necessarily self-guarded nobility, yet opening to all, as Nietzsche put it, a hospitable gate. Since the concept of the sovereign individual is neither simple nor without controversy or misconception regarding its proper role in Nietzsche's overall project of natural human ascent, I will first endeavor to offer a limited but close reading focusing upon the essential conditions necessary for the thrust of the mere idea to compass what he called a paradoxical task. And then I will later attempt to exemplify Nietzsche's idea in the person of Abraham, similarly with a limited but a close reading of the biblical text. A person, to separate the necessary from the accidental, to calculate in this way, must himself become, quote, calculable, regular, necessary, even in his own image of himself, if he's to be able to stand security, to gut sagen, vouch for his own future. This is precisely how responsibility originates in the long story, the lange Geschichte, of how one becomes answerable for what one is. The tremendous work of the morality of mores, Zita meaning mores, customs, comedy, mutual courtesy, civility, traditions, even common decency. The metaphorical fruit of the tree of morality of mores is the sovereign individual, souverain individuum, defined by, and I quote, an independent, protracted will and the right to make promises. It's important to note Nietzsche's expression, besprechen darf, to be allowed to promise, not können, can, but dürfen, may, a modal verb expressing not only permission rather than tyranny, but also politeness and subjunctively possibility, ideally even likelihood. Nietzsche subtly challenges patriarchal sovereignty here, inasmuch as the feminine Frucht necessitates by his own diction the Gallic, not Germanic, souverain, the empress, not the emperor, and then moves quickly beyond gender by positing the Latin neutral form of individuum, the indivisible entity. By way of a fruitful anticipation of part 2 of my talk, I can here note that Abraham, the father, is perhaps most shockingly flawed, lacking a beneficial sovereignty in exercising power over women. Indeed, 2 sovereign women, his wife Sarah, whose name means princess, and his wife's maid Hagar, who, at least in the Midrash, was Pharaoh's daughter and thus herself an actual princess, and later became Abraham's second wife. His failures with both wives are counted among the worst trials of his life, a few of which I will discuss below. The sovereign individual ultimately bears the privilege of responsibility, so deeply ingrained that it becomes instinct, but one with full awareness, in short, conscience. Nietzsche's use of the Latin privilegium adds more complexity than would have just a loan word or the German Vorrecht, meaning a prerogative. In Roman law, a privilegium was a special constitution by which the Roman emperor conferred on some single person some anomalous or irregular right, or some anomalous or irregular obligation, or even some anomalous or irregular punishment. The responsibility of making a promise, and indeed keeping your word, might simultaneously confer rights, obligations, and potentially punishment, but not through an external agent, an emperor, but rather by dint of your own self-sovereignty. The sovereign individual is answerable, but to himself. The culmination, however, of the sovereign individual is in the external power of an internal justice that, quote, ends as does every good thing on earth, by overcoming itself. This self-overcoming of justice, one knows the beautiful name it has given itself, mercy, gnade. It goes without saying that mercy remains the privilege of the most powerful man, or better, his beyond the law, jenseits des Recht. A terminus for humankind is here reached, less in the sense of an end achieved and more in a boundary met, a true terma, to use the ancient Greek, against which there is yet another beyond, an overcoming of humanity, where the sovereignty of self-power yields. The individual remains for Nietzsche always human, even in overcoming his humanity. But in this state of gnade, of grace that is beyond the law, he occupies less a place than a space where an apparent opposition of fate and freedom, necessity and creativity do not reconcile, but at least can meet in a moment of strategic possibility. Gnade meaning mercy, grace, pardon, but particularly in the sense of unaccountable forgiveness, a pardoning that is unaccountable in not calling to account the transgressor unable to pay the debt of his sins, but also a pardoning that is in view of only weaker eyes, unaccountable, that is strange, inexplicable. But for Nietzsche, the eyes of justice that can exist beyond the law are not blind, as he most beautifully expressed in Zarathustra, the bite of the adder. Nobler is it to own oneself in the wrong than to establish one's right, especially if one be in the right. Only one must be rich enough to do so. I do not like your cold justice. Out of the eye of your judges, there always glances the executioner and his cold steel. Tell me, where find we justice, which is love with seeing eyes? Devise me then the love, which not only bears all punishment, but also all guilt. Devise me then the justice, which acquits everyone except the judge. The biblical figure of Abraham, whose promise was ceaselessly tested by an ineluctable amor fati, may be an exemplar of the sovereign individual, but perhaps even more for what lies beyond it, not only in profoundly private struggles, but even on the public stage, where he intervened in a war between monarchs, indeed finding himself siding with the kings of Sodom and Gomorrah. However, Abraham showed himself a sovereign above these tyrants by abiding by the covenant, the promise made, in rejecting the sin of Sodom, which was the baseless hatred that results from insisting precisely, exclusively upon one's own legal rights, often cruelly no less and often tragically no more. And yet also finding himself further siding with Sodom in arguing against divine sovereignty, rising above himself in rising up to stand security against the destruction of Sodom, and in the noblest theater of pardoning, to stand security for gnada, for unaccountable grace and mercy. Now, the tale of Abraham in the book of Genesis is no doubt a lange Geschichte, a long story, but we could still in short form frame it along the arc of his resisting, his overcoming sovereignty, testing and proving his Nietzschean Macht, his power, as he continually bested mightier opponents, his father, his king, his homeland, the kings of his new land, not yet or even ever really his, of course, and surprisingly only penultimately his God. We see Abraham opposing the sovereignty of his father. As per the Midrash, Terach was a seller of idols. He smashed his father's store, the idols for sale. Then opposing the sovereignty of his hometown, Ur, again, as per the Midrash, surviving being cast into a fiery furnace by Nimrod, the leader, or in a less dramatic tradition, surviving a fiery face-to-face argument with Nimrod. Then opposing the sovereignty of his entire homeland, of the Chaldees, setting on his long journey from Ur Kasdim to the Promised Land. Then opposing the sovereignty of the kings of Canaan, both his enemies as well as his ersatz allies, the kings of Sodom and Gomorrah. Then opposing God in challenging the decree against Sodom and Gomorrah. And finally opposing himself in the ultimate test of power and justice and pardoning, the binding of Isaac. The Lord said to Abram, "Go forth, lech lecha, from your native land, and from your father's house to the land I will show you." Lech, meaning the imperative go, but also related to the same root, alach, to alacha, Jewish law. Following the law, in other words, is the way to go. The external general imperative being internalized into specific individual action. And lecha, combining preposition and objective pronoun, to mean not only lecha, for yourself, indicating the self as beneficiary, but also to yourself, indicating the self as the destination. Abraham journeys both for his own good and simultaneously to find himself, to begin to process the tremendous work of becoming what he is. And God keeps the end of Abraham's sojourn obscure, to the land I will show you, fitting perfectly the Nietzschean concept that becoming is distinct from being, as he said in The Will to Power. Becoming must be explained without recourse to final intentions. Even the promise of Abraham being blessed himself and being a blessing to others in the uncertain future is fraught with present calamities in the here and now. Abraham's becoming a sovereign individual was a tremendous work indeed. Not for nothing is he said to have famously endured 10 trials. Now, before concluding by focusing on one of them, I must note what major event in Abraham's life is not included among his trials: Abraham's challenging God's decision to destroy Sodom and Gomorrah. And Abraham approached and said, "Will you even destroy the righteous with the wicked?" Abraham's approach here is expressed by a verb, vayigash, otherwise used in the sense of coming near to wage a war. But this is not a battle of arms, of course. It is a trial, just not Abraham's. In this grandest theater of pardoning, while God is the judge, Hadayan, Abraham's role is that of counsel for the defense, hasanegor, a Talmudic term that originally comes from the Greek sinuros. And according to one view, a single sanegor is worth 909 accusers. To argue then for the sake of others is not a matter of personal tribulation, but righteousness. Abraham certainly had no love lost for Sodom and Gomorrah. And as noted, one of his trials was that he was drawn into a war against 4 other Canaanite sovereigns, fighting on the side of these wicked cities. Yet in his defense of Sodom, Abraham also was said to approach God in a state of war. But even more profoundly, Abraham, in the midst of even that battle, appears to be defending God as well. "Far be it from you," he says, "to do such a thing as this, to put to death the righteous with the wicked, so that the righteous should be like the wicked. Far be it from you. Will the judge of the entire earth not perform justice?" And indeed then, with that last question, Abraham extends his defense to all humankind, seeing that you are the judge of the entire earth, shofet kol haaretz, if you will judge people based on the conduct of the majority, says Sforno, you would eventually be forced to destroy all mankind, seeing that most people everywhere are wicked. Now, one here easily thinks of Shakespeare in Hamlet. Use every man after his desert, and who shall escape whipping? Use them after your own honor and dignity. The less they deserve, the more merit is in your bounty. And in an impassioned manner, far more galling to our self-importance, but born of a love with seeing eyes, what Kazantzakis, that great devotee and disciple of Nietzsche, declared about man in Zorba. Is he good or is he bad? That's the only thing I ask nowadays. As I grow older, I feel I won't even go on asking that. Whether a man's good or bad, I'm sorry for him, for all of them. The sight of a man just rends my insides, even if I act as if I don't care a damn. There he is, the poor devil, I think. He also drinks and eats and makes love and is frightened, whoever he is. He has his God and his devil just the same, and he'll peg out and lie as stiff as a board beneath the ground and be food for worms, just the same, poor devil. We're all brothers, all worm meat. Nevertheless, even given that reality, the fate awaiting us all at any moment, or one might say happening to us at every moment, Abraham is still depicted as always keenly aware of boundaries and scrupulous in defining and insisting upon, especially property boundaries between himself and others. Thus, Abraham and his nephew Lot separated, and Lot chose to live in Sodom, where he found himself a captive of war, with Abraham choosing to come to his rescue and restoring his possessions. Sodom, by contrast, disrespected property systematically, giving away what was not theirs to give, not troubling themselves to know when their men were stealing or not, and giving so-called gifts that they surely would reclaim later. Thus, we see Abraham the victor absolutely refused to share in any of the spoils. And Abram said to the king of Sodom, I raise my hand to the Lord, the Most High God, who possesses heaven and earth, neither from a thread to a shoe strap, nor will I take from whatever is yours. In fighting for Sodom and later in defending Sodom, Abraham still maintained this boundary, still held firmly this line. And yet the sin of Sodom was a perversion of this. For one who says, what is mine and what is yours, this is the trait of Sodom. Ha'omer sheli sheli v'shalcha shalcha zo midah Sedom. The midah of Sodom, of Sodom, literally the measure of who the people of this city are, is that each man insisted on his legal rights to the last degree, inculcating in them an arrogant lack of generosity, such that even if it cost them nothing, no one would countenance a beneficial act for another. Now, as noted above, Abraham could not be bought off by the king of Sodom. He was, therefore, in Nietzschean terms, a freya mensch, a free man, which in turn is defined by an entirely different kind of midah. For the sovereign individual does possess a measure of value, a wertmaß, for those whom he honors, those whose trust is a mark of distinction, who give their word as something to be relied on, and a measure for those whom he despises, those, as Nietzsche put it, feeble windbags who promise without the right to do so, and the liar who breaks his word even at the moment he utters it. Against these lowest types, these men of ressentiment, even in the humble charity of defending them, of asking for them pardon, Abraham holds the line, but only so that he can lech lecha, for himself and to become himself, go beyond it and overcome his own sovereignty. For the midah, the measure of Abraham, is lefanim mishurat hadin, to go beyond the letter, rather the shura, the line of the law, or as Nietzsche put it, jenseits das Recht. Only then can an individual be more than merely right. Only then can a person be blessed and be a blessing. Thank you.
Michael, thank you very much. That was phenomenal, especially with linguistic analysis. I really appreciate that. And so we will now move to Shana Trapito, who is going to offer commentary on this. Shana, you've got 10 minutes from this point. So
yeah, that's going to be easy. No problem. Given the nature of these pretty amazing papers that we just heard, I'm sure that, like me, you are quite amazed by the scholarship, the questions, the future directions, I think, that are presented by our panelists. To borrow a phrase, I guess, or word from Professor Warren, the fullness of each paper here merits a lot more processing and reflection than I can do justice today in the couple of minutes that I have. So I think all I can really do is offer my responses, share my thoughts, and hope that they contribute to the objective of this conference, and which is, from what I've gathered, a richer and more purposeful and collective understanding of sovereignty, humanity, and the law. Or I guess, to borrow a phrase that Ambassador Eisenstadt used yesterday in his keynote address, to help us think about the best means to achieve belated justice. So as Professor Hibbets mentioned at the beginning, or at the outset of this panel, being included on a panel such as this is, of course, a tremendous privilege. It's an honor and also an occasion to read the work of these panelists. And as my professional background is more in early modern literature and culture, not law and politics, I hope that Professor Myler doesn't mind that I rely a little bit more heavily on her book, which I recently read, in framing my response to what she presented today. So as Professor Myler demonstrated in this very impressive new study, Theories of Pardoning, there's a very close connection between pardoning and sovereignty, which she began, which she kind of gave us a portrait of a bit here today. And that can be traced back to the late 16th century, where it was then solidified throughout contests over power between king and parliament, really throughout the 17th century in England. And what she does beautifully there is explore kind of dramatic manifestations of pardoning in the period. And if we trace that as she does, we see this shift where there's an alternative account, she says, quote, of law and mercy as operating to benefit the state, rather than serving the primary purpose of glorifying the sovereign. And she asks today for us to think about to what extent pardoning really is something that is, in fact, compatible with modern democracy. So Professor Miller's scholarship has prompted me to revisit perhaps another public biblical figure who also has a reputation for spectacle and showmanship, who captured the imagination of Tudor and Elizabethan monarchs, poets, artists, politicians, preachers, and playwrights, and that would be King David. His life was actually dramatized many times throughout the 16th century, and my particular favorite version, maybe the most poetic treatment, is George Peele's 1593 play, The Love of King David and Fair Bathsheba. While the life of David appealed to the public's proclivity for paradox at the time, and this is Professor Platt makes this argument, David was fascinating because he was shepherd and slayer, poet, potentate, lover, womanizer, usurper, anointed, and then sinner, saint. An American scholar and former director of the Folger Library, Folger Shakespeare Library, Lewis Wright, suggests that David received so much theatrical attention at the period because the nationalistic period of ancient Jewish history appealed so much to Elizabethan patriotism. But what's interesting is that in the 17th century, David's paradigm of kingship was more frequently considered. More publications about David are leading to monarchy in the 17th century than in the 16th century combined. I'm going to skip my list of recommendations, 17th century reading list, but feel free to contact me in the chat. What I'll do though is move a little bit to what I would imagine, I hope, Professor Myler would grant as another kind of theater of pardoning. So during David's reign, the Israelites experienced unprecedented military triumph, prosperity, but there was also excessive bloodshed, tragedy, and scandal. And in Solomon's public eulogy for his father, recorded in Kings and in Chronicles, which I think Professor Myler might see as a rather public stage theatrical account, Solomon presents David as God's servant who did everything well, everything that was asked of him. Although Solomon appears to be the first to offer a very redemptive reading of what would be a kind of controversial public life, he was by no means the last. And the generations of Jewish and Christian thinkers have wrestled with David's legacy for years. And perhaps the most astonishing scene of pardoning is the one that is staged on the pages of the Talmud. So a very superficial reading of the Hebrew Bible displays David's religious devotion, keen military acumen and leadership skills, but it makes no attempt to hide his faults or justify his transgressions. However, an interpretive impulse to pardon or excuse David's indiscretions and elevate his status emerges in rabbinic discourse. And I find it exemplified in the sage's assertion, quote, "Whoever says that David sinned is surely in error." But how can this be? David himself in the Psalms repeatedly calls out for God's forgiveness. So in a series of debates, the Talmudic sages build their case that any apparent sins performed by David are merely products of a very misguided hermeneutical approach. And then what they do is they rely on very strict legalistic interpretations. They argue almost one by one that technically David did not commit adultery with Bathsheba because that encounter happened while her husband Uriah was off at battle. And it was customary at the time that before a soldier would go to war, he would give his wife a bill of divorce in advance. In the event that he perhaps did not return or his body was not recoverable, that would leave her bound, or she would not be able to remarry. She'd be what is called a naguna, she would be tied. So he inherently granted her a divorce before leaving, therefore there was no adultery there. The Talmud also absolves David of any guilt for the death of Bathsheba's husband, which resulted from David sending him to the front lines, and claiming that actually Uriah warranted the death penalty for his rebelliousness against the royal authority. And the rabbis' collective response is just exonerate David from all of his mistakes, except one. And the sages concur that there is fault to be found in the way that David initiates the relationship with Bathsheba, though it has nothing to do with sexual desire. Reb Judah focuses on a verse from Psalms 26, where David says, quote, "Examine me, God, and prove me, try out the reins of my heart." And then Reb Judah contextualizes it as follows. He says that David called out to God saying, "Sovereign of the universe." Why is it that in prayer, we use the liturgical phrase, the God of Abraham, Isaac, and Jacob, and not the God of David? And God replies, well, they were tested, they were tried, as we heard about the trials of Abraham, and you, David, were not. So then David replies, "Try me." Paraphrasing, of course. But God answered, "I will test you. I will actually even give you a special privilege or an advantage, unlike I did for Abraham, Isaac, and Jacob. I will tell you the nature of your challenge." Spoiler alert, it will be adultery. And still, from this episode, we know that David still goes forward with the affair or with the incident. And Rabbah concludes, or at least counsels, that one should never intentionally bring himself to a test, since David, king of Israel, did so and he fell. So in this interpretation of David's actions, he's not motivated by any kind of licentious desire. He simply seeks the highest levels of spiritual satisfaction and intimacy with God. But as is the case with rabbis and maybe a few lawyers, this provision is met with numerous demands for clarification. Why did God consent to the test if he knew that David would fail? How did David fail when God expressly warned him against committing adultery? So these are things that we cannot unpack here, but Babylonian Talmud, enjoy. It's a great summer read. So another exegetical act of pardoning that we find in the tradition too claims that David was fully capable of resisting the physical temptation, but he intentionally yields. He actually accepts God's challenge and then forfeits the wager. Why? And here's where I see Professor Warren's conceptual model finding purchase in Talmudic discourse for me. Because even though David has intimate knowledge of God's designs, he also understands the importance of hierarchy. And in this case, the Israelites' sovereign being foremost, God's servant. In other words, the sovereign is supposed to be subservient to God rather than a worthy opponent or someone who overcame God. Thus, David fails for God's benefit so that the nation never doubts their true master. In Jewish exegetical tradition, David merits knowledge of heavenly enterprises, sure, but he is still subject to the judgments of human beings. And I'll return, I hope you don't mind, to Professor Warren's productive thinking with angels in a moment. But one more point perhaps worth probing here, I think in Professor Myler's work on this historical and political development of pardoning reflected on the stage are cases where compassion or empathy are actually what bring us to a kind of social repair on a broader scale, right? There's a movement from not just pardoning of an individual sovereign, but to something that brings about a kind of reconciliation at the state, and where we have some form of mercy rather than a strict application of the law that prevents the overturn of the state itself, she says. Now, no, I'm not going to bring up Shylock, though I happily direct you to Professor Richard Weisberg's extensive work on the Merchant of Venice. I do think, however, that David's exegetical literary and even 17th century political reception offers a very compelling test case for the dangers of mercy metered law. The skepticism that was addressed that pardoning is not perhaps compatible with democracy, or to use Professor Weisberg's term, the perils of flexibility, taken from his most recent book, In Praise of Intransigence. So after David learns of his daughter Tamar's rape by his son Ammon, a crime to which he was an unwitting party, scripture says that David in fact did grow angry, but then 2 years go by and he still does nothing. And this pattern emerges throughout 2 Samuel. Tamar's assault, Ammon's murder, Absalom's rebellion. Whether King David was exercising mercy and not seeking retribution for these transgressions, or he simply abstains from the pursuit of justice, the result is the same. As history has shown, no choice is still a choice. And in these cases, it leads to a national crisis and the loss of innocent lives. And verbal echoes and narrative parallels between the life of David and Hamlet, which was referred to today too, richly texture Shakespeare's tragedy. So my aim is not to disagree with the Talmud. I'd probably lose that debate about David, and those who believe he sinned are in error. But I do see perhaps that declaration really as a provocation. Sages asking us to dig deeper and question whether or what is the nature of transgression? What is the nature of sin itself? What's the difference between a transgression, an omission, an injustice? And of course, whether that standard of responsibility is higher for a sovereign versus a citizen. For the purposes of time, I'm going to skip over a little bit of the reading that Professor Weisberg offers in his book about Hamlet and the erroneousness in delay. And he urges us to think about that when everything within you knows what is right, that delaying more than necessary is in fact to err. But ultimately what we have here is that while David, we are told in scripture, walks before God in wholehearted devotion, he is certainly no angel. Of course, Professor Warren's concentrated and compelling illustration of the interlinked conceptual histories of early modern angels and diplomats and their exemplification of what he terms the plurimatic paradigm of inviolable fullness challenges us, I think, to rethink the dominant ontological status of human beings and what is the basis for human rights. He's moving us away from animals and creaturely needs, which perhaps recalls Lear's lament of the unaccommodated man, a poor, bare-forked animal, or the very image of Agamben's bear life, upward towards angels who, like diplomats, are afforded greater dignity, power, and rights. Warren draws our attention to the great chain of being, and he asks us again to raise our gaze, noting that the human had neighbors not on one, but 2 sides, positioned above animals and just below angels, a divine proximity and a theological legacy that has been mobilized to expand human rights, but perhaps it could do more for us. While the Judeo-Christian positioning of mankind is this predominant narrative in the West, though, I wonder how Professor Warren's argument and our conference's objective might be further supported by looking at the account of the creation of man in the Quran and turning to Islamic wisdom, in which Allah commands the angels to bow to Adam. And the Khalifa referred to in the text is understood by some Muslim exegetes as meaning that Adam, or mankind, is the deputy of the angels. He replaces and he succeeds them on earth, where he will act as they did before. As Professor Warren notes for Aquinas, largely representative of Judeo-Christian position, free will is part of man's dignity, but the angel's dignity surpasses that of men. Yet in Islamic thought, the angels are envious of Adam's superior knowledge. And here, human dignity is tied to intellectual striving. In the discussions of what is the content of Adam's knowledge, though, there are sources according to which knowledge was actually the knowledge of language and of craft, again, gesturing kind of back toward what Professor Warren introduced us to. And here, knowledge enables man to control the world and act within and upon it. I greatly appreciate that Professor Warren calls us to question how comfortable we ought to be with the surviving hierarchy in political theology, and how pluralistic rights and the rights paradigm of angels and diplomats makes human rights look less full by comparison in its heavy reliance on rank and hierarchy. So as such, perhaps the wisdom of Islamic exegetes and commentators might further support Professor Warren's argument that access to knowledge and education is essential to the protection and extension of human rights and dignity. Making space for the secular, or the sacred in the secular, which I wasn't expecting when I came into the panel today, but happily found here, is really very inherently linked to the cause of human flourishing. And Julia Lupton cautions us against identifying religion with tribalism. She says, when you do that, it fails to recognize the contributions that religious discourse, especially that of the three monotheisms, have made to the universalist programs, including citizenship. So it's this kind of interdisciplinary and inclusive scholarship modeled by our panelists here today that is really essential for us confronting our past failures and exercising remedies. For the purposes of time as well, I'm going to skip over wonderful comments by Hannah Arendt, again, another recommendation or recommended reading, and end with this notion that Professor Tanzakos leaves us with, which is that the sovereign individual ultimately bears the privilege of responsibility. And he posits that through Abraham, he's the exemplar of the sovereign individual. By using Nietzsche as this kind of intellectual fulcrum, it is Abraham abiding by the covenant, keeping his promises that allows him to rise above himself and seek accountable grace for others. So in this sense, I'm grateful to Professor Pantzakos is showing us with this kind of weighty imperative, lech lecha, to go. Abraham is charged with taking on the work of becoming, in which the individual's manner of living brings blessing to oneself and to others. In the Abrahamic model of human rights advocacy, if we want to call it, the individual must stop at nothing, not even the judgment of God himself, to achieve righteousness. And also what's very nice, of course, about the Abrahamic model of individual sovereignty is that Abraham wasn't a sovereign. There's no barrier to entry for this kind of conduct. He's not like Moses. He doesn't lead a nation. He has no throne. He's a person, a partner, a father, an educator, a neighbor. Moreover, he's a traveler. Arguably, he had no land, no status, no title. And in fact, none of that is necessary for us to do the things that I believe this conference is urging us toward, that we should see sovereignty, actually, the individual sovereignty, as service. And it is a practice available to all of us, professionals, educators, citizens, neighbors, caregivers, in our own project of natural human ascent. Thank you so much. And thank you to our panelists. Wow.
Sheena, that was both engaging and exquisite. Thank you very, very much. It was just a lovely job. So now we have some time to open things up for comments. We have one comment and a series of questions in the Q&A. I also see a couple in the chat. So I'm going to start with those and we'll see where we go from here. And I would encourage others to submit questions in the chat or in the Q&A as appropriate. So Christopher, let's start with you. This actually comes from Bernie here. She'd like you to talk a little bit more about dignity as a corollary of sovereignty. She says often the dignity of a sovereign state is referenced in constitutional law by defenders of state sovereign immunity and similar doctrines. Also, she continues, do you have thoughts about how jurisdiction is involved here? The comparison between angels and diplomats made me consider the role of sanctuary in religious spaces as well as in diplomatic spaces. Is this sanctuary something that could be applied in the human rights domain?
Great, thanks, Bernie. Fantastic questions, and I'm afraid I won't be able to do them justice. I need to think more about them for sure. But with regard to the dignity of the sovereign, I mean that's a sort of fascinating question, in part because of the way the term dignity changes over time. So, Paul Guyer could tell us as well as anyone what Kant does to the term dignity, where it becomes sort of a much more sort of metaphysical kind of concept. the way that I'm using dignity is this sort of tradition that Jeremy Waldron is sort of pulling out regarding sort of rank and status. And I have to say that one of the things that appeals to me about that sort of historically is, number one, it sort of speaks to the way that the term was used most frequently in the early modern period, as you well know. And secondly, it means that the dignity of the ambassador, for example, sort of conceptually, is not sort of like apart from or separate from sovereign dignity. It sort of flows from it. And so there's something that's kind of attractive to me about this model, in which it's not exactly competing dignities, but instead it's a kind of way of understanding rights within a paradigm of sovereigns who themselves do have dignity, meaning high status or rank in the sort of on the world stage, but for whom rights are sort of borrowed and flow from that high status of the sovereign. Now, obviously, then it becomes sort of comparative, the way in which one sovereign's dignity sort of relates to another sovereign's dignity, and sort of this sort of notion of diplomacy. And that's where you get these sort of fascinating and totally bizarre fights over precedence about who gets to sit next to whom. But that is, for me, a kind of, again, just, I want to think more about it, but the way in which we're not sort of sidestepping sovereignty or competing against sovereignty in this model, but we're sort of operating within it. And that seems to me something worth thinking about.
Okay, thank you, Christopher. Appreciate that. Bernie, did you want to come back on that at all?
No, just to say that I think I like this idea of dignity kind of flowing from sovereignty. I think some people, like I think Judith Resnick and Julie Sook have tried to put together the ideas of individual dignity and sovereign dignity, but this idea of a sort of flow where it's not one or the other seems really promising to me.
Thanks.
Okay, so we have a couple of questions actually from Richard Weisberg in the chat. And Richard, I think I see you on the screen here. I don't know whether you want to directly ask your questions in person. If you do, it would be great. If you don't, I can articulate them for you. And I think you're muted.
He disappeared too. Oh no, there he is.
Okay, now maybe. Still muted. I don't know why. So I don't know whether we can't hear you, Richard. I don't know why that is happening at the moment.
Yep. Can you click the arrow beside mute and double check which microphone you're using there?
This is to me or to Richard?
For Professor Weisberg.
That's what I thought.
It's the little arrow beside mute. Just make sure that the right microphone's chosen.
I'm seeing an odd icon next to his microphone, Kim, which is unusual for me. So maybe while we're working on that, oh, Richard, can you hear me? Can you speak? No, still no sound.
I could answer his first question.
That's great. So why don't we try to do that? Thank you very much.
Great. Yeah. So I think I just want to also begin by saying thanks so much, Shana, for those great comments. And I have a lot to think about, but I also want to sort of fold in some answers to you in my answer to Richard. So kind of beginning with Shana, I think this idea of a kind of hermeneutic version of pardoning is really fascinating, and the way that the Talmud kind of performs its own pardon of David is really interesting. And also, I mean, I think the figure of David in the 17th century is also fascinating, but we can put that to one side. And to me, it resonated a bit with this debate about whether pardoning or mercy always includes forgetting. or what is forgotten or retained when something is pardoned. And something that I didn't talk about today, but I discuss in my book, is this idea of an act of oblivion, where there is a mandatory forgetting of certain kinds of events, generally in the context of recovering from civil war or revolution, and that the acts of oblivion, as passed in late 17th century England, actually did tell people that they weren't allowed to at least judicially recognize certain acts as having occurred, right? So that there were, in fact, penalties applied, or at least nominally, according to the legislation, if someone raised a fact that they weren't supposed to raise. So that's, in a way, the most extreme version of this kind of hermeneutics of, of forgetting, or of some hermeneutics of mercy, where you're not really allowed to even interpret something a particular way, or raise it as a fact that occurred. So I think that that's a really interesting point about the Talmud, and one that kind of continues, I think, in the tradition of pardoning further towards today. Then, in terms of, I think there's some overlap between what you were then saying and Richard Weisberg's question about merchant, and so I think that the way that I see the role of Portia, and then the subsequent, so Shylock is ultimately pardoned, in fact, except that it's a punishing pardon, right? So he has to convert in order to receive his life back, and then also give away his money. So there's a way in which I think that becomes emblematic for me of the punishing pardon, and there is this real tradition of the pardon as a form of not of true mercy, but rather of assertion of power over the person pardoned. And I think there's a way in which that's all inherent in all of the forms of sovereign mercy. And so that, to the extent that there is a reaffirmation of sovereignty through the exercise of mercy, often that results in this idea of the this kind of punishing pardon. And Cynthia Harrop, I think, has written quite well about this notion. And there were even examples of people who refused pardons, not just because they thought that that would imply guilt, but just because the consequences of being pardoned were worse than for them, the consequences of accepting punishment. So I think that Shakespeare really stages that issue there. At the same time, I'm intrigued by the fact that, in general, Shakespeare seems to positively associate pardoning with sovereignty, and with the idea of sovereignty more generally. And recently I was rereading Julius Caesar and trying to defend Brutus in an argument, a moot argument about whether he was a murderer or committed treason. But in doing that, I was really interested that right before Caesar is killed, he again refuses to pardon someone, or they bring up the possibility of him pardoning someone, he refuses, which then, having read a lot of the history around it, seemed really odd, because in fact, one of the critiques of Caesar was that he exercised too much mercy in a lot of contexts. But it seemed like it was not really possible for Shakespeare to kind of critique him for exercising too much mercy, because that would somehow be incompatible with his conception of a sovereign as appropriately exercising mercy. And so he kind of converts it into a failure to exercise mercy rather than an excess of mercy. So I think that that's an interesting sort of test case of like how Shakespeare is conceptualizing the relationship between mercy and sovereignty in a number of the plays. But thanks so much for the commentary, Shana, and for the question, Richard.
Thank you, Bernie. Actually, Richard has another one for Michael. I'm going to pass that along directly at this point. So Michael, is Nietzsche's thought, or in Nietzsche's thought, can one self-overcome by pardoning before achieving self-sovereignty?
That's definitely an important and provocative question. In short, no. Primarily because according to Nietzsche, sort of the base natural instinct, the unimproved, the unascended instinct of the human animal, and he doesn't shy away from calling us what we are, it lies in forgetting, and the process begins from that lower base of us to the ascent to self-sovereignty is in the effort to remember, is the memory. And of course, remembering entails suffering. And we would rather more easily want to forget. And this is certainly highly appropriate since the conference comes about during Yom HaShoah. The instinct, for so many would just be, it's in the past, it's happened, we acknowledge it, but paper it over, forget it. What was done is done. It's time to move on. And the harshness of the memory is what earns one that right to make promises. Is only when you earn that right, when you go through that process, which is, as Nietzsche said, a tremendous work. And it's not a work that it happens instantly. It happens basically over a lifetime. But only by the work of becoming responsible, of understanding that your word given has consequences if it's broken, only then will you come to the position that you can become of that noble nature. And I think Walter Kaufmann put it best when he said, sort of summing it up, from Nietzsche's perspective, nobility is having claws but not using them. And it's only when you've attained that level and when you understand that those individuals that he would label as liars or feeble windbags, they deserve punishment, yes, but not in a way that cheapens us as the judge and the jury, that it sort of infects us and makes us sick with their own sin. But as Nietzsche would put it, a rod for the liar or a swift kick for the feeble windbag. But indeed, there's not no punishment, but it's not one that sickens us with their illness. Without achieving the tremendous work of our own sovereignty, though, pardoning is forgetting, and forgetting is our basest instinct.
Thank you, Michael. Speaking as the feeble windbag here, maybe I can pass over to Richard, who I think may have his audio clear at this point in case he wants to respond. Richard. No, still. It was clear there for a second, and then something happened. So I guess we're gonna be cursed, cut. All right. So, but thank you. I'm sorry, Richard, that we can't connect you. Any other quick comments from anybody? We have like a minute left. If anybody wants to plunge in with anything quickly. No. Okay. That's fine. Thank you all. I mean, this was really a fascinating panel on any number of levels. And I was scribbling things as I went here. We don't have time to really pursue any of those particular thoughts, but I'm so glad that you all had a chance to connect with each other. I'm so glad that we got a chance as a group to sort of grapple with the elephant that is sovereignty here from so many different perspectives. And again, thank you to our panelists. Thank you to Bernie, to Christopher, to Michael, and a special thank you to Shana for amazingly pulling a lot of this together in her comment, which I think was a really difficult thing to do in this kind of environment. So with that said, and there is Richard raising a glass. So I think that's a wonderful gesture and a great thing to do at the end of a wonderful panel. And I think Shane is going to match it, and so will others in all of this. And of course, I'm glassless here, but please allow me to do this in spirit. So with that all said, I think that is it for us at this particular point. We did have a hard stop at 5:15. We're about 1 minute or so before schedule. So I will pass it back to Professor Brand for closing remarks and any further instructions. So Ron, over to you.
Thank you, Bernie, and thank you to all the panelists and Shana for the commentary. It was a wonderful panel. It was a great dessert to the dinner that was the conference. And so really, really appreciate that. Richard, I don't know if we're going to be able to get you to be able to speak here. One more shot at it. Okay, that communicates more. So on behalf, I was going to say thank you to everyone on behalf of the Center for International Legal Education, but I will speak for Richard too and say thank you on behalf of the Law and Humanities Institute. All of the participants over the course of 2 days, Ambassador Eisenstadt for a wonderful keynote address. I think it's been a rich set of talks and discussions that has certainly enriched my thought and understanding on these issues. There's obviously a whole lot more that can be done. That word sovereignty is, as Bernie Hibbett said, the elephant that we can all approach in different ways and see very different things. That has come out, but I think it has demonstrated as well an ability to discuss a topic across disciplines that I think is so important in the academy and bring in practitioners as well in that process. And so I want to say again, thank you so much to all of our speakers, all of our panelists, and thank you to those who joined us and listened in. I wish we could all be together and now be going to a celebratory dinner where we could have further informal discussion of the type that often has so much even greater impact and makes the formal talks so much more valuable. We can't do that, but in the time of COVID, I have the feeling that we've done quite well. So thank you all for being a part of this. We very much appreciate it. Have a wonderful weekend. I hope the weather is as nice everywhere else as it is in Pittsburgh for that purpose. But, so again, thank you and goodbye.